Check 1, 2. Check 1, 2.
Got a button there.
right, let's go on the record. Good morning, everyone. Today's September 29th. 29th? Today's September 30th, 2025. The Commission has set this time for the evidentiary hearing in case number EO 2025-0154 in the matter of the application of Evergy Metro, Inc., doing business as Evergy Missouri Metro, and Evergy Missouri West, doing business as Missouri West, for approval of new and modified tariffs for service to large load customers. My name is Carolyn Walker, and I'm the regulatory law judge that will be presiding over this hearing. To my left is Commissioners present, the Chair, Kayla Hahn, and Commissioner Kolkmeyer. Commissioner Coleman will be joining us, and Commissioner Mitchell is online. I'd like to start with, we have a few pending motions. We have a few preliminary matters. One is that Liberty has filed a motion to be excused from the hearing. Is there anyone from Liberty here? Okay. I sent an email yesterday, and that motion will be granted with the same conditions as for Sierra Club and the data center. They've given up the right to cross-examine, and they will obtain any evidence that's admitted from EFIS. They would like the opportunity to file a brief. All right, let's do entries of appearance. Okay, we'll start with Evergy.
Thank you, Your Honor. Cole Bailey, we have Jackie Whipple, Jim Fisher, and Chandler Hyde for Evergy.
Okay, commission staff.
Andrea Hansen. We also have Travis Pringle and Alexandra Klaus representing staff as well.
The Office of Public Counsel.
John Kleiser.
Okay. Union Electric Company, doing business as Ameren, Missouri.
Thank you, Your Honor. Jim Lowry, Wendy Tatro, and Paula Johnson on behalf of Ameren, Missouri.
Renew, Missouri.
I'm sorry, I did not hear that at all.
We're going to have a reporter online, so everyone needs to speak in a mic. Please come up here and talk into the mic because we do have a full house.
I apologize. Nicole Mers on behalf of Renew Missouri.
Nucor Steel, Sedalia LLC.
If you'll allow me, Your Honor, I'll do an entry of appearance for Mark Ellinger of Ellinger Bell on behalf of Nucor Steel Sedalia. He's stuck in a hearing in Cole County, but will join us shortly.
And you are?
I am Stephanie Bell. I'll do my entry of appearance for Velvet Tech Services.
Okay, thank you.
Thank you.
Google LLC.
Good morning, Andrew Schulte, Frank Caro, and Jared Jevons with the Pulcinelli Law Firm on behalf of Google.
Data Center Coalition.
Good morning, Your Honor. Nikhil Vijayakar and Elisa Greenwald from the law firm of Keys & Fox, LLP, on behalf of the Data Center Coalition.
The Sierra Club.
Good morning, Your Honor. Sarah Rubenstein on behalf of Sierra Club.
Please silence any cell phones or other electronic devices that you have. Your exhibits should be pre-marked and continue sequentially. Does anybody need time to mark them? Good. As far as the order of witnesses, we're going to follow the order filed by the parties in their joint list of issues and witnesses. Are there any pending motions that we have not discussed other than the late filed testimony motion from Evergy, which we will grant?
Oh, well, actually, Judge, staff has an objection to that motion and was planning on filing a written objection later this morning. As an alternative to our request that that motion be rejected, we'll be attaching a staff memorandum in opposition to the non-unanimous stipulation agreement that our alternative relief would be to enter that in the record, but it has not been filed yet in EFS, but will be filed momentarily.
Okay. I'm going to admit the late filed testimony from Evergy and give you an opportunity when you testify to file what you would like to file in opposition and to that motion.
Your Honor, the OPC would also like to lodge an objection to the inclusion of the admitted. I know that you've already ruled on it, but for the sake of the record, I would like to lodge our objection and request permission to late file if we see fit as well.
I'll note your objection and your request is granted.
Your Honor, this is Cole Bailey with Evergy. Can we have a deadline for the filing?
I'll let the parties set their deadline later in the case.
Okay.
Please remind me. Are there any other preliminary matters we need to address? Okay, let's start with opening statements. Evergy? Are you offering this to be admitted as evidence?
No, it's just for ease of review, and I've distributed copies to attorneys for the parties as well.
Do you have extra copies for the commissioners so they may review what? Oh, they are. Okay. Thank you. Thank you. All right, you may begin.
I will have a PowerPoint when Brian has it up. I'll be
Okay.
able to do that. Thank you so much.
Perfect.
I'll just introduce myself meantime. Good morning. As we entered our appearance, I am Jackie Whipple with the law firm of Denton's U.S. LLP. I'm here with my colleague Chandler Hyatt. Cole Bailey is with Evergy today, and Jim Fisher of Fisher & Doherty PC is here as well. We represent, of course, the applicants, Evergy Missouri West and Evergy Missouri Metro. We may be referring to them as Evergy or the company, or EMM in the case of Evergy Missouri Metro, or EMW in the case of Evergy Missouri West. Your Honor, up to you. I certainly don't want to cause delay. I have passed out hard copies of my opening statement, so that parties, counsel, and the commission can review it as I speak, and I can just kind of give some verbal cues, or we can wait for the restart on Brian's computer. How would you like to proceed, Your Honor?
What? I think we're going to wait till Brian reboots his computer so that everybody who is here
Can see it.
has the benefit of looking at what you have given the commission.
Understood. Okay.
Your Honor, while we're waiting, can you make one announcement to everyone to make sure if they do make an objection or speak, if they would please say their name just so that I don't get confused on who's talking.
Sure.
Thank you so much.
This is Jackie Whipple for Evergy. I'll be giving the opening statement.
Can you spell your name for the court reporter, please?
Jacqueline, Jacqueline. I also go by Jackie. Last name is Whipple, Whipple, and my information is in the record.
And if it helps the court reporter, the objection voiced earlier on behalf of staff was Travis Pringle.
Thank you very much. I appreciate that.
No problem.
May it please the Commission. Good morning. As explained in Evergy's application and pre-filed testimony, this case involves Evergy's request for the Commission's approval of its Large Load Power Service, also referred to as LLPS, rate plan, including Schedule LLPS and its associated riders, along with conforming changes to existing tariffs and related updates to Metros and West's general rules and regulations. In addition, and as I will later describe further, Evergy requests today the Commission's approval of the September 25, 2025 non-unanimous stipulation and agreement, which we may refer to as the stipulation or the stipulation and agreement, to which the following parties are signatories: Evergy, Ameren, Google, Data Center Coalition, or DCC, Renew Missouri, Velvet Tech Services, Nucor Steel Sedalia, the Sierra Club. Likewise, Liberty has indicated that it does not object to the stipulation, although it is not participating in today's hearing. Today, we believe the Commission is faced with a choice. Does the Commission choose to encourage economic development and load growth in a responsible and fair way in the state of Missouri, or will the Commission cede that opportunity to surrounding states, including Kansas? As this Commission is well aware, the national electrical grid is experiencing the most dramatic load growth in modern history, driven by AI, data center development, industrial electrification, onshoring, and decarbonization objectives. These developments are impacting Southwest Power Pool, or SPP, which has warned that demand for electricity is outpacing the supply from its generation fleet. Even more specific to Missouri, Evergy's energy pipeline includes over 6 gigawatts of potential new load. Several customers have acquired land or land rights within the state, signed letters of agreement, or made financial commitments to Evergy, including that a large meta facility is already secured within the state of Missouri. The earliest time frame that LLPS customers could start to take service from Evergy is first quarter of 2026. While this scale of growth is unprecedented, so too are the economic benefits that come with it, including thousands of future construction and permanent jobs, incremental tax base, and longer-term technology infrastructure improvements. The Commission and Missouri utilities are well positioned to facilitate the economic development driven by these large loads because of Missouri's newly enacted Senate Bill 4, codified at Section 393.130.7. Evergy believes, and all of the non-state agency parties to the stipulation agree, that adopting the non-unanimous stipulation and agreement is the path forward. Section 393.130.7 enables electrical corporations to, quote, develop and submit to the Commission schedules to include in the electrical corporation service tariff applicable to customers who are reasonably projected to have above an annual peak demand of 100 megawatts or more. The schedules should reasonably ensure such customers' rates will reflect the customer's representative share of the costs incurred to serve the customers and prevent other customer classes' rates from reflecting any unjust or unreasonable costs arising from service to such customers, end quote. In response to the influx of large load customer interest in Missouri and in compliance with Senate Bill 4, Evergy has developed the LLPS rate plan, which is now modified by the stipulation. As described in Evergy's application and the pre-filed testimony of Evergy's witnesses, the LLPS rate plan is founded on the commission-approved structure for large commercial and industrial service, but is enhanced to accommodate today's very large customers who are distinct in scale and sophistication. As I noted, the stipulation was filed as a modification to Evergy's original tariff proposal. Only staff and OPC are non-signatories to the stipulation. I will highlight key aspects of the company's modified tariff proposal, but all of the ways in which the stipulation modifies Evergy's original application are detailed by company witness Gunn in his supporting testimony filed in support of the stipulation on September 29 and which was granted into the record this morning. Overall, the modified LLPS rate plan can be implemented practically. It maintains the company's and existing customers' ability to benefit from these economic development opportunities in Missouri, and it effectively balances costs and protections among all customers. Accordingly, Schedule LLPS applies to new Missouri customers with monthly peak demands reasonably expected to be at or above 75 megawatts, and for existing customers who add 75 megawatts or more of incremental load. The LLPS structure is aligned with the company's LPS rate architecture while incorporating additional protective and customer choice features, including but not limited to a service agreement with a minimum term that includes up to 5 years of an optional transitional load ramp period, plus 12 years for LLPS customers exceeding 75 megawatts. It includes minimum bill and minimum demand commitments with defined capacity reduction and termination fee frameworks to protect non-participants from stranded cost risks. It includes creditworthiness and collateral requirements. It has complementary riders that enable demand response, capacity management, and clean energy procurement aligned to customer goals. The path to power queue reforms for loads customers over 25 megawatts with initial evaluations, refundable deposits in $200,000 increments, a cluster study approach, and defined priority for community interest projects. There are also clear rules for cost responsibility of transmission costs that require them to be paid by the requesting large load customer, excluding SPP network upgrades. The general rules and regulations are updated to memorialize these regulations and obligations. There is also a mechanism for recovering additional costs to serve large loads, the cost stabilization rider, and increased demand charge. Initial pricing is set in Exhibit A of the stipulation. The LLPS rate plan adequately responds, therefore, to the unique needs of large load customers while protecting existing customers and ensuring large load customers pay their representative shares of incremental costs. The modified LLPS rate plan also positions Evergy in the middle of the fairway with respect to large load plans implemented nationwide, helping ensure that Missouri is able to compete effectively for this new load. To further explain the company's application and for purposes of your later questions, the company's witnesses are Kevin Gunn, Vice President of Regulatory and Government Affairs, who discusses national energy trends, the LLPS rate plan's statutory and policy alignment, and the stipulation. Jason Clint, who is Senior Director of External Affairs, he will be adopting the testimony of Evergy witness Jeff Martin, who's retiring. Jason Clint, on behalf of the company, discusses the company's path to power approach. Derek Brown is the Director of Large Customer Strategy and Planning, who serves also as a key Evergy representative to the SPP. He will discuss the company's load-serving capabilities and commitments, as well as comments on load-related developments within SPP. Bradley Lutz is the Director of Regulatory Affairs. He discusses the intricacies of the LLPS rate plan and its associated riders as modified by the stipulation. There are several issues, notwithstanding the stipulation, that are still present in this proceeding for the Commission's resolution. Although Section 393.130.7 permits only utilities to submit large load tariffs for the Commission's approval, staff in its report and recommendation filed its own proposed tariff regarding large load customers. Rather than engage with Evergy's tariff, which was developed after years of experience with actual large load customers and months of nationwide industry benchmarking, unlike staff's proposal in this case, staff invented a wholly competing proposal. In effect, and contrary to the governing statute, staff has positioned this case to force the Commission to choose between staff's and the company's diametrically opposed tariffs. As a result, the following issues on the parties' jointly filed list of issues still remain for Commission resolution. They are listed on the PowerPoint, and they are A, B, C, D, E sub A, F, G, H, I, J, K, M, N, O, P, Q, R, S, and T. Evergy witnesses and several other parties in this case have detailed their disagreements with staff in their pre-filed testimony, and Evergy's witnesses will be available for the Commission's specific questions during this hearing. So for purposes of this opening statement, I will address staff's proposal more categorically. As Mr. Gunn and Mr. Lutz testify, staff's tariff proposal is contrary to Section 393.130.7, Missouri's economic development policies, and regulatory precedent. Staff has not identified any state or industry trend to support its proposal, which is considerably more complex than any other large load design examined by Evergy in its months of tariff research. Likewise, staff developed its tariffs with little to no input from real-world customers. Frankly, staff's proposal is an outlier that deviates from anything Evergy has ever reviewed across the country. As a necessary result, staff's proposal has not been tested or adopted in the United States. As the customers in this proceeding even explain, staff's proposal cannot be practically implemented, does not align with conventional rate-making practices, and instead unreasonably allocates incremental costs to customers in violation of the governing statute. Staff expresses concern, for example, that Evergy's tariff will maximize shareholder benefits from, quote, positive regulatory lag, end quote, associated with LLPS customers. But this is misguided. As Mr. Gunn explains, no statute in Missouri precludes positive regulatory lag, as it is a normal aspect of utility rate making and cannot be invoked solely to the detriment of the utility, of course. Moreover, any new revenue collected via this tariff will mitigate associated cost impacts and provide rate stabilization for existing customers. If the company earns revenue above this offset, the Commission's traditional rate-making processes will still apply, requiring Evergy to reimburse customers in the event it exceeds its authorized rate of return. Staff proposes that Evergy incorporate Fuel Adjustment Clause, or FAC, LLPS adjustments to track the, quote, excess, end quote, revenue from LLPS customers as a regulatory liability. However, such approach would be a significant departure from established regulatory policy and Commission precedent, and would unduly increase regulatory burden, as Mr. Lutz and Mr. Gunn both explain in their testimony. Evergy also disagrees with staff that all material terms should be defined in the tariffs and subject to the Commission's approval. Doing so would unduly restrict Evergy's ability to exercise reasonable discretion while servicing LLPS customers, since those customers' needs are highly individualized and not amenable to a one-size-fits-all approach. As Mr. Lutz, Mr. Martin, Jason Clint, and Mr. Gunn testify, Section 393.130.7 permits the company this discretion in its tariffs. Staff recommends denying all of Evergy's optional riders despite their varied benefits to customers. Instead, staff's proposal includes additional charges and rate components at price levels dependent on volatile variables that are beyond the LLPS customer's control, which would unnecessarily increase cost uncertainty for the customer. Staff also recommends registering LLPS customers as separate SPP commercial pricing nodes, a step that, to Evergy's knowledge, is unprecedented within the SPP process. As Mr. Brown explains, this approach would create highly volatile and unpredictable rates, and would subject LLPS customers to costs they did not solely cause. Staff risks isolating Missouri from a once-in-a-generation growth opportunity, and staff is inconsistent with how other jurisdictions have accommodated large loads. Staff even recommends arbitrarily restricting the quantity of load to be provided by LLPS customers, foregoing the associated benefits to existing customers and to the state, and while being unduly discriminatory to other customers. Overall, staff's tariffs would drastically chill economic development in the state of Missouri from LLPS customers, as Evergy's and other parties' witnesses have testified. Therefore, the Commission should approve the stipulation, reject staff's recommendation in whole, and approve the company's modified tariff proposal in this case. As to OPC's arguments, OPC's pre-filed testimony generally offers blanket support for staff's recommendations without any substantive analysis. Different from staff, however, OPC witness Mark's testimony asserts that certain studies should be required for customers to take service under the LLPS tariff. However, as discussed by Evergy witness Kevin Gunn, requiring such studies is not part of industry standard in SPP or across the United States. These studies are focused on issues that are behind the meter and do not provide value for advanced manufacturing or other non-data center LLPS customers. Witness Mark also suggests service under the LLPS schedule be subject to mandatory emergency curtailments, but as explained by Mr. Lutz, EMW and EMM already have an emergency energy conservation plan memorialized in their general rules and regulations. These plans define an emergency and highlight the major steps that will be taken during an emergency, called the SPP Reliability Coordinator. OPC witness Mantle testifies regarding Evergy's FAC, which would not need to be addressed by the Commission if the Commission approves Evergy's tariffs proposal in this proceeding rather than staff's. The company's proposal does not alter the existing FAC structure except for some immaterial changes regarding certain renewable programs, as Mr. Lutz explains further. Importantly, existing customers will actually receive an advantage in the form of mitigated cost impacts and rate stabilization when large load customers' revenues flow through the existing FAC as it currently operates. In conclusion, Evergy's modified LLPS rate plan satisfies Section 393.130.7 by reasonably ensuring large load customers pay their representative share of costs and by preventing unjust or unreasonable costs from being shifted to other customers. It meets the needs of Missouri's grid and economy, and it does so with the protections, transparency, and flexibility that this Commission expects. Staff's and OPC's alternative proposal is radical, unlawful, and impractical in stark contrast. it would needlessly and severely impair Missouri's competitiveness at precisely the moment when prudent policy can deliver durable public benefits in this state. Evergy respectfully requests approval of the stipulation and of its application as modified by the stipulation in full. Thank you.
Good morning. And for the court reporter, my name is Andrea Hansen, and I am giving the opening statement for staff. Absolutely. It's ANDREA HANSEN. Good morning, and may it please the commission. My name is Andrea Hansen, and I am one of the attorneys representing commission staff on this case. My colleagues, Travis Pringle and Alexander Klaus, are also representing commission staff in this case. Since it was established in 1913, the Missouri Public Service Commission has had many decisions that have had far-reaching consequences. The case before the commission today is no exception. The loads that will be served under the tariffs authorized in this case will be far larger than any load of a customer currently served in any investor-owned utility in the state of Missouri today. Both commission staff and the OPC recognize the potential impacts of this decision. As such, both parties are aligned pertaining to the potential impacts Evergy's application will have on existing ratepayers. Evergy filed this application under Section 393.140, subsection 11 of the revised statutes of Missouri and the Commission's general rule regarding applications. Section 393.140 describes the general powers of the Commission in respect to gas, water, electricity, and sewer services. More specifically, subsection 11 describes in part that the Commission has the power to require every electrical corporation to file with the Commission and to print and to keep open to public inspection schedules showing all rates and charges made, established or enforced, or to be charged or enforced, and all forms of contract or agreement and all rules and regulations relating to rates, charges, or service used or to be used, and all general privileges and facilities granted or allowed by such electrical corporation. Importantly, that subsection ends by stating the Commission shall also have power to establish such rules and regulations to carry into effect the provisions of this subdivision as it may deem necessary, and to modify and amend such rules or regulations from time to time. Why is this so important? It is so important because the Commission is in the driver's seat when it comes to determining what is reasonable in this case, and the Commission has options in making this determination. For instance, we are aware that EMM, EMW, Ameren Missouri, Google, Velvet Tech, Nucor, the Data Center Coalition, Sierra Club, Renew Missouri, have entered into and filed a non-unanimous stipulation and agreement. Staff has noted in its filed objection to that stipulation. As staff has noted in its filed objection to that stipulation, this stipulation will result in increases to the bills of existing customers through the FAC and will not comply with Missouri law, and staff also intends to further brief on this issue. Staff recommends that the Commission reject the stipulation, to which neither staff nor the OPC are a party, and if the Commission does order a tariff to be filed on the basic terms of the stipulation, staff begs the Commission to require tracking of revenues and expenses to a regulatory deferral account to be addressed in a future general rate case. There are some additional options. These are: the Commission can reject Evergy's application, the Commission can approve Evergy's application, the Commission can approve Evergy's application subject to conditions, which here staff would urge the Commission to order a tariff filing consistent with the tariff set out in Schedule 1 to Sarah Lange's rebuttal testimony. Because no tariffs have been filed in this case, no deadline clock has started, and the Commission needn't be rushed in its decision. The Commission can hear all of the evidence in this case and all of the evidence in ET 2025-0184, Ameren, Missouri's large load tariff filing, and make its decision after hearing both of those cases. While staff does not support end-use rates, the Commission could determine that Evergy's proposed tariff applies only to data centers, as supported by OPC witness Jeff Marks' rebuttal testimony, or the Commission could order a working docket to facilitate Commission input into the development of a final tariff. There are three broad questions that staff encourages the Commission to keep in mind as you listen today to testimony and as you make your decision in the coming weeks. Question number 1, how do we ensure that in designing rates that work for data centers, the Commission does not order rates that create barriers of entry for other large customers? This case is about creating a tariff to serve a diverse pool of potential customers, which may include data centers, but it could also include factories, metallurgy, agriculture, and technologies that may not even exist today. That potential diversity necessitates a rate structure that allows a reasonable rate to be billed to each customer. Such a rate structure will not be a flat energy charge and a static minimum demand as proposed by the signatory parties to the stipulation mentioned above. Evergy witnesses have painted staff's recommended rate structure as complicated, but staff's recommended rate structures are far simpler than the annual billing demand and hours use rate elements that Evergy currently applies to customers far smaller and far less sophisticated than potential large load power service customers or LLPS customers. Staff's recommendation leans on transparency and flexibility for a wide variety of industry types, as opposed to the stipulation approach, which enables Evergy to capture massive amounts of revenue for shareholders between rate cases, and is likely to lead to far more contentious rate cases in the future, which, due to the confidential customer information, could also involve significant amounts of time, days to weeks, of in-camera hearings. Question number 2, what are the right rates under Senate Bill 4, codified in part as Section 393.130.7 of the Missouri Revised Statute Section 393.140, the statute under which Evergy filed this application? Staff's approach facilitates right-sizing the bills of potentially diverse customers, and staff's approach is more transparent than Evergy's proposed rate structure. Staff's proposed rate elements are rooted in cost causation. The components used by staff in this approach to rate structure, in the instant case, are the elements that are reviewed and allocated in class cost of service studies. The usage of these components allow customer bills across diverse industries that may be served through all the rate schedule to better reflect the cost of serving each customer. Staff proposes demand deviation charges and imbalance charges that work better rather than a static minimum demand charge. This approach operates in a way that benefits customers who do not have a 100% load factor without overcharging customers with a flat load. This would better serve potentially diverse customers that are not data centers. A significant concern with the Evergy approach is the lack of transparency, especially as Evergy's approach contemplates customer agreements, which would vary the calculations of bills for LLPS customers from the tariff calculation and potentially include a series of offsetting agreements and pricing terms. In fact, Evergy's position statement in this case states that a form customer agreement should not be included in the commission-approved LLPS rate tariffs resulting from this case. Evergy's rationale in taking this position is because, 1, Evergy believes a form customer agreement would unduly restrict Evergy's discretion in servicing large customers. 2, that the elements included on a given customer's bill will inherently vary from customer to customer. And 3, that the pricing within these elements is also unique from customer to customer. Thus, in Evergy's opinion, it is not reasonable to subject the LLPS customer to a form service agreement. This is not consistent with a filed rate doctrine, and the Commission should ask, 1, does the large load tariff in this stipulation really set out the rates and terms for those customers? Or 2, will customers effectively be served under special rate contracts without the prior approval and oversight that the Commission has historically exercised over special contracts? The stipulation's deference to customer service agreements does not provide the level of transparency needed for the Commission to effectively determine whether Evergy is complying with statutes and rules. And this is just one small aspect of Evergy's proposal. Evergy's position on this issue is in contrast to Ameren, Missouri's large load customer proposal, which includes a form agreement or ESA. One should note as well that Ameren, Missouri has been forthcoming in providing examples of additional or supplemental agreements upon request of staff. The lack of transparency afforded by Evergy's proposed customer agreements is partly why staff recommended an alternative, under which any customer considering taking service in the EMM or EMW territories can simply look at the published tariff in conjunction with their own usage projections and readily estimate what their bill would be, without resorting to customer-specific terms and pricing. The third and last question staff requests that the Commission keep in mind today, during today's hearing, and ultimately in making its decision, is, are other customers impermissibly harmed? Large load customer revenues cannot improve affordability if the revenues from the bills they pay are retained by Evergy. Senate Bill 4, enacted this August, and for this case codified under 393.130.7, requires each utility to have tariff provisions applicable to customers who are reasonably projected to have above an annual peak demand of 100 megawatts or more, that reasonably ensure that customers' rates will reflect the customer's representative share of the costs incurred to serve the customers and prevent other customer classes' rates from reflecting any unjust or unreasonable costs arising from service to such customers, and allows the Commission to order tariff schedules applicable to customers with lower annual peak demand. If rates set for LLPS customers do not cover the new cost of service to serve those customers, then existing ratepayers are worse off. If the revenue provided by LLPS customers is retained by Evergy and not passed through the revenue requirement calculation, but the increases to costs of service are, then existing ratepayers are worse off, even if the rates paid by LLPS customers covers the new cost of service. It's worth repeating that large load customer revenues cannot improve affordability if those revenues are retained by Evergy. The Commission should question and scrutinize Evergy on what happens to the revenue. And again, If the commission orders a tariff filing consistent with the stipulation, staff requests that this commission require tracking of revenues and expenses to a regulatory deferral account to be addressed in Evergy's next rate cases. Staff notes that the concepts behind several of Evergy's riders are worth exploring. But for now, let's assume that we can set rates for LLPS customers in this case that are exactly right and perfectly recognize the differences between LLPS customers and existing customers. The details of the interaction of these riders and these hypothetical just right rates would need to be carefully thought out and evaluated. This will require a future docket. Riders that will interfere with prudent planning should be rejected. As some final thoughts, I would like to firmly and clearly state that staff is not against economic development. However, staff is opposed to regulatory lag that benefits Evergy shareholders to the detriment of remaining ratepayer base, as well as the creation of a barrier of entry for future non-data center large load customers, which, in actuality, have greater job building potential than data centers. Staff does not inappropriately single out these large customers for any sort of unfair treatment. Customers of this size, whether Noranda, Nucor, Praxair, or Velvet Tech, have nearly always been the subject of special tariffs from Missouri utilities, and the complexities of schedules SIL and MKT are good examples of what special tariffs look like in an RTO world. And again, to reiterate, staff is not opposed to the creation of a working docket to facilitate commission input into the development on a final tariff. Staff remains ready to work with stakeholders in developing large load tariffs, and it is true that staff takes seriously Senate Bill 4's charge that tariff provisions reasonably ensure such customers' rates will reflect the customer's representative share of the costs incurred to serve the customers and prevent other customer classes' rates from reflecting any unjust or unreasonable costs arising from service to such customers. 11 members of staff are here today to answer questions, provide explanations, and give additional clarity to staff's recommendation and testimony. The staff witnesses you will hear from today are Jim Bush, Sean Lange, Michael Stallman, Brooke Mastroyanis, Jordan Hull, Brad Fortson, Amanda Arandia, Broderick Niemeyer, Claire Eubanks, Jay Lubert, and Sarah Lange. I will do my best to answer any questions you may have or try to direct you to the individual who can answer those questions. Thank you again for your consideration of this immensely important case.
Are there any commission questions? Okay, hearing none. I'm going to ask the Office of Public Counsel if they would like to go next or last. Okay. Ameren?
Good morning, and may it please the Commission. I'm Jim Lowry, and along with Wendy Tatro and Paula Johnson, we represent Ameren, Missouri in this case. One thing I think we do agree with staff on is that this case, and Ameren, Missouri's similar case, presents some really important issues for you to consider. The resolution of those issues will likely have a profound impact on Missouri Electric Utilities' ability to do what the PSC law requires that they do, and that is provide service to all who desire in their service territory, but on terms and at rates that reflect just and reasonable terms and rates. The Commission's resolution of the large load customer issues in this case and in Ameren, Missouri's case as well will also likely have a profound impact on the state's ability to capture the economic development opportunities that the state clearly wants to capture. The evidence in this case strongly supports the conclusion that businesses that are going to be a part of the 21st century economy, including large load customers who would be served under Evergy's tariff, under Ameren Missouri's similar tariff, present an immense opportunity for Missouri to capture literally billions of dollars of investment. That investment will come, with it will come a greatly increased tax base. It will employ Missourians both in construction and permanent jobs, and more jobs I think than staff gives credit for. That investment will also bring a substantial increase in economic activity generally, driven by those investments, by goods and services consumed by the people building the facilities and by the workers, both construction and permanent workers, who will be working at those facilities, and that in turn will create more economic benefit throughout the communities where they locate and throughout the state generally. Now, I think it's always true that with these economic development opportunities, and I think that's true of any opportunity that you have, as the saying goes, nothing ventured, nothing gained. I mean, there is a certain amount of risk that comes along with any opportunity that one pursues. That's just the way it is. And those risks do require thoughtful regulation by the Commission, and that's why we're here today, for the Commission to exercise its regulatory authority. Evergy's proposal and Ameren Missouri's proposal filing do address those risks by reflecting thoughtful, balanced, and fair terms designed to do a couple of things. First of all, they're designed to actually capture the opportunity, to capture the economic development opportunity that the state wants to capture. And secondly, they are designed to do so in a manner that comports with Senate Bill 4, specifically Section 393, 130.7, and to do what that statute requires. Reasonably ensure that the operation of those tariffs, together with the Commission's ongoing oversight over terms of service and over rates, and that's important, the Commission does have ongoing oversight, doesn't end in this case, will mean that large load customers ultimately are fair and that rates for other customers are also fair. Make no mistake, if we don't do the first, if we don't capture the opportunity, then what the terms and conditions and rates are won't matter, because there won't be any customers to which they would apply in the first place. As Ameren Missouri witness Rob Dixon details in his rebuttal testimony, there are numerous state legislative and executive policy priorities that clearly establish that the policy of the state is to capture economic development opportunities, because doing so is vital to the long-term prosperity of the state. As Mr. Dixon puts it, and I quote, "It is difficult to think of any Missouri governor or General Assembly in recent memory who has not made economic development one of their top priorities. That is certainly true of both the current and immediately previous governor, whose terms have coincided with the recent boom in large load and data center development," end quote. And Mr. Dixon, I think, aptly sums up the task before the Commission in this way, quote, "What the Commission should be doing here is to decide, based on the record in this case, whether Evergy's proposal will support the state's goals in promoting economic development while providing the reasonable assurance from a regulatory standpoint Senate Bill 4 requires," end quote. I'd note that the federal government similarly recognizes the importance of, for example, data centers to national security. You have a choice before you, and I think that's been made pretty clear by Evergy's and staff's opening statements and by their cases. You have a choice in this docket, and it's a binary choice between two competing proposals that can't be reconciled with each other. It's not a case where you can find middle ground and somehow meld them together. They are binary, vastly different approaches to large load customer tariffs, and there's really no getting away from that. I'm not going to go into the details of each. Evergy and staff have already done that quite a bit this morning, but what I will say is that of the two proposals, only Evergy's, as modified somewhat by the stipulation, although the basics of it remain the same as filed, is faithful to both the economic development priorities of the state and to the actual terms of 393, 130.7, which, when you distill the statute to its essence, it's requiring the Commission to determine that there is reasonable assurance that large load customer rates and terms will be fair, and reasonable assurance that the rates and terms for other customers will be fair. Unlike Evergy's approach, staff's proposal is not faithful to both those economic development priorities and to the statutory terms, which, as Governor Keogh said when he signed it, was actually intended to, quote, "support long-term economic development of the state." Now, why is staff's approach not faithful? The evidence will show that it is a hodgepodge of complex, unnecessary, opaque, overly risk-averse, and burdensome terms, conditions, and rates that are divorced from any basis in Evergy's actual cost of service and that are biased toward overcharging large load customers. Moreover, as has been pointed out this morning, it's uninformed by the needs of large load customers that the state seeks to attract in the first place. And therefore, it can't promote economic development. In fact, it's likely to deter economic development in the first place. Again, if you don't capture the opportunity, the terms won't matter. One need only read Staff Industry Analysis Director Jim Bush's testimony to appreciate why the staff has developed the proposal it has put before you. Notwithstanding what Staff Counsel said a few minutes ago, Mr. Bush's testimony reflects his opinion that the economic advantages of attracting large load customers, I guess specifically data centers is what he was talking about, attracting that investment in Missouri is simply, quote, not worth the risk. That's what he said. And so what has staff done? Well, staff has developed an uncompetitive proposal that appears to substitute its viewpoint for the state's decisions about the importance of economic development and that suffers from the infirmities I just mentioned, and created a situation where nothing will be ventured and nothing would be gained if that proposal were adopted. Although staff repeatedly, and I would point this out, they repeatedly cite 393.130.7 as if it supports their tariff structure, but they do so in a conclusory fashion. They never provide a cogent interpretation of what the statute means, but it's not difficult to see what they think it means when you look at their proposal. It ignores the actual language of the statute, and it ignores the context in which it was adopted. It reflects staff's view, it appears to me, not that large load customer tariffs should reasonably ensure that essentially rates are fair on both sides, but there should be an ironclad guarantee that large load customers are in effect ring-fenced such that other customers don't experience a single cent of cost that could even conceivably be considered to have been caused by service provided to them. Never mind that the utility has an obligation to serve those in its service territory and to not discriminate among those customers. If staff's viewpoint of what 393.130.7 means were adopted, then the General Assembly, by adopting that statute, has in effect undone all of the economic development related statutes that the General Assembly has put in effect, and Governor Kehoe's signing of Senate Bill 4 is not going to support economic development in the state as he said it would when he signed it, but instead it's going to severely hamper it. As Mr. Dixon puts it, adoption of staff's proposal would amount to erecting a closed for business sign at the borders of Missouri. Compare that message to the message other states are sending who have adopted tariffs that are in effect pretty similar to Evergy's, because Evergy actually modeled their terms to a great degree on what is happening across the country in the states with which Missouri is competing, and that includes Kansas, our neighbor to the west, where a diverse group of parties, including the KCC staff and the consumer advocate in Kansas, have agreed on a large load customer tariff that looks much like the proposal that is before you in this case. I want to address one other issue this morning that's apart from the terms and conditions of staff's and Evergy's large load tariff proposals, and that is that is staff's attempt to inappropriately bootstrap into this case the rate-making treatment of future electric service revenues. This case is about large load customer tariff terms and conditions. It's not about future revenue requirements and future rate cases where all relevant factors will be considered. What staff is proposing to do is yank away what could be positive regulatory lag temporarily created by these customers as they ramp up their operations. And it's inappropriate for them to do so in this case. It doesn't need to be done in this case, but it's inappropriate for a number of reasons. First of all, it's a one-sided proposal. It's a one-way tracker. And it ignores the fact that utilities consistently and persistently face negative regulatory lag all the time. That's the way the system works. But staff just wants to capture one side of the equation. Second, it's contrary to the basic reason regulatory lag exists in the first place. One of the most basic principles of public utility regulation, to incent cost control and efficiency, as staff itself has on many occasions indicated should be done. And finally, it's biased and grossly overstates the possible positive regulatory lag that large load customers could provide. And I'm not going to go into all the reasons why that's the case, but Mr. Wills in his rebuttal testimony lays out several reasons why it grossly overstates the possible positive regulatory lag. In closing, I want to circle back to where I started. This is an important case, and so too is Ameren Missouri's similar case, as you recognize in your intervention orders in both cases. That staff has in substance made the same proposal in both this case and Ameren Missouri's case ties those cases together even more closely, because you've really got the same proposal made in both cases. Consequently, in making what will be, at least from a practical perspective, policy decisions about how the state law and policy should be applied in this context, in the context of large load customers, the Commission should give strong consideration to taking its decision, in this case under advisement once it's submitted, hearing Ameren Missouri's case, and only then making its decision in both cases. Only then, this approach will, as you yourself put it in one of your intervention orders, allow evaluation of, quote, both approaches to large load customer demand, and ultimately issue tariffs that are in the best interest of the state and of all customers, end quote. Appreciate your attention, and if there are any questions I can answer at this time, I'll do my best to do so.
Can the attorney for Ameren please spell his name for the court reporter?
Jim, J-I-M, Lowry, L-O-W-E-R-Y.
Thank you. Are there any commission questions?
Thank you.
Google? Please state and spell your name for the court reporter.
Thank you, Judge. I'm Andrew Schulte. First name spelled as you would expect, A-N-D-R-E-W. Last name S-C-H-U-L-T-E. And along with Frank Caro and Jared Jevons, we represent Google LLC in this proceeding. And good morning, Chair Hahn, Judge Walker. Good morning, Commissioner Kolkmeyer. And good morning to Commissioners Coleman and Mitchell as they listen online. We appreciate the opportunity to be here today, and we appreciate the leadership that the state of Missouri has shown on large loads. That includes the proactive tariff filing by Evergy, the direction provided by the General Assembly through the passage of Senate Bill 4, and the diligence of this commission in presiding over this pivotal case. Before addressing the merits of the issues before you today, I want to provide some background on Google's efforts to develop data centers responsibly. Given the increased focus of data center load growth and artificial intelligence, or AI, more broadly, we believe it is important to state the why and how of Google's approach to data center deployment across the state, the nation, and the world. Google's data center development and investment is defined and informed by the following pillars. First, advancing vital infrastructure. That means building the necessary infrastructure of tomorrow to support connection, digitization, and prosperity for all. Second, accelerating the economy. That means bringing more economic activity, new business, and growth opportunities to the communities we call home. Third, investing in communities. That means collaborating with each community and providing long-term support through grants, educational programs, and other initiatives. And fourth, innovative, sustainable solutions. That means driving advancements in sustainability every day by accelerating the clean energy transition, continually improving efficiency, and preserving natural resources. As Google makes business decisions regarding growth in the region, clear policy and signals and regulatory frameworks are key components that help Google make informed and long-term business decisions. In Google's view, the recently passed Senate Bill 4 lays the groundwork for what should be a clear, objective, and transparent framework for infrastructure investment across the state. Because of Senate Bill 4, companies like Google can explore multi-billion-dollar investments with increased confidence, knowing that there will be a clear regulatory path that balances flexibility with appropriate levels of commission oversight. Additionally, Missouri's long history of affordable and reliable service, coupled with its forward-looking regulatory structure, make it well-positioned among states competing for large-scale data center and AI investment. This is why we view Missouri not just as a location for new facilities, but as a partner in building the infrastructure of the digital future. The current dynamics within the energy industry and the global economy places us in historic and evolving environment. This dynamic requires an active commitment to develop and advance new solutions, which should be the result of a deliberate process that considers the impact of all affected stakeholders, helping us to achieve our shared goals. Risk management and financial risk-sharing structures are central to that discussion. Utilities and ratepayers more broadly have historically borne the investment risks associated with demand forecast inaccuracy. As a good corporate and grid citizen, Google recognizes, however, that at current demand projection levels, which include AI, cloud computing, and policies supporting the onshoring of advanced manufacturing, it is important that the cost and benefits of new infrastructure are appropriately balanced and assigned. While Google recognizes that projections of new load growth have raised concerns among a wide variety of impacted parties, we believe this situation presents a unique opportunity. This is a chance for regulators, customers, and utilities to establish partnerships that can be leveraged to power the digital economy moving forward. Data centers are not just large consumers of power. They are also economic and operational partners that provide important advantages to electric utilities like Evergy and their customers. For example, the operational advantages are numerous. They include data centers that are consistent and predictable consumers of energy that support the more efficient operation and planning of the electric utility grid. It enables utility system planners and grid operators to optimize existing generation and transmission infrastructure, which can delay new infrastructure investments and improve overall system efficiency. Many large load customers engage in demand management, which further enhances grid stability and reliability. There are also numerous economic advantages associated with data centers coming online. Those advantages include data centers' consistent energy usage, which helps distribute fixed costs across a larger energy volume, contributing to a lower average cost per kilowatt hour for all customers. Google, in particular, is leading with several strategic initiatives that provide significant operational benefits to electric utilities like Evergy and their customers. These include long-term energy storage technology. Specifically, Google recently partnered with Energy Dome, who developed a CO2 battery technology that can continuously dispatch energy for 8 to 24 hours. This technology can help stabilize the grid by providing natural inertia from rotating machinery to act as a shock absorber and smooth out sudden changes in frequency. Google is also involved in demand-side flexibility initiatives. These include developing the capability to dynamically shift computing tasks and data consumption across its data centers, to enable access to available carbon-free electricity, and to provide additional capacity when requested by system operators. Google is a major contributing partner in DC Flex, which is EPRI's, or the Electric Power Research Institute's, new initiative to create frameworks for data centers to support and strengthen the grid through demand-side flexibility. Google and other data centers developers are investing in advanced transmission technologies. Google recently announced an initiative to accelerate deployment of next-generation transmission technology, specifically advanced conductors, across the U.S. electric grid to enhance the capability and capacity of existing transmission lines at a fraction of the cost of installing new transmission. In their opening statements, Evergy and Ameren addressed the numerous flaws with staff's proposal. Google agrees that there are numerous fatal flaws with staff's proposal, and those are explained in Dr. Berry's rebuttal testimony on behalf of Google. I will not burden the record here by repeating all of those flaws. However, I do want to say a few words about Google's unique perspective on staff's proposal. Google has participated in large load tariff proceedings in multiple jurisdictions. In the Midwest specifically, Google has participated in proceedings in Kansas, Ohio, and Indiana, in addition to Missouri. In Kansas and Indiana, the parties reached unanimous global settlement agreements. The tariffs developed through each of those proceedings followed an emerging consensus on how to balance the benefits and opportunity of large loads versus the risks represented by those loads. Generally speaking, the tariffs established thresholds for tariff applicability, minimum contract terms, including a load ramp period, contract capacity requirements, including permissible capacity reductions with notice and fees, termination provisions, including significant notice and exit fee requirements, applicable rates and charges, including minimum monthly bills, and customer creditworthiness and collateral or security requirements. Some of these large load tariffs also address procedures and processes and cost associated with interim capacity, optional riders, including customer capacity riders, demand response riders, clean energy riders, and more. And they also address requirements for customer-specific service agreements. The stipulation and agreement in this case is similar to the unanimous settlement agreement filed in Kansas. And we recognize that the Kansas settlement agreement is not determinative. However, it is noteworthy that it was supported by a very diverse group of 17 stakeholders, which included the KCC staff, the Citizens Utility Ratepayer Board, which is similar to the OPC in Missouri. The Kansas settlement was also supported by existing industrial customers and existing school district customers. The broad support in Kansas and the similarities between the Kansas settlement and the Missouri stipulation and agreement underscore the fact that customer protections within the Missouri stipulation and agreement are in alignment with stakeholder expectations and widely accepted standards. Conversely, staff's proposal deviates from that emerging standard and sound regulatory policy. For example, it has been noted that staff did not consult with any large load customers or utilities, nor did they conduct a detailed comparison of other large load tariffs to inform or validate their approach. Staff assumed without sound justification that the current rate-making framework and methods for cost allocation for large load customers will not result in an allocation based on cost causation. However, staff has not identified deficiencies in the current framework that would provide the basis for their proposed changes. The emerging industry standard establishes terms and conditions that ensure large load customers contribute their representative share of costs while minimizing risk to other customers. If the anticipated load growth fails to materialize, which is a very unlikely scenario, customers are still protected through tariff provisions that I've mentioned before, which include minimum contract terms, minimum monthly bills, collateral requirements, notice provisions, and fees for any reductions in capacity. Staff's proposal, however, fails to include minimum demand or bill charges or options to reduce contract capacity after notice and fees, and it does not include options to secure renewable or clean energy. Moreover, a complete overhaul of rates, such as what staff has proposed, should only occur within a formal rate case. Staff does not have the data required to determine if such a major change is needed or how it would best be implemented outside of the established regulatory framework of a rate case. Staff's proposal is unduly discriminatory because it proposes separating large load customers from all other customers and then allocating costs and designing rates using completely different methods for the large load customers. It is also not cost-based in several respects. For example, the demand deviation charge, which is proposed by staff, penalizes large load customers if their updated yearly demand estimates differ from their contract demand. The charge is based on the SPP deficiency payment, which applies to load-responsible entities, such as Evergy, that fail to obtain sufficient capacity to meet their resource adequacy requirement. Such SPP deficiency payment does not and should not apply to individual customers. They have a similar charge called an imbalance charge that penalizes large load customers if its actual monthly demand is different from its forecasted monthly demand. And this charge is also based on the wholly unrelated SPP deficiency payment. Staff recommends that the Commission reject Evergy's 4 renewable and carbon-free riders that are part of the LLPS proposal. but staff does not replace those riders with options that are necessary to attract large load customers who often have aggressive corporate clean energy goals and who desire energy options that allow them to manage their energy mix. The Commission should adopt the stipulation and agreement in this case because it falls within the emerging industry standard and protects existing customers. Specifically, the stipulation includes a minimum contract term of 12 years in addition to a ramp period of 5 years, which is consistent with the recently approved large load tariff for Indiana-Michigan Power in Indiana. The stipulation implements a minimum demand charge of 80% of contract capacity, even if actual usage falls below that threshold. Additionally, under the stipulation, large load customers cannot exit the system without 36 months notice and payment of an exit fee equal to the value of the minimum monthly bill times the number of months remaining in the term, extension term, or 12 months, whichever is greater. Large load customers cannot reduce their contract capacity during the first 5 years of the term, but may subsequently reduce their contract capacity only within certain limits. Those limits are 25 megawatts or 10%, whichever is lower. But that reduction may only occur after 24 months prior notice, and reductions beyond that amount, so beyond 25 megawatts or 10%, require 36 months notice and payment of fees based on the remaining minimum monthly bills. These protections ensure that other customer classes' rates will not reflect any unjust or unreasonable cost associated with service to large load customers. Thank you again for the opportunity to be here and for your consideration of the evidence that was pre-filed in this testimony and that you will hear during the evidentiary proceedings. Google's witness, Dr. Carolyn Berry, is in the hearing room this morning, and she looks forward to responding to your questions regarding the emerging industry standards for large load tariffs and the appropriate balance that is struck by the stipulation filed in this case. Thank you.
Any commission questions? Hearing none. We will go to opening statements for data center.
Thank you, Your Honor. And this is Nikhil Vijaykar, appearing via video. Can everybody hear me?
Yes, can you please spell your name for the court reporter?
Certainly. My name is Nikhil. That's Nikhil. My last name is Vijaykar. Vijayakar. Okay. Thank you, and good morning, and may it please the Commission. My name again is Nikhil Vijaykar, and I am one of the attorneys representing the Data Center Coalition in this case. My colleague, Elisa Greenwald, is also online and is also representing DCC in this case. And we appreciate this opportunity to present an opening statement. Let me start with some quick background on DCC for the Commission's benefit. DCC is the National Association for the Data Center Industry. It represents leading companies who own and operate data center infrastructure across the country and across the globe. In this opening statement, I will discuss DCC's perspective on Evergy's LLPS application and request the Commission approve the September 25th, 2025 non-unanimous stipulation that several counsel have already addressed this morning. As I will explain, that stipulation is a balanced resolution of the several important policy issues and questions that Evergy's application raises. Now, Commissioners and Your Honor, as you have heard from parties already, the reason we're here, the impetus behind Evergy's application, is a surge in requests for service from large load customers, including data center customers like DCC's members. Now, these customers represent a massive opportunity for the state of Missouri. They are likely to invest billions of dollars in the company's service territory, create good-paying jobs in construction and information technology and maintenance, diversify the state's economic industrial base, and bring in significant new revenues that will help the company spread the fixed costs of its system over a larger base. However, Missouri will only realize those benefits if the customers and the load actually show up. And I thought Office of Public Counsel witness Jeff Mark put it well in his surrebuttal testimony. He says the benefits of data center customers to the state and to local communities have the potential to be quite large. But this is predicated on the assumption that the customer takes service for long enough for those benefits to be realized. Which brings us to the main problem that the company is trying to solve here. The core objective of the new large load power service tariff is to mitigate the risk of stranded costs and the cost shifting to other customer classes that could occur if large loads do not materialize as the company expects. That's the objective motivating the substantial new customer protections Evergy proposes in this case, including long-term contract commitments, minimum demand charges, termination provisions and termination fees, and financial security provisions. Now, rather than negotiating those protections on a one-off basis with individual customers, as has sometimes occurred historically, Evergy here proposes to move those protections into a tariff, recognizing that the company has a queue of large loads requesting service. Now, while DCC believes it is highly likely that the large loads Evergy forecasts will in fact materialize, DCC nevertheless supports reasonable customer protections and supports the creation of a tariff that reflects those protections. As this commission is likely well aware, while Evergy is certainly an early mover, regulators across the country are considering utility proposals to impose new requirements on large customers. Those proposals generally aim to leverage the opportunities that electric load growth will bring while mitigating its risks. DCC is active in many of those cases and has routinely supported reasonable policies that accommodate load growth in a thoughtful and deliberate manner so as to mitigate the risk of stranded costs. That is why, as you see in the pre-filed testimony of DCC's witnesses, we do not object to the customer protections Evergy proposes in concept, nor do we object to the proposal to create a tariff that reflects those protections. DCC's recommendations in their witnesses' pre-filed testimony are generally modest and aimed at ensuring that customer protections allow large customers a reasonable level of flexibility such that the company is able to attract a diverse set of large loads. That said, DCC does not support the company's system support rider proposal as filed, however, because that proposal is conceptually and analytically flawed and doesn't do anything to mitigate the risk of stranded costs. This is a focus of DCC witness Higgins' pre-filed rebuttal testimony, and I would note staff witness Sarah Lange also criticizes the SSR proposal in her testimony. While I won't get into Mr. Higgins or Ms. Lange's critique of the SSR proposal in depth, as a threshold issue, that proposal is broken because it would collect revenues from large load customers without defining any specific costs to be recovered. The premise of the SSR is also broken. It focuses exclusively on the supposed acceleration of generation costs to serve large customers, but ignores the acceleration of revenues that accompany those costs and the obvious relationship between revenues and costs that ultimately impacts customer rates. The Commission should reject the SSR, but to be clear, that does not mean DCC encourages the company or this Commission to ignore the potential revenue and cost allocation impacts if large loads do materialize as the company anticipates. We just don't think this is the right venue. The logical venue to work out the allocation of cost responsibilities after a change in the company's resource mix is a general rate case. The Commission should not address that issue through an abstract acceleration charge that does not reflect actual costs or actual retail load. Now, since the time that DCC and other parties filed testimony, we being DCC, was able to reach a settlement agreement with many, but not all, of the parties to this case. That settlement agreement resembles the comprehensive, unanimous settlement that parties reached in Evergy's parallel case in Kansas. Now, while I will of course not get into the substance of settlement negotiations, I can say that a lot of hard work and difficult conversations went into negotiating both a settlement in Kansas and ultimately a settlement agreement here. But ultimately, DCC supported the settlement agreement in Kansas and the one filed here because we felt it strikes a balance. It gives large load customers, including DCC's members, a reasonable opportunity to do business in the company's service territory, allows customers modest flexibility, but also guarantees significant minimum revenues from large loads to protect other customers, non-large load customers, from cost shifting. Importantly, the settlement proposal does not include the system support rider proposal, which, as I discussed, DCC does not support because it is fundamentally flawed. The suite of customer protections that is included in the proposed settlement is not identical to the customer protections that other utilities in other jurisdictions have adopted, which of course is not surprising because every utility is necessarily different. However, those protections are reasonably in line with where other utilities have landed when trying to answer the same question that Evergy tries to answer with its application here. We therefore urge the Commission to adopt the non-unanimous settlement as a reasonable resolution of this case. The last thing I'll address is staff's pricing proposal in this case. Now, while DCC appreciates staff's efforts to address large load growth in the company's service territory by advancing a series of pricing proposals, those proposals have multiple flaws and leave a lot of questions unanswered. We agree with counsel for Evergy and Google, where they describe staff's proposal as different from and significantly more complex than anything we have seen in other jurisdictions grappling with large load issues across the country. And frankly, the suite of proposals is simply unworkable for large load customers. DCC witness Higgins addresses the flaws in staff's proposal in detail in his surrebuttal testimony. At its core, staff's pricing proposal boils down to a near 25% markup over staff's calculation of the sum of variable and fixed costs to serve large customers. Now, putting aside some of the errors in staff's calculation, which DCC points out in its testimony, staff's 25% markup is essentially an arbitrary premium. The Commission should not accept staff's suite of proposals and instead should approve the non-unanimous stipulation. With that, Commissioners and Your Honor, I will conclude my opening statement, and I look forward to presenting DCC's case through its witnesses at the appropriate time. Those witnesses are Kevin Higgins, a principal in the firm of Energy Strategies, LLC, and Shana Ramirez, a director at Energy and Environmental Economics, also known as E3. Thank you for your time this morning.
We can have an opening statement from Nucor Steel.
Thank you, Judge. Mark Ellinger on behalf of Nucor Steel Sedalia LLC. That's MARCELLINGER. Madam Chairman, members of the Commission, Judge, Nucor stands here as a slightly different party than everyone else to this matter. We're not a utility, we're not a governmental entity, we're not a public interest group, we're not a data center, we're not a coalition of data centers. We're a private steel employer located in Sedalia, Missouri, a major manufacturer with a major employment base. We're also a major user of electricity. We really believe in economic growth and development, and we think that the non-unanimous stipulation that has been developed is one that fosters that opportunity for economic growth and development. As you may know, Nucor currently takes electricity under a special contract under Schedule SIL of the tariff, and we support the stipulation. And we really want to start by saying thank you very much to all the parties, particularly Evergy and the parties to the stipulation who reached out and did have a negotiation over this to come to a reasonable, fair, and ultimately beneficial for the state of Missouri determination of what a LLPS tariff should look like. I think the conclusion that we all came to as a group of private parties, utilities, users, and frankly, public interest groups is
this is the best interest of Missouri. It complies with what the General Assembly set as a policy. And we think that this commission should adopt that. And we think that the proposal that's made by staff and by the Office of Public Counsel kind of going along with it does not serve those same economic development benefits. Nucor has been a good employer in the state of Missouri. It's an employer that has grown and potentially in the future would like to grow more. And the opportunities that are offered under the proposed non-unanimous stipulation are opportunities that we believe will foster that growth and development in the future. With that, I urge this commission to adopt the non-unanimous stipulation and agreement, and I'd be happy to answer any questions.
Are there any commission questions?
Thank you, Judge. Good morning, Mr. Ellender.
Good morning, Commissioner Kolkmar.
2 questions.
Yes, sir.
Does Nucor have another plant smelter in Missouri, or is that just across the line in Arkansas?
It's in Arkansas.
And that is served by Ameren?
I believe that's correct, although I can't specifically say that.
Okay, so the one in Sedalia is
Served by Evergy.
Evergy. Okay, what is the usage at Sedalia? Or is that confidential?
That's a highly confidential matter, but it's a significant usage.
And you would fall, that you would or would not fall under these rates?
Depending upon where that rate target was set.
That threshold?
The threshold,
Yes.
future development could definitely fall into that rate.
Okay.
And depending on whether it was applied retroactively or whether, we believe that the SIL tariff should continue to maintain, and we would take service under the SIL tariff. It wouldn't change the existing operations.
Okay. Are you going to come back up and testify for Velvet, or?
No, I'm not.
Okay. Is your company, your firm?
My partner, Stephanie Bell, and our firm does represent Velvet separately.
Are they going to testify?
Testify or make an opening statement?
Yes, make an opening statement.
I believe she is planning on making an opening statement. Yes, I believe so.
I'll save a question for her.
Okay, thank you very much.
Thank you.
Thank you, Commissioner Kolkmeyer. Are there any other commission questions? Okay,
Thank you.
hearing none. Velvet Tech?
Thank you, Your Honor. Stephanie Bell, that's Stephanie, Bell, Bell. May it please the Commission, Stephanie Bell for Velvet Tech Services, which is wholly owned by Meta. As you know, Velvet is Evergy's first hyperscale data center customer, and the Kansas City data center is now operational. The data center represents an investment of over $1 billion in the state of Missouri, with the majority of construction materials sourced right here in the U.S. The construction of the data center resulted in an average of 1,500 skilled trade workers on site at its peak. In addition, Meta has proudly directed more than $1 million to schools and nonprofits spanning Clay County, Platte County, and Kansas City, Missouri. In the words of Brad Davis, Data Center Community and Economic Development Director at Meta, in 2022, we selected Kansas City because it offered excellent infrastructure, a robust electrical grid, a strong pool of talent for construction and operations jobs, and incredible community partners. We are extremely proud to be part of this community, and we look forward to continuing to strengthen our partnership for years to come. As you know, Velvet is a signatory to and supports the non-unanimous Global Stipulation and Agreement. This stipulation represents lengthy negotiations among diverse stakeholders, utilities, large industrial customers, data center operators, environmental advocates. The result is a balanced framework that serves multiple critical public interests. First, the stipulation addresses Missouri's economic competitiveness. The LLPS tariff creates a structured pathway for large load customers to locate and expand in Missouri. The 75 megawatt threshold appropriately captures customers whose load characteristics require specialized rate treatment while maintaining protections for existing customers and traditional ratepayers. Second, this stipulation includes robust customer protections. The comprehensive collateral requirements protect existing ratepayers from financial risk.
Credit-based discounts reward credit-worthy customers while maintaining security. The framework also ensures large customers cover their cost of service and prevents subsidization by other customer classes. Third, the stipulation aligns with many customers' clean energy goals. The renewable energy riders provide flexibility for large customers to support renewable development and meet corporate sustainability requirements. Fourth, the settlement protects against stranded costs through carefully crafted exit provisions. The minimum term, coupled with substantial exit fees, ensures long-term commitments while providing utilities reasonable cost recovery certainty. Finally, this framework includes meaningful oversight mechanisms. Annual reporting requirements as well as stakeholder meetings ensure transparency and accountability as this new rate class develops. For Velvet specifically, this tariff provides the regulatory certainty needed for long-term infrastructure investments while ensuring we pay our fair share of system costs. The alternative to this settlement is continued uncertainty, delayed investment, and missed economic development opportunities. This stipulation strikes the right balance, protecting existing customers, enabling economic growth, and providing regulatory certainty. We respectfully request the Commission to approve the stipulation, recognizing that its interdependent provisions represent a carefully negotiated compromise that best serves the public interest. Thank you. Commissioner Kolkmeyer?
Yes, you were kind of forewarned, weren't you?
I was.
Yes. Are you at liberty to tell the consumption, energy consumption of your current data center?
I'm not.
Okay.
But as you'll recognize on the issue list and as part of the stipulation, Velvet's current operation, for folks who've signed their ESA by the time this tariff is approved, they're essentially grandfathered. And so the deal that Meta reached on for the facility that was already built it is essentially grandfathered. However, as you know, there's a lot of data center growth. So to the extent that Meta was to expand above that 75 megawatt threshold, we would be under the new LLPS tariff.
That was my next question.
Yes.
I have one more.
Okay.
How much water do you use?
So that's a really interesting question, and certainly in OPC's testimony, they raised some concerns about different reporting that they would like to see. And I would urge you, Meta produces multiple reports every year. They are really in-depth. There's two reports that I direct you to. There's a sustainability report and a data index. And those are published on their website annually, and they report things like water usage, like many of the issues that OPC addressed in its testimony publicly. And in fact, in certain circumstances, they are broken down by each facility. So while the Kansas City facility is new, you start to see some of that reporting on the most recent public reports broken down by, and you'll see Kansas City included.
I do have one more. Can you expand that counties into Lafayette for taxes?
Okay, I'll make that suggestion.
Okay, thank you. My schools could use it.
All right, thank you, Commissioner.
Thank you.
Oh. Is there anyone from Sierra Club online?
Yes, good morning. This is Sarah Rubenstein
Thank
for
you.
Sierra Club.
Ms. Rubenstein, can you state and spell your name for the court reporter, please?
Certainly. Sarah, S-A-R-A-H, Rubenstein, R-U-B-E-N-S-T-E-I-N. Good morning, Commissioners and Judge Walker. My name is Sarah Rubenstein. May it please the Commission, I represent Sierra Club in this matter. Large load growth, particularly from data centers, is the primary issue of this proceeding, but also of utility regulation nationwide. The historic increase in load growth has the potential to shape ratepayer bills for decades to come. Sierra Club believes that the non-unanimous stipulation filed before this Commission fairly resolves the issues in this docket among the disparate interests of the parties for 3 reasons. First, any adopted tariff must ensure that large load customers do not encumber other customer classes with incremental cost or risk, and also ensure that these customers pay their fair share of the costs incurred to serve them. Simply put, large load customers must pay the costs that they are causing on the electric system. Sierra Club believes that the settlement adequately insulates Evergy from stranded asset risk and provides a framework for large load customers to mitigate the costs that they cause on Evergy's system. Second, Evergy must provide a path for large load customers to procure the clean energy that they demand. Many large load customers have climate goals and want to locate in states where they can procure clean energy. The settlement provides a means by which these customers can procure clean energy to meet their goals, while also benefiting all of Evergy's customers at no direct cost to non-large load customers. This will help stabilize, if not drive down costs through diversification of generation. Third, the non-unanimous settlement is very similar to the unanimous settlement filed before the Kansas Corporation Commission. Having similar rules between the 2 jurisdictions provides for a level playing field between the states as they compete for economic development opportunities, and also helps to ensure that ratepayers in both states do not experience wildly different treatment. For these reasons, Sierra Club respectfully requests that the Commission approve the non-unanimous settlement struck between and among most of the parties in this docket. Thank you for your time.
Are there any commission questions? Okay, hearing none, thank you very much.
Thank you.
We will now hear from Renew Missouri.
Good morning, and if it can please the commission, this is Nicole Mers, and that is Nicolemers on behalf of Renew. I'm going to be very brief because it is almost 11 and we've been sitting here for a while, so we've got a lot of witnesses. We provided some limited testimony in this case about the renewable riders. In approaching this case, Renew's framework for evaluating it was being mindful of the efforts that have been taking place in the legislature and with the governor's office to encourage economic development. It appears that policymakers have decided that attracting these customers is in the interest of the state of Missouri. So then what happens next? Well, as a signatory to the stipulation, we believe that that stipulation provides a framework that provides a tariff and rate structure that will both attract the large load customers, but ensure that they will provide additional contributions to the revenue requirements, which is better than the status quo would be currently. In addition, the riders that Renew Missouri had supported are all contained in the stipulation. There was a bit of an expansion, actually, to allow non-utility scale solar to be allowed, so we were very excited to see that. And we believe that those riders will also help attract these customers to the state. You heard the customers themselves mention it several times, so we believe that that's important. And we believe that the benefits of that renewable generation, having those riders will help bring those to the state and to the customer base. So with that, I'll just conclude my remarks, but if you have any questions, I'll try to answer them.
Any commission questions? Okay, thank you very much.
Thanks.
The Office of Public Counsel. Thank you.
Brian, when you're ready. There we go, super. Speaking to the mic. Good morning. I'm pretty sure you all know who I am, but for the record, John Kleiser on behalf of the Missouri Office of the Public Counsel, and my name is Johncliser, So, I want to start off by saying, honestly, Commission, I don't envy your position here. This is quite possibly one of the most important cases that you're going to hear. It's one of the most important cases that probably has come before this Commission in a very long while. And that has to do with the size and scale of the investments that we're talking about that are going to be involved in serving the amount of load coming on. And we're going to get to that in just a second. But I really want the Commission to consider just how impactful this case could be on Missouri, on regulation, on everything that we're doing, and specifically Missouri ratepayers. And also consider that, we're dealing with this in a very rapidly evolving environment. We have news coming out just about every day on changes to how AI and data centers are being used and handled. And it really does beg the question whether or not we should be slowing down to think about this a little bit. Now, fortunately, the good news is that this Commission has plenty of opportunities to think about. I believe Mr. Lowry, on behalf of Ameren, for example, pointed out that the Commission is about to hear pretty much this same case in about a month's time, and that they should be waiting to hear the case then before making a decision here. And I actually echo that opinion. I think the Commission should really consider hearing both this case and Ameren before rendering a decision in either case. Another opportunity is that we could potentially move towards a workshop, for example. That was an issue that was brought up by the Commission staff. And frankly, it's one that merits some consideration. Maybe it would be a better idea, instead of trying to do this in two cases, to pump the brakes, go to a workshop, and think it all through. But again, we are here, so let's go through this and kind of talk about it. With that in mind, the one thing I would ask is just that the Commission maintain a healthy degree of skepticism and really consider all of the impacts here. So, I mentioned a moment ago about the size of the impact, and I really want to focus on that for a second. This picture in front of you, this was taken from the Evergy annual 5-year capital plan that was filed in March of '25. This is a public version. And it's showing what Evergy projects in terms of a demand capacity coming online. The gray bar that you can see on the right there is their current demand, and it's about 10.6 gigawatts. That means that all the residential, all the commercial, all the industrial customers Evergy has right now are demanding about 10.6 gigawatts. The bar on the left is what Evergy is anticipating might come online in 5 years. And the first thing to note about that is the bar on the left is actually larger than the bar on the right. Please go ahead.
Can I ask a question midstream?
Absolutely.
Is that all of Evergy, or is that in Missouri?
That is all of Evergy, yes.
Okay.
And I don't know why that backed forward. That's just a product of how Evergy presented it, not my choice.
Okay.
But the point here is that we're talking about quite literally doubling the size of the utility over a 5-year period. And you'll note that even if you cut out the balance of pipeline at the end, the 6 gigawatts in various stages of preliminary discussion, the remaining balance is still nearly 50% of the company's existing demand. So no matter how you slice it, this is enormous. I mean, you are really, really changing the scope and field of how we operate here. And the one thing I want to bring up, so a large amount of this is being driven by data centers. That's the kind of word of the day, right? And it's what's kind of weird going through and listening to all of these opening arguments is that you're not hearing a whole lot about the risks associated with data centers. We all seem to just be assuming that these data centers are going to come online, they're going to stay online, they're going to make money, and everything will be hunky-dory. And I kind of think that's a bit concerning, and I'll get to why in just a second. Let me give you what I think are the two arguments for why we should like data centers, right? And they've sort of been touched on by prior people. They are, first, adding data centers will spread fixed costs and thus lower rates for non-data center customers. You heard this also sort of referenced as additional revenue, rate stabilization. There's all sort of wrapped into the same concept. And then the other one, which we've definitely heard several people mention, are the economic development, creating jobs, tax revenues, and et cetera. And I want to take just a brief moment to touch on both of those because there's a little bit of a myth, I think, surrounding both that needs to be addressed. And the first comes with this idea that, data centers are automatically going to lower rates for everybody. That's not necessarily true. And the reason it's not true is because fixed costs may not benefit customers if there's also an increase to fixed costs. Let me give you an analogy to really explain exactly what I mean. I want you to think of three guys renting a house together, right? And their landlord charges them $3,000. So each one of those three guys is paying $1,000 in rent a month. A fourth guy comes on and he says, I'd like to join you. Now they're splitting the rent 4 ways and each one's paying $750. That's an example of how you can lower the costs for everybody by spreading them out. But what happens if that fourth guy comes on and he can't move into the house because there's not enough space? He has a whole bunch of knickknacks and stuff that he needs to get somewhere, and they just don't have the space there. The landlord comes back and says, well, what if I build you a new house, brand new, and I'll charge all 4 of you the rent for those 2 houses. In that case, now the whole group is paying $6,000 in rent between the 2 houses, but they've still split it up 4 ways. But each person's now paying $1,500 in rent. You see, what's happened here is even though you've spread out the costs, you've also increased the costs because you had to build more. And that's the situation in front of us right now. Bringing on data centers is going to spread out the fixed costs for all customers, but the companies don't have the generation needed to serve those data centers. So they're going to have to build more and thereby increase the existing fixed costs in order to provide service. And it's a very real possibility that increasing those fixed costs might mean that everybody's rates go up, even as you're spreading them out. And then you can double down on that. We know that it's getting more expensive to build generation right now. In a recent case in which Evergy sought a CCN for additional build, we had already seen prices rising as high as 60% against what they've been in the past. We have tariffs, we have inflation, we have all kinds of things driving up the prices. So if we have to build even more generation to serve this new load coming on, again, the risk that rates for everyone will rise increases. And then you add on to that the fact that we're in a constrained energy market, and you see again, prices are set to rise. As more people tug on the demand, as more people need more energy, the cost for everyone is going to go up. So this idea that data centers are just bar none going to lower rates for customers, it's not as clear cut as you'd think. Now let's consider job growth, because that's something we've definitely heard a lot of. And it's very true that data center build is going to create a lot of temporary jobs. There's no doubt about that. But they create much fewer permanent jobs than anybody here would like to admit. And I think the best way to see that is to look at the testimony of Dr. Mark, who compared, for example, the 875-acre, $500 billion Stargate project that's being built by OpenAI in Texas, which is expected to create 57 full-time jobs, just 57, with an annual wage of $57,000 and a net salary gain of about $3 million. He compared that to the average Sam's Club, which is employing about 160 to 7 associates, admittedly at a lower salary, but actively actually generating a much higher net salary gain. So this idea that these data centers are going to be this engine of job growth and economic development, it doesn't actually stand true. And that's before you start to consider the other problems that might be out there. For example, there's already a lack of transparency surrounding the impact of data centers. We're not entirely sure the impact they're going to have on water tables, and as we'll discuss later, there's already concern regarding the impact they have on the electrical grid, a very big concern that many people in this room seem to have ignored. There's also a very high risk that other customers are going to be asked to subsidize these data centers. And by the end of this, I'm going to explain how, in my opinion, that risk of subsidization, that is this case. Of all the issues that have been brought forward, the biggest one, the most important one, is really just, are we allowing non-data center, non-LLPS customers to subsidize data centers? And I'll explain why I believe that the stipulation agreement does do that. And then finally, of course, there's the much talked about risk of stranded investments. And on that note, I'm going to again come back to this slide just to point out the amount of generation that we're going to have to build to serve that load is going to be enormous. Again, you're talking about nearly doubling the size of the utility. And that gray bar, that's been built up over however long Evergy's been in service. The bar on the left, we're talking about 5 years. Think about bringing on as much generation as we have now in just 5-year time. That's the issue that we're creating in front of us. And I also want to be clear, it's not just the OPC raising these concerns, right? It's not just John up here spitting from the cuff. The problems that we've identified are showing up across the news. For example, a Wall Street Journal article talking about job creation pointed out how John Johnson, the chief executive officer of Patmos Hosting, admitted that data centers have rightly earned a dismal reputation of creating the lowest number of jobs per square foot in their facilities. Patmos Hosting, by the way, is currently building a data center in Kansas City, Missouri. Another Wall Street article talks about how Chief Executive Jim Farley, that's of Ford, said that artificial intelligence is going to replace literally half of all white-collar workers in the US. So in addition to all the job creation we're talking about, there's a real risk that this could actually result in significant job loss. Another article from the Harvard Business Review talks about how investors are making a critical error around AI. They're treating AI companies like high-growth, asset-light software firms, when in reality they're capital-intense, high-cost, and infrastructure-heavy. AI-heavy tech stocks have traded at 20 to 40% premium, assuming future profits that haven't materialized. And Bain & Company's 6th annual Global Technology Report, they pointed out that even if US companies shifted all of their on-premise IT budgets to cloud and reinvested the savings from applying AI to sales, marketing, customer support, and R&D into capital spending on new data centers, the amount would still fall short of the revenue needed to fund the full investment, as AI's compute demand grows at more than twice the rate of Moore's law. We also, again, have concerns regarding the environmental impacts. This article from BBC describes one customer who said they can't drink the water after living next to a data center. And as Commissioner Kolkmar identified, data centers are water-intensive units, consuming millions of gallons a day, which can have dramatic impact. And the result of all this is that we're seeing significant pushback across the US and in Missouri. St. Charles County, for example, issued a ban on zoning for data centers. A similar ban has been proposed or is in place in Peculiar, Missouri. So across the state, in a variety of different locations, you're starting to see citizens come out against building these data centers. And all of that really doesn't begin to touch on what I consider the biggest problem, which is this concept of, can these things actually last? And this, again, this is the point that nobody here seems to be addressing. An MIT report in July of 2025 talked about how for about 95% of these organizations building or creating AI, they weren't getting any return, and that just 5% of integrated AI pilots were extracting millions in profits. Okay, good, Brian, thanks. Another article in the Wall Street Journal talked about how NVIDIA had dropped $100 billion to support OpenAI, even though it had struggled to chart a path to profitability, and was set to lose $44 billion through 2029, and that was before engaging in several pricey commitments. The Wall Street Journal last week, had an article about whether AI can ever pay off. And I want to quote this: "The money invested in AI infrastructure in 2023 and 2024 alone requires consumers and companies to buy roughly $800 billion in AI products over the life of these chips and data centers to produce a good investment return." And that's considering that the chips have a 3 to 5 year investment. The wave of AI infrastructure spending will require $2 trillion in annual AI revenue by 2030. And that is more than the combined 2024 revenue of Amazon, Apple, Alphabet, Microsoft, Meta, and NVIDIA, and more than 5 times the entire global subscription software market. And finally, you're starting to see multiple reports by major figureheads in this industry saying that we are in a bubble. In this case, it's Sam Altman, the CEO of OpenAI, who compared the existing AI marketplace to the dot-com bubble of the 1990s into early 2000s. And you can see at the bottom there, he's joined by many other industry experts. So why am I bringing all this up? Well, again, what's been missing from the conversation up to this point is that everybody seems to just be assuming that these data centers that we're building right now are going to be around forever and that they're going to make tons of profit. But the reality is that there is no guarantee that the generation we build now is going to last as long as the data centers are. And again, given their extreme power usage and the sheer amount of power they require, that gives us a massive risk for stranded investments. Also, as I said, the data centers are not guaranteed job creators. So all of that put together says there is a very real risk that data center boom might do more harm than good to Missouri ratepayers. And you'll note I stressed the word might. My goal is not to tell you that this is going to be a disaster. My goal is to point out the risks. There is absolutely a world where this all works wonderfully, where we cure cancer, crack fusion, and are all living on guaranteed income. But there's a risk that it doesn't. And that really brings us to the point I want to ask, does the OPC, are we just opposed to data centers? Are we just anti-data center? And the answer is an emphatic no. Despite everything I've said up to this point, we are okay with data centers coming to Missouri. We are happy, we are welcoming to them. But like I said, we are cognizant of the risk. And what we are asking for is simply that there are protections in place for existing customers. And more specifically, stronger protections, more realistic and better protections than what are currently being offered in the non-unanimous stipulation. And again, if you consider the risks that I pointed out, you consider all the issues, there is a good reason why the commission should look on this and say we need to err on the side of caution and have more protections than fewer. Now, really quick, I just want to say what I would ask this commission to not do, because there's a couple of things that I really want to make sure are not going to be the case. The first is I don't want this commission to just ignore the question of financial viability for data centers. And to point that out, I will tell you that in the past, we've had cases, for example, the Noranda, where this commission had to make a determination on the financial viability of an industry because they were getting a special rate treatment. And in that case, the commission heard from economists, from bankers, from investment firms, from metallurgists. They took in a huge amount of information to make a decision, is this a business that's going to last long enough to justify the investment, and should they get a special rate as a result? And I'm asking the commission to do the same here. Take a careful look at the actual industry and determine whether or not there are more risks involved. I also would ask this commission not to treat this as just another tariff. There's definitely been some discussion by other parties that say, well, it's just a tariff, we'll fix it in the future in a rate case. That's not a good idea here. Companies are making path-dependent decisions now. This is a major, major case, one that could define your legacy, and you should be treating it as such. And finally, we'd ask that you simply not rush into this decision. As I mentioned earlier, there is time. Staff pointed out how you have time. And staff's recommendation about opening up a workshop is a sound one, in my opinion. Use this opportunity, use the time that you have to really think this through carefully, to solicit additional feedback, and to involve yourselves in that discussion to try and reach the best possible answer. All right, I've talked a lot about what the commission shouldn't do. I've talked about the risks involved. Let me get really quick to what the OPC is asking of the commission. What should the commission do? Well, the first thing, of course, is that we would ask you to follow the legislative guidance. And I won't spend much time here because you've already heard it mentioned by multiple other parties. Section 393.130.7 includes the provision for electrical corporations to put forward schedules that should reasonably ensure such customers, and here we're talking about customers with 100 megawatt, rates will reflect the customer's representative share of the costs incurred to serve the customers and prevent other customer class rates from reflecting any unjust or unreasonable costs arising from service to such customers. Really fancy legalese, what does it actually mean? Prevent subsidies. Now that's my interpretation. Obviously other parties will have a different one, but I think you can summarize this really simply as just don't let non-large load customers subsidize large load customers. And that's truly the heart, again, of this case, in my opinion. The OPC's solution for achieving this, I have broken it down into what I consider to be 8 core requests. There are other aspects kind of filtered through the position statements and elsewhere, but these are the ones I want to focus on because they're the ones I consider the most important generally. And I'm going to walk through each of these. I'll only spend a slide or two on them. Should go relatively quick. The first, we're asking to modify accessibility requirements. And what that just means is who can take or who has to take under this service. We have 5 parts. The first is to increase the term of service to 20 years with a 5-year disconnection notice. Why am I asking for this? Again, these industries that are coming online, these customers are so big that they can justify their own generation. And the generation that we're going to build to serve these customers might last 30 to 60 years. If you're going to build generation to serve one customer, and that generation lasts 30 to 60 years, doesn't it make sense for you to have them commit to at least nearly as long? And again, to be clear, the OPC isn't asking for the full commitment. We're good with 20. And to compare that to what's in the stipulation, I believe the stipulation's at 12 years. So we're talking about an 8-year difference. It's not like we're way off here. The next is for a minimum bill to cover 90% of contract capacity. Again, if you're building generation to serve almost one customer, you want to make sure that their money is there to pay for that generation from that one customer. And again, we're fairly close to what the stipulation signed by the other parties was. In that case, I believe it was 80. I could be wrong. If someone is, I'm sure I'll be corrected. We're asking for 90. We're asking for no waiver from the collateral requirement. This basically just comes back to the idea that if one of these customers goes bankrupt, goes out of business, decides to leave the state, we want to make sure the money is there to pay the exit fee. We're afraid of somebody, maybe like Google, deciding to walk away and then saying, hey, it might be in our best interest just to fight this in court. Or a smaller data center, a smaller industry might end up going bankrupt, in which case, if they don't have the collateral, customers will be left holding the bag. So we are asking for no waiver. We're asking to decrease the applicable size to 25 megawatt capacity. This is in line with staff's recommendation, and it's really just there to make sure that we capture all the available customers. And then finally, we want the tracking of the termination fees in order to offset plan. Again, this is fairly straightforward. If a customer leaves and they pay a termination fee, but that termination fee is outside of a rate case, it won't be reflected in rates. It'll just be profit to the company. So in order to prevent that, you have to track the termination fee. And I want to point out that's actually a component of the stipulation. So on that point, we're aligned. I wanted to put that out there separately in case the commission did their own thing. Make sure you track the termination fees. And I want to throw out there also, none of these recommendations are out there. In fact, all of these recommendations come from various other states. We just pulled from other states and said, look, these are what other states have already agreed to. We think that they are what should apply here in Missouri. And if you want more information or detail on that, I encourage you to ask questions of Dr. Mark. He's the one who sort of developed these. All right, the next one is the FAC. And I want to be really clear here. If LLPS customers, the customers on this tariff, are included in Evergy's existing FAC, you will be creating a subsidy. And I'm going to walk through exactly how that works because it's important. If you assume the LLPS customer comes online after base rates are set in a rate case, which includes purchase power. Well, let's back up even further. In a rate case, we set the base fuel and purchase power costs that the company is going to assume. That includes all the energy that they're going to buy from the RTO market. So if there isn't an LLPS customer on the system yet, they won't be included in that. If they come on after the rates are set, then Evergy has to increase the amount it's buying off the market to serve just that customer. And because all the purchase power costs flow through the FAC, it means that all the money they spend buying energy for that one customer will flow through the FAC and be recovered by all customers. So again, this is exactly what's going to happen. If you include them in the existing FAC, they will be subsidizing, or rather, non-LLPS customers will be subsidizing LLPS customers. And this also will continue, by the way, even in the base rates once you've come in for a rate case, because at that point, the purchase power will just be flown into the base rates. The OPC has a very simple, easy solution to this. Just split the FAC. Have one FAC for non-LLPS customers and have a second FAC for LLPS customers. The brilliance of this is that nobody is worse off, right? The company is made whole in both cases. They both get their fuel and purchase power costs. Non-LLPS customers don't have to be worried about subsidizing LLPS. LLPS doesn't have to worry about their revenues being used to subsidize non-LLPS. If you just segregate them and keep them separate, the problem is solved. An easy solution. The next one I want to talk about is the tracking of revenues. And we've already heard from multiple people talk about positive regulatory lag. You've already heard this regulatory lag thing thrown around a lot. That's a mistake. The problem here is not just regulatory lag. It's that you are, again, creating a subsidy. And again, here's how this happens. If Evergy expects a large customer to come online, they're going to build generation to serve that customer, right? Because they have to have the generation to serve. If you put the generation in rates before the LLPS customers come online, and then you come in for a rate case, all of your other customers have to pay for that generation because it's in plant. I'll say that again slowly. If you build generation in anticipation of a large customer coming online and then have a rate case, all of your customers are paying for that generation. If the large customer then comes on after the rate case, those revenues are not included in rates. So they just go straight into the company's pocket. What you should do is track the revenues so that in the future you can give the money back to the non-LLPS customers in the form of a reduction to plant. Effectively, you're going to treat it like a loan from the non-LLPS customers to the LLPS customers. If you don't do that, you have created a subsidy because now the non-LLPS customers are paying for the plant. The revenue generated from the LLPS customer is going straight into the company's pocket. That's it. Again, simple solution to this problem. Order the revenues tracked. And this does not harm the large power customers at all because you're not changing what they pay. You're just tracking it from Evergy's perspective. So zero harm, no impact on them whatsoever. We're asking for no application of the Economic Development Rider. For those of you who aren't aware, the Economic Development Rider is a straight subsidy. It's a subsidy by design. It says basically, for a large customer, we're going to reduce the amount you have to pay, and everybody else has to make it up. We don't think that large customers, or rather these type of customers, should be able to use the Economic Development Rider because you have that statute that literally says, don't allow subsidies. And the Economic Development Rider itself says, hey, you can put in alternative terms and conditions. So it itself anticipates you don't have to apply this in every case. And we don't apply this in every case. Evergy's existing MKT and SIL tariffs already say you can't use the Economic Development Rider. So this is something that we've already done for other large customers. Now I want to touch on this because it gets a little weird. The company has put forward, in my understanding, they are allowing customers to take under the Economic Development Rider, but they've created a separate rider that's attempting to claw back that subsidy. In the initial filing, I believe this was the SSR, and then I believe in the stipulation they changed the name of it. And you might, if you ask them, they might say, yeah, we're trying to claw back that subsidy through a separate rider. And I posed you a simple question. Why on earth would you do it that way? Like, why would you give them a subsidy and then claw it back through a separate rider? Just don't give them access to the EDR. You can do it. You've already done it. It's legally allowed. Just don't allow them to use the EDR. It's that simple. Mandatory emergency curtailment feature. Okay, you all probably are aware SPP is having energy problems. It's having tight margins. It's having difficulty sourcing its energy. Evergy West in particular doesn't have generation capacity in its own to meet its demand. It has to buy with bilateral contracts, and they won't until 2030. Right now, because of a stipulation, we are doing what is called a value of lost load study. And what that value of lost load study says is basically there may be a point where it makes sense for a utility to not supply energy because it's more cost effective to not supply energy. And if that's what the study says, we think that's what should be applied. Basically, if there is a point where the utility says, hey, it's cheaper for us overall for everybody just to not supply you energy, that's what we're going to do. Now, if that sounds a little bit confusing, I strongly encourage you to ask Dr. Mark about this. He's the one who can provide all the details on this. He can explain better what that means. This kind of thing, it's already kind of anticipated in Texas, so it's not out there. Again, it's not out of the ordinary. We're asking for that to be applied here in Missouri. The pre-construction and post-construction analysis reporting metrics. Again, the OPC proposed 3 studies of power usage effectiveness, water usage effectiveness, and total harmonic distortion. These are really just about transparency. You know, to Commissioner Kolkmeyer's point earlier regarding how much water does Meta use, this is trying to make sure that that information is readily in front of the commission. It's basically just transparency, best practices, resource adequacy. Now, I do want to talk a little about that third one because that one's the unique one. That one's a little bit weird and interesting. So what is total harmonic distortion? Electric harmonics refer to unwanted voltage or current variations due to load variations. So like if you can imagine your light started to flicker, it's because some really big entity nearby was turning up or down their power and they were causing congestion on the line, for example. And we already have data right now, today, that shows that these power distortions are worse closer to data centers. Like we already have a report by Whisker Labs that shows that data centers are having a severe impact on the harmonics of nearby local residents. And those can have profound impacts. They increase your risk of house fires, they lower the life of your appliances that have to run on electricity. This is a major issue. And we would think that mitigating those should be costs borne by those causing them. Again, we're supporting cost causation. And I just want to bring this up because earlier it was mentioned that these issues that we're raising are behind the meter issues. That's not entirely true. This is very much an electric grid issue. This is a safety and reliability issue. And having the commission require the companies to put forward information on this is going to help make sure that we are providing safe and adequate service. Now the good news is that this is actually really easy to do. There's already companies like Ting who build little monitors that you can just plug into an outlet and they'll monitor the amount of variation in your home. And just to kind of show you what that looks like, this is a graph that shows harmonic variations in, I believe it's Virginia. And you can see sort of, this is a normal one along the bottom. The bad harmonics along the top is what it looks like nearer to a data center. So you can see they can have some pretty significant impacts on the grid. And we're asking for the commission at this stage just to require studies to help explain this, to help track this, and if necessary, that's going to allow us to make arguments in the future for how to correct it. The phase 2 study, I'm not going to spend much time on this. This is a really simple one. Effectively, there's a $200,000 deposit in place to help pay for interconnection agreements if a customer wants to come on. Evergy wants to waive that under certain circumstances. We think, you know, if a customer is going to join the grid of your size, you need to have enough skin in the game to show that you're going to actually take. I want to point out that, like, we're talking $200,000 on issues where people are dropping $1 billion on data centers. I genuinely don't know that this is like an issue holding up anything. And we don't have an objection if the company wants to waive it from their end, you know, put it on shareholders. They have every benefit or reason to because it's going to ultimately benefit them. So the short version is Evergy proposed it. They said they want to waive it under certain circumstances. We just say don't waive it. That's it. The last one I want to talk about is a community benefits program. Again, I think most of you are already aware that there is a reduction in the federal funding currently available to serve a lot of the programs that are aimed at helping ratepayers in Missouri that are on the lower end of the economic spectrum. I'm also fairly certain that in a week's time, when you all come to the Power Mo Affordability Summit, this issue is probably going to be brought up there as well. So we look at this and we say, hey, these data centers, they're posing a lot of risk to the system by being brought online, right? There's that risk of subsidization, there's that risk of stranded investment. In order to combat that risk, we think that these data centers should be contributing to a community benefits program that would help balance, right? It would help to give back to the community and justify their presence on the grid. And again, we believe this is consistent with Missouri law and is already included in other states such as Texas and Oregon. And I'll say for the third time, if you have any questions, if you want more details, I please strongly encourage you to ask our witness, Dr. Jeff Mark, to provide more details on this. Okay, so in my conclusion, if there was ever a time to be skeptical, Commission, this is it. This is the time where you really need to start thinking about, okay, how sure are we that these data centers are actually going to be able to justify the amount of investment they're calling for here in the state? You need to be asking that question. You know, can these things actually turn a profit? Can they survive for the 30, 60 years that we're anticipating to have generation online to serve them? We also need to say, you know, what are the rewards and what are the risks? Because you've heard a lot about the benefits from the various interveners, but you haven't heard much about the risks from anybody outside of OPC and staff. And again, that's a bit of a concern. And you need to be considering whether or not you should even be hearing this here. As I said, staff put forward the idea, let's consider making this a workshop. You should actually consider making this a workshop. There's no reason you can't just deny both tariffs and say, let's go handle this, and liberty for that matter, all at the same time in the same place. And that would allow you all to be more directly involved in the discussion, to ask questions directly and to better inform yourselves. And I think that that's a really, honestly, it's a smart idea, and I strongly recommend you to consider it. Last slide, what is the OPC asking? The OPC is asking for cost causation to be maintained. The OPC is asking that the commission follow its legislative guidance, that you avoid allowing the subsidies that are built into Evergy's and the rest of the party's stipulation from occurring. And on that point, again, in my opinion, this case is not so much a fact-based issue that we get with all the rate cases. In my opinion, this case really is a policy issue. And honestly, it's basically just one major policy issue, and that is, what is the state saying with regard to subsidizing data centers? Now, if you all believe that the policy of this state should be that we are going to subsidize data center build-out, then by all means, go with what Evergy and Ameren and all the other interveners have proposed, because that's what you're going to get. You're going to get a system that allows for non-large load customers to subsidize data center build-out. If alternatively you say, we welcome data centers, we're happy to have you here, but you have to pay your own way, that's when you should be going with the OPC, that's when you should be going with staff, because that's our end goal. Despite what anybody else has said, our goal here is simply to make sure that at the end of the day, data centers are paying for themselves, large load customers are paying for themselves, and that we are not getting cross-subsidization. And that, Commission, concludes my opening arguments.
First, I'd like to welcome Commissioner Coleman, who has gone from being virtual to being real. And then ask if there are any commission questions. Commissioner Kopmeyer.
Thank you, Judge. Who is Patmos hosting?
A company that builds data centers. Again, I would actually ask Dr. Jeff if there's more specific information than that on it.
And they currently have one in Kansas City?
Building, I believe, in the process of. I'm not sure what the time frame.
Yes. Okay.
It is cited in his testimony, I will point out, and I'll get you the citation later if you would like, but he references it in testimony.
Okay, thank you.
Commissioner Hahn?
Thank you, Mr. Kleiser, for your opening. I want to understand OPC's position clearly, and I may not, because OPC did not mention anything about staff's proposed tariff, and we have two very distinct choices. What I think I might have actually heard is that you may potentially, with protections that are added by the OPC, be closer to the stipulation and agreement. Is that the case, or are you still advocating for staff's proposed tariff plus your additional modifications?
Thank you, Commissioner. That's an exceptionally good question. It actually reminds me to address something that I wanted to touch on earlier. Specifically, I believe it was Mr. Lowry on behalf of Ameren got up here and told you it's a binary choice. You have to make a binary choice. And with all due respect, he is wrong. This is not a binary choice. I understand why you'd see it that way. You have one proposal, you have a second proposal, you'd think those are the only two options. But it's not at all the case. This commission has the power to pick and choose. It can look at what it likes from each of the two proposals and say, we like a little from column A, we like a little of column B. It has the ability to say, we like what you're going for, but we think there should be additional protections, like what the OPC is asking for. It has the power to say, we think this also needs to be put in there. To answer your question directly, I think that, yes, if we got additional protections on top of what on top of what the company is proposing, it would definitely get us much closer to something we'd be comfortable with. I also don't think that that was possible to achieve from a settlement position, because we're asking to prevent that subsidy, which is ultimately going to benefit the company bottom line. And I think that was probably an insurmountable hurdle. I can't speak for the company, obviously, but that's just my 2 cents on it. But at the end of the day, again, I think staff for the large part would honestly agree with me. You have a wide option on what to order here. You can absolutely simply say, this is the general parameters of what we want. Parties go back and work together on getting something together. You can say, we approve of, we like staff's overall design, but maybe not the minimum bill. That's a little bit confusing. Maybe we should adopt what the company had. Be creative. Explore options. Don't just stick yourself in the camp of thinking it has to be A or B. That is a mistake. You guys are smart enough to know that there are a multitude of ways to solve a problem. So I recommend that you consider it. Again, to answer your question directly, I think that if we got all the recommendations we put on top of what the company proposed, we'd be significantly closer. I would need the double check, but that's kind of where I'm at. Does that answer the question?
I think so. Thank you.
Any more commissioner questions? Okay, hearing none. Okay, we're gonna break for lunch. Before we do that, in a bit of magic, I have received staff's objections to Evergy's late filing while they were sitting here. It is. And OPC, if you'd like your objections to be part of the record, please have them here by the end of tomorrow.
Do I need a written objection, or can I make a standing objection to it?
You can make a standing objection to it.
I'm going to be completely honest with you, Your Honor. I would prefer to simply make a standing objection. I had not had an opportunity to review the testimony, and therefore I would object to its inclusion until given at least proper time to review it and potentially file responsive testimony if so warranted.
Actually, I'll allow both of you to have rebuttal testimony to the extra testimony that was filed during the testimony today.
And Judge, would you like that as pre-filed rebuttal or live on the stand rebuttal? And if pre-filed, when would you like for us to file that?
Well, I'm assuming Mr. Gunn is going to be the first witness, so live is what I'm guessing.
All right. Thank you, Judge.
All right.
I'm sorry, who made that objection? I can't see the video any longer for some reason.
Sorry, I think the objection was made by John Kleiser on behalf of OPC, but the second person talking who posed a question to the judge was Travis Pringle on behalf of staff.
And this is Travis Pringle, and that Mr. Kleiser is correct.
All right.
Okay.
Have a good lunch. We will come back here in an hour. Everyone, can you be back by 12:30? Thank you.
And Judge Walker, I'm sorry, one more clarifying question on staff's rebuttal. That is, staff, when our witnesses take the stand, we could ask them directly about Mr. Gunn's testimony and have them do the rebuttal live on the stand.
You can ask him directly about the rebuttal testimony that was filed by Evergy yesterday.
Yes, that is what I'm looking for, Judge Walker. Thank you.
Mic check, mic check. All viewers, you should see the intermission slide now, along with audio.
Back, we're gonna go back on the record.
Hold on one moment. Okay.
We will start testimony, and we will start with Mr. Gunn.
Thank you. Company calls Kevin Gunn. Your Honor, how do we do a swearing in?
I do that.
Great.
You raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may proceed.
Thank you.
Please state and spell your name for the record.
Kevin Gunn, Kevingunn.
By whom are you employed?
Evergy.
And what is your position there?
Currently, it's Vice President for Regulatory and Government Affairs.
Did you prepare direct, surrebuttal, and testimony in support of stipulation and agreement, in this case on behalf of Evergy, Missouri Metro and Evergy, Missouri West, which have been marked as Exhibits 100, 104, and 106?
I did.
Do you have any corrections to any of those three pieces of testimony?
I have no corrections, but the opinions would conform to supporting the stipulation and agreement that was filed last week.
Are the answers to those questions in that testimony true and correct today to the best of your knowledge and belief?
They are.
Your Honor, at this time, company would move to admit Exhibits 100, 104, and 106, please. Yes. The direct testimony of Kevin Gunn is Exhibit 100. The surrebuttal testimony of Kevin Gunn is Exhibit 104. And the testimony in support of stipulation and agreement, which was, Your Honor granted leave for that today, that's Exhibit 106. And the red weld that we just brought up to you are the hard copies of those.
Thank you so much.
Are they so admitted, Your Honor?
Yes, they are.
Your Honor?
You can't hear me?
No, I can hear you.
Okay.
I was just going to say, I appreciate that it has already been ruled on, but for the sake of the record, we renew our objection to the admission of the testimony supporting surrebuttal. Again, I appreciate it's already been ruled on.
So renewed.
And this is Travis Pringle on behalf of staff. Same statement, just standing on that objection from earlier.
So noted.
And that was to just Exhibit 106.
Mr. Kleiser, are you objecting to all exhibits or just 106?
No, just the 106.
At this time, Your Honor, I would tender the witness for bench questions and cross-examination.
All right, we're going to do cross-examination in the same order. So we'll begin with staff. Do you have any cross-examination?
Your Honor, the order of cross-examination differs based on the witness being crossed, and there's a specific list of order for each sponsoring party in the list of opening, the list of issues to filed.
Does anybody have that so I can see it?
Yes, we're pulling up right now, Judge.
Perfect.
Looks like Ameren, Missouri would be going first.
If we waived all parties, we waived cross-examination.
Except as part of the stipulation, the signatories have agreed to waive cross of the other signatories to the stipulation.
So we're right back to staff.
Yep, with that clarification, yeah, it is back at staff.
I meant to do that. Okay, staff, you may proceed.
Thank you, Judge. For the court reporter, this is Alexandra Klaus on behalf of staff. That is Alexandra. Last name is Klaus, Klaus. Good afternoon, Mr. Gunn. Had to check the time there. Were you here during the opening statements in this case?
I was.
Did you hear your counsel state something to the effect of, existing practice requires Evergy to reimburse customers for revenues in excess of its authorized rate of return?
I believe she said something to that effect, yes.
Do you agree with that statement?
If we're found to have been earning over our rate of return, the commission absolutely could order us to refund that.
So you do agree with that statement?
If the commission orders us to refund those revenues that are over our authorized rate of return, yes, I do.
Does the Kansas version of the FAC include a base amount in rates, or is that a fully separate rider?
I actually don't know the answer to that question. Witness Brad Lutz will probably be able to answer that question.
Thank you. Appreciate that direction. Are you aware of the MKT tariff?
I am.
We do have some copies we could distribute around. Would ask that administrative notice be taken of an officially published tariff, but just want to work through a couple of quick questions with you, so we'll get a copy up to you.
Sure.
Your Honor, may I approach?
Thanks.
And Mr. Gunn, if I could have you get to sheet 158.1. I believe that's on the second page. And I'm looking at paragraph 1, rate for energy service. Do you mind reading that for me pretty quick? Out loud, please.
Sure. Rate for energy service. An energy charge will be assessed based on the number of kilowatt hours consumed in any given hour multiplied by the appropriate cost to purchase energy from the Southwest Power Pool, SPP, for that hour. The company will specify the load node to be used in the special high load factor market rate contract described below, and that SPP node will be used to price the hourly energy and all applicable SPP charges. All elements included in the rate will be specified in the special high load factor market rate contract described below.
Thank you for that. Is that more like the staff structure or the stipulation in this case?
Well, it's more like the staff structure, but it's because the staff takes an incremental charge rather than a base rate tariff, which is what the LLPS is.
Thank you. Could I ask you to please go to paragraph 2? I'm looking at that captioned rate for capacity service. Could you please read that out loud?
Sure. The company will use good utility practice to identify lowest cost capacity options available at the time.
I'm sorry to interrupt, but Mr. Gunn, could you slow down for the court reporter a little bit? I think she's probably having a hard time.
Sure. The company will use good utility practice to identify lowest cost capacity options available at the time each customer requests service under this schedule. The approach to identify these options may include, but is not limited to, pricing for construction of physical resource to serve capacity or a distinct request for a proposal for firm capacity offered in the SPP market. Recognizing that capacity may not be obtained in small increments to match customer needs, all efforts will be made to maximize the benefit of the capacity options for the customer and the company. As needed, the rate for capacity may be inclusive of other capacity-based costs, including all applicable SPP charges, infrastructure investment recovery, or customer contributions. The rate and all elements included in the rate will be specified in the special high load factor market rate contract described below.
Thank you for that. Now, does that sound more like the staff structure or the stipulation in this case?
I mean, to me, it sounds more like the staff structure, but again, they're apples and oranges.
Thank you. Could I please ask you to look at paragraph 3, and this is captioned pricing for all other service. And then I will also ask you to go to paragraph 4, the last paragraph there. If we have some hiccups in working through that, I'll help you through that. May I ask you to please read aloud paragraph 3, pricing for all other service.
Judge, I'm sorry, this is Jackie Whipple for the company. I just want to object to relevance at this point.
Again, you just want me to read it?
Yes, please.
Pricing for customer charges and any other applicable charges applicable under this rate schedule are defined within the special high load factor market rate contract described below and shall include all applicable minimum demand and facility charges.
And then if we hop over to the next page, I'm looking at paragraph 4. And that last two sentences of paragraph 4, beginning with customer will not. May I ask you to read that aloud, please?
Customer will not be eligible to take service under this rate until the commission approves the individual special high load factor market rate contract. If the commission does not approve the individual special high load factor market rate contract, customer may take service under another rate schedule for which they qualify.
And finally on this round, does that sound more like staff structure or the stipulation in this case?
Again, I think the point is that we've developed a base load tariff, and this is not a base load tariff. This is a special incremental cost tariff. So it may sound a lot more like the staff structure, but that is another example of why staff structure doesn't work here, because we are creating a base load tariff.
Does the stipulation allow any customer to stay on the MKT tariff?
No.
Does the stipulation allow any customer to stay on the SIL tariff?
Yes. And I don't
Thank
think we
you.
have any customers on the MKT tariff, by the way.
Your SIR rebuttal and your supplemental testimony focus a good bit on the settlement agreement that was reached in Kansas. Would you agree with that?
Sir rebuttal, yes.
And the supplemental? The supplemental would be as to this stipulation.
Right, the supplemental in this case was designed to give the commission to know what was different between our filed case and what the stipulation and agreement was.
And you couldn't tell me if the FAC is different between Kansas and Missouri?
I don't know the answer to that question.
There were a couple of industries that I noted were represented in that Kansas stipulation, and more particularly, I'm thinking about Goodyear, and I'm thinking about an aerospace entity that was a signatory to that Kansas stipulation. Is that in line with your recollection and understanding?
I believe that's correct.
Were there any automotive customers that are in this room or in this docket in this case?
No.
Are there any aerospace customers?
No.
Do you recall in December 2024 or January 2025 meeting with staff and OPC regarding Evergy's proposed tariff filing?
Are you talking about one of the workshops that we held?
I don't know if I'd call it a workshop necessarily.
Where
but
we walked through our proposal with the parties?
we had some informal meetings, yeah.
That's correct, yes, we did.
And did staff provide a marked up red line of the tariff with comments after
did.
that meeting?
They did.
And did staff provide a summary of the concerns that it had with the proposed riders
In writing?
in writing?
I believe that's correct.
Do you have a copy of your testimony in support of the stipulation?
I do.
A little quicker than I am with it there. I've got a copy in front of me now, too. May I please ask you to go to what looks to be page 6?
Sure.
And I'm looking at lines 4 through 8. And the question is, when did the company initiate settlement discussions? And you state that we, the company, initiated settlement discussions in earnest after rebuttal testimony was filed and engaged through the course of multiple settlement discussions. All parties had an opportunity to participate in settlement discussions, either directly with the company or with the broad group of interveners at various points. Did I read that correctly?
You did.
How many total meetings were there between the time that rebuttal testimony was filed and the filing of the stipulation in this case?
Total meetings?
Total meetings.
Are you talking about settlement discussion meetings?
Yes.
I can't answer that question. There were multiple, both individual and as a group.
I'm sorry, what's a meeting? Can we get a little more specificity on what your question is?
A meeting, I guess it could be any group of people coming together to discuss settlement. I can change the wording of my question. How many settlement discussions did you have?
I personally had multiple discussions with all of the parties.
Who was invited to these discussions?
Various parties were invited to various meetings. Some were one-on-one and some were as a group.
Was staff invited to any group discussion?
Yeah, I actually offered, I spoke to staff before the formal settlement discussions on September 23rd. I spoke to them on September 19th and said, look, if we would love to have you participate, if you think that the fundamental differences that we have in our tariffs can be resolved. If not, there may not be an entire value to do it, but we would love to sit down with you. I had subsequent discussions with other individuals from staff and made the same offer, that if we felt that there was places where we could have agreement, we would love to sit down and talk to them. So they were absolutely invited to settlement discussions.
Thank you for that. And I think you referenced 2 dates. I just want to make sure I got those clearly. You said September 19th and September 23rd, correct?
September 19th was where my direct contact with staff. September 23rd was the formal settlement negotiations, and September 23rd was also the date that I spoke to some of staff's lawyers and reiterated the offer to participate in settlement discussions.
And at that time, was the stipulation agreed to in principle?
No.
When was the stipulation agreed to in principle?
When it was filed.
No further questions. Thank you for your time today, Mr. Gunn.
Sure.
Ms. Klaus, if you would like administrative notice taken of this special high-load factor market rate schedule, you need to offer it and we need to mark it.
Thank you, Judge. Yes, I would so request, and trying to find our exhibit list. I think we are at Staff Exhibit 208. Staff so offers Exhibit 208, Evergy's Schedule MKT Special High Load Factor Market Rate.
Are there any objections?
None.
Hearing none, it will be admitted.
Thank you.
All right, now we'll go to cross-examining. Well, maybe OPC would like a turn. Office of Public Counsel, would you like to go now, or would you like to wait till the end?
Yes, I would like to cross.
You want to go now instead of waiting till the end?
I think we are the ends.
Oh, yeah, you are the end.
That's okay. Good afternoon, Mr. Gunn.
Afternoon.
I have to say, I didn't have anything prepared, but the first Q&A that you got from staff has got me real curious, and I want to make sure I heard you right, because I think I misunderstood. If the commission sets Evergy's rates in a rate case, and then in a subsequent rate case determines that the company over-earned its ROE, is it your position that the commission can order revenues that were accumulated, that were recovered by the company between the rate cases returned as part of the subsequent rate case?
Object to the extent that it's asked and answered, and also to the extent that it asks for a legal conclusion.
Overruled.
It's my belief that the commission can order refunds under certain conditions.
And that's as part of a general rate proceeding?
I think as a general rate proceeding, I believe they would have that authority.
Okay, I guess I didn't mishear. That was all my questions.
Are there any questions by the commission? Chair Hahn?
Good afternoon, Mr.
Afternoon.
Gunn. I'm going to follow on the questioning from Ms. Klaus. In the opening from Ms. Whipple, in the PowerPoint presentation, there is a bullet point that says, staff's tariff proposal, by not participating substantively in settlement discussions, staff is effectively forcing the commission to choose between Evergy's tariff and staff's proposed tariff. Can you further elaborate on what is meant by that bullet point?
Look, I think we came to the conclusion that staff's proposal is irreconcilable with ours. It's not a pick and choose, they're just fundamentally different approaches. And because those that have fundamentally different approaches, it's very difficult to actually move and come to an agreement. Almost impossible. I've described it as kind of like we're on two different playing fields, and until we could come to an agreement that we were on one single playing field, it was difficult to do that. But I disagree with OPC's opening, where you have the ability to pick and choose, because all of these provisions work in concert. All of the protections, all of the riders, all of the mechanisms that are involved kind of work in concert. And if you pull one out and push one in, it could cause almost fatal flaws in those documents. So we do believe that it really is a binary choice between what staff has proposed and what the other parties through their global stipulation and agreement have proposed.
Okay, thank you. Ms. Whipple brought it up in opening. Staff, I think, has brought it up, as has OPC, on the FAC. Can you please talk about, OPC proposes changing the FAC potentially in this case. Can you talk about that, if it could be changed in this case, if it cannot be? I'm sure there is significant discussion about it. If you would just kind of give me your thoughts.
Sure, and I'll do it at a high level. I think Brad Lutz would be another person to go into more detail on this. But we don't believe that you need to change the FAC with this process, because we are not carving out LLPS of this, and we think that there can be real benefits to customers. There are a lot of circumstances, I think, that have to happen for the FAC to not operate the way it's supposed to under this. We believe that there are circumstances under which initially, because you're projecting some of the accumulation periods, use projected load, that you actually could see a reduction in some of the rates for existing customers at the beginning part of it. But overall, because of the way that we've incorporated the LLPS customers into the process, we just fundamentally don't believe that we have to do fundamental changes to the FAC.
Thank you. In Mr. Bush's rebuttal, he argues that Evergy hasn't provided evidence of your large load customer pipeline in detail. Can you speak to what Evergy has or has not provided and why?
Well, obviously, most of this is incredibly commercially sensitive information, both for Evergy as well as for the customers that are seeking service. So we have tried through, whether it's our earnings call where we're presenting this to that are governed by SEC rules, or whether it's our other presentations, our large load filings, we have tried to demonstrate without specifically naming who the customers are, what our realistic pipeline is, what our realistic queue is. And I think that's why you see in the chart that I put on that we do place different levels of advancement of how far those discussions are on, so that we don't overestimate the potential customers that are coming, but also not to underestimate that as well. Do we believe that every single one of those projects is going to come to fruition? No, we do not, but they are in our active queue, and so we are in some sort of discussion with those customers. So, but we can't specify for, again, commercially sensitive reasons or because we're under non-disclosure agreements and other things that would say specifically what customer, what's their name is, what their load ramp is, what size of their facility, where it's going to be located. All of that, and some of that is not necessarily dependent on us. Some of that's dependent on negotiations that the customer might be having with the county or with other entities. So we have tried to our earnest to demonstrate that this is real. We can't make false statements in our earnings call. We can't make false statements to the SEC. Tried to demonstrate that this is real, but we also recognize that there is not all of these projects are in various stages and they're not all going to pan out.
Thank you. One of the items that staff brought up in their opening is that there's been a lack of transparency, which could have been based on some of the testimony that was filed, and that Evergy does not agree that there should be a form service agreement, but Ameren has provided an example service agreement. There's been no examples from Evergy. Can you expand on that as to why that's the case?
We have a very diverse customer base that would fall not only into this, but other certain tariffs that we have. And I think that having a form does not grant us the flexibility to deal with the customers and their particular abilities as well as their and capabilities. So having a form approved seems to potentially hamper our ability to negotiate with these clients and demonstrate them. I would say that those ESAs are governed by the four corners of the tariff. We cannot do something in that ESA that is not allowed by the tariff or isn't authorized by the tariff. So to say that those ESAs can operate outside of the tariff, I don't think is an accurate statement. However, I mean, those ESAs can be provided to the commission, but I think it's important to realize that a lot of that, what's contained in the ESA are commercial operation utility management terms and conditions, which is really in the province of the utility to be able to manage as long as it's covered by the four corners of the tariff, which it would be.
Thank you. A large part of staff's case today and the testimony is a real concern over positive regulatory lag, one direction regulatory lag. I know that this was dealt with in Kansas in a rate case that had an earnings sharing mechanism. It was dealt with in a rate case and not in a tariff case. In your view, is that something that could be implemented in an Evergy rate case in Missouri to match something similar in Kansas to mitigate staff's concern on positive regulatory lag?
I think the commission would have the power to order some sort of similar mechanism. I would remind the commission that the mechanism in Kansas assumed that you were earning your authorized ROE, and I think that that's not the environment that we're in right now. And so I think that's something to keep in mind. But the commission would absolutely have the authority in a general rate case, and I think that would be the appropriate place to do it, to deal with a mechanism if it so chose to do that.
Okay. One other item relating to Kansas, the Kansas stipend agreement had a collateral change where collateral could be reduced at 5 years. In this stipend agreement, it's 3. Why? Why the difference?
I think what that 3 years is that there would be no collateral reduction after 3 years. I think for certain customers, we would review that. I think it says we'll review it on an annual basis after that 3 years to determine whether a collateral reduction is necessary. The size and scope of some of these projects, and if we have good payment history for 3 years, and I think the stipulation agreement also has certain metrics that we would take into account. We're not obligated to do that, but we thought that with especially with certain customers that have demonstrated creditworthiness, that have fulfilled all of the requirements, that 3 years was enough for us to be comfortable that we would be able to take a good look at it. That would give us enough history to be able to start taking a look at it on a going forward basis on an annual basis. I don't know that there's a lot of magic between 3 and 5, and I think that that collateral reduction would be customer specific, especially those customers that have demonstrated high creditworthiness, good payment history, already demonstrated examples of fulfilling their obligations.
Yeah, it just seems like there is a lot of parity between the two proposals. And for that sake, I was curious if there was a particular reason why collateral could be reduced after 3 years in Missouri compared to 5 years in Kansas.
I would tell you that it was a negotiated settlement, and some of the parties felt that it was appropriate, and we felt like it was fine to move to that.
Sorry, I have more. I have more, but I have to find my notes.
No problem.
On the riders and the Stipend agreement, I'm trying to think through the Green Solution Connections program, which is on page 19 of the stipulation.
I'm looking at it now.
I'm kind of confused about how the program or the rider would operate, because it says it gives subscribers an opportunity to subscribe to future renewable energy attributes associated with new company-owned wind or solar acquired through the IRP process that are not needed to meet renewable compliance targets or requirements. Can you talk me through the aim of that program? I assume it's based on corporate goals. If subscribers would pay for the entire cost of those projects?
I'll answer what I can. Mr. Lutz might be a better person to walk you through this, but I believe what this allows to do is corporate policies, if they want to give them the flexibility to meet their corporate sustainability goals, not mandates or anything. So if we're not using them to fulfill whatever requirements we have in the state of Missouri, we can future sell those attributes to those companies. They could purchase them and use them to fulfill their corporate sustainability goals, but that would be subject to check with
Okay.
Mr. Lutz.
Okay, I might ask him. Thank you. On the subject of EDR, it's been brought up, I think, by both staff and OPC, that if you're eligible for LLPS, you should not be eligible for EDR. My reading of EDR is that you are eligible. It's an automatic under statute, and that you are trying to reconcile that with the LLPS and trying to then, there's an additional rider that was added to try to make up the difference if you're not covering your full cost of service. Is that how Evergy reads it? Is there any way using an EDR and LLPS that the large load customer would not cover their full cost of service?
So that was actually our reading. We believe that EDR is a mandatory statute, and even though there are some qualifiers that we would be forced to offer that to an otherwise eligible company. So we agree with that reading. We believe that because of the way that the mechanism and the demand charge is set up, that will get that 120% threshold, which means the EDR would not be available. So, but the rider is designed that if that threshold was not met, that we would be able to make up that, and so that customer would not get the benefit of that EDR discount. That absolutely was the design of that.
Thank you. I'm looking through my list, and I think it may start with other witnesses, other Evergy witnesses. I don't want it. Thank you. There were certain studies that OPC proposed on harmonic distortion, water usage, and power usage effectiveness. Can you talk me through Evergy's position on conducting those studies, if they would be well conducted here or through the environmental regulator, or what your position is on those particular studies?
So fundamentally, that's not information that we can provide. It's more of customer facing, and that for part of that reason, we don't think it's appropriate for it to be contained in the tariff. There are a lot of reporting that these customers do. I think it was mentioned in the opening. And we think that much of the information that OPC is looking for can be provided through reports that are already provided by the customers, and we certainly encourage the customers and OPC to work through those. We just don't think that it's appropriate for the tariffs. The harmonics issue, there is some question about whether or not data centers really are. There's some dispute out there in the engineering world, and I'm not an electrical engineer, about whether data centers are actually the cause of those voltage irregularities. But from our extent, we would be required to follow the power quality SPP interconnection rules that we think take care of that. If the parties agree that studies should be done, it could be outside of this tariff, and could be done on a voluntary basis or through another agreement. But fundamentally, they're not really company. For example, we don't have the ability to talk about water usage, for example. We don't regulate it, we don't provide it, we don't have the ability to do that. So, I mean, we're happy to discuss what aspects that we can provide, but again, we think it's not as appropriate to put in the tariff moving forward.
One of OPC's other requests was a pre-construction analysis and post-construction reporting metrics. I'm assuming of large load power service customers. Can you tell, is that something that could be included in the annual report that is part of the stipulation and agreement?
I think the annual reports, part of the reason we wrote in the stipulation agreement that the annual reports would be negotiated is so we could work out some of those issues. Again, that would be a negotiated report that we would put in. We included the two kind of mandatory items that we have control over, and which was the number of customers and I think one other provision that we would be able to provide. But part of the reason we wrote it that way was to allow the parties to figure out what we thought would be helpful, what was already being reported, what we didn't want to duplicate reports, and what could be contained in those annual reports. But I think those are negotiable among the parties or the stakeholders if the commission were to order that as part of the tariff.
Okay. I think that's all I have.
Great.
Thank you.
Thanks.
Thank you. Just one. I don't think I don't recall the chair talking about this, but One of the things that OPC brought up was the $200,000 deposit, and that Evergy wants to waive the fee. And one of the comments, if I remember what OPC stated, was that with the amount, I'm paraphrasing here, with the amount of dollars coming into, or what would be a result of prospective LLPS customers, that this amount seems pretty low. I wanted to get a perspective from Evergy about that deposit amount.
Sure. First of all, we did kind of a survey among other utilities, and we had initially thought it was lower, and that perspective was from the other utilities were like, no, it needs to be higher. And it's not just 200,000. We can actually request more if those costs go up. So if we use up that $200,000 and we continue to use it, we reserve the right to again go back and charge them more for that. So it's not just 200 and you're done if it goes over that. We also have, quite frankly, a refund provision that if for whatever reason you decide to drop out of that project, we can refund that money. The waiver provision really is designed to give us the flexibility if there is a particular community interest project that comes in. If, for example, the state were to come to us and say, we are in a competitive process and we want to see if you can, and this is just extra money that makes our program not as competitive as it would be. So it's not designed just as kind of say, hey, we don't want your money, because that money helps offset the cost for the studies that we're providing and offset Evergy labor. It's really designed for those community interest projects that there may be special circumstances, whether it's speed, competitiveness, or a particular project that would somehow be an impediment, that we would be able to waive it under those conditions. But and we can get you the information, but I think that almost everyone in the queue has paid that deposit.
Thank you, Judge. That's all.
Okay, we'll go to recross.
Just one moment, please, Judge. No recross, thank you.
Office of Public Counsel, do you have recross?
Just briefly. In part of the discussions with the chair, you had talked about whether or not the project analysis, the reporting, is something that could be provided. And I believe that your response was effectively that the company cannot provide that. Do you recall that discussion?
Yes, I do.
Okay. You would agree with me that the tariff requires several things from the prospective LLPS customer, correct?
Sure.
For example, providing collateral, right?
Yes.
It would be entirely reasonable for the tariff to say, as a requirement of receiving service, you must provide a study if the commission found such a study was worthwhile. Wouldn't you agree?
I would agree with one clarification. I think there's a lot of information out there that is already being provided in the manner in which it's being provided that people are comfortable with. So I think that that's part of the reason why you have the ability to negotiate that in order not to duplicate and in order to make sure that it's all done correctly. If the commission orders us to do that, obviously, and puts it in a tariff, obviously, we would comply with that.
If it's already out there, what's the risk of just allowing it to be put in front of the commission so people don't have to go looking for it?
It's not my issue, John. It's the customers have commercial sensitivity issues. There are site. I don't know all the reasons. What I do know is that it's not the company's issues. It's the customers' issues that we have to be respectful for.
Well, I mean, you just said that it's all publicly available. That's part of the reason why.
No, I didn't. What I said is there may be certain publicly available reports and information that they provide already that may be a portion of that, and we don't want to duplicate that. I did not say that all the information was publicly available, or that all the information was not, or that some of the information was not commercially sensitive, which it could be.
And they could file that in front of the commission under confidentiality, correct?
That's a potential possible outcome.
So if there's information out there that isn't publicly available, it would make sense for the commission to potentially require that to be provided as part of the application process, subject to confidentiality.
The commission can always order that in a tariff.
All right. Let's move on. Regarding the economic development rider, I believe there was an exhibit marked previously. You know what, actually, I'm going to skip past that for just a moment. I want to go back to the FAC. In the discussions that you had with the chair regarding the FAC, I believe that you sort of expressed Evergy's opinion that you don't think the FAC needs to be changed. Do you recall that discussion?
I do.
And I understand that that's your position. I assume that you're at least familiar with the position put forward by OPC witness Ms. Mantle.
I am.
Right, and again, her position effectively is that it should be changed for the reasons that she lays out in there. You agree with me on that?
I agree that's her position, yes.
Of course. My question really is, would Evergy be willing to consider? I mean, you testified effectively that you don't think it needs to. Would you be willing to consider changing the FAC in accordance with what the OPC has suggested?
I don't know the answer to that question.
All right, fair enough. One last second. It's up to you. I don't have any further questions. Thank you.
Your stipulation allows for recross from the parties, so I will call them, and if you have recross. Ameren?
No questions?
She gets redirect.
I think all of the stipulating parties have waived any kind of cross. Do you mean in response to bench questions, Your Honor?
I do.
Okay.
Is there any redirect from, do you have any redirect?
Yes.
All right. Ameren doesn't have anything. Google? Data Center Coalition?
No recross from DCC. Thank you, Your Honor.
Velvet Tech Services? Sierra Club?
Not from Sierra Club, thank you.
Renew Missouri? Okay, Evergy?
Thank you. Mr. Gunn, do you recall a conversation, I think with the chair and also with OPC about project level detail and what can and what has not been provided?
Yes.
Is this a question for you or maybe for Jason Clint? Are you aware that whether the company provided a DR response in this case with more project level detail than the SEC earnings call information?
It's probably a question for Jason, but would not be surprised.
You also had a conversation with the chair about the Kansas sharing mechanism. Do you recall that?
I do.
Was that sharing mechanism part of a negotiated settlement with the parties in the KCC proceeding?
It was.
And it's not currently a KCC order, is it?
Separate and apart from the negotiated settlement?
That's right.
That's correct.
But that's on the docket, isn't it? For it
That's-
to become ordered, isn't it?
Well, the KCC, I could be wrong, subject to check. I thought the KCC approved the rate case settlement last week, but I could be incorrect on that.
Okay. In conversations about the FAC, do you know if there's a statutory provision that may limit the ability to change the FAC mechanism outside of a general rate case?
There might be. Again, Mr. Lutz is much more familiar with the mechanics of the FAC than I am.
And if there is such a statutory restriction, then it can't be changed in this tariff proceeding.
I'm going to object on the basis that he just said it should go to a different witness.
Well, I didn't finish my question. If there was such a restriction, would it be your understanding that it couldn't be changed in this proceeding?
My objection still stands. He literally just testified this should be asked to a different witness.
I'm going to overrule it. He can give his opinion.
I agree.
There were several questions from staff regarding settlement discussions among the parties in this case while protecting settlement privilege. Do you still stand behind the sentence on page 6 of your Exhibit 106 testimony? All parties had an opportunity to participate in settlement discussions either directly with the company or with the broad group of interveners at various points?
Let me say that part of my job is to reach out to the stakeholders in various proceedings in front of the Missouri Commission and try to reach a consensus. And I certainly did that in this case, to each one of the parties separately, definitely separately, and at different stages, but yes.
And of course, that would have included staff and OPC.
It absolutely did.
You also had some questions about a statement in my opening presentation. Do you recall that I said, if the company earns revenue above this offset, the Commission's traditional rate-making processes will still apply, requiring Evergy to reimburse customers in the event it exceeds its authorized rate of return?
Yes.
Now, traditional rate-making processes, are you aware that that could include the company filing surveillance reports to evaluate over-earnings?
Yes.
And could other parties file an over-earnings complaint if there was a surveillance report indicating an over-earnings?
Absolutely.
So in response to questions you received from OPC and staff, you certainly weren't advocating for any retroactive rate making or the like, were you?
No.
Yeah, I'm going to object again. I believe I believe the witness is actually being solicited to change their testimony at this point. They said very clearly what they said on the record.
What is the objection?
That you're soliciting that he change his testimony at this point.
I disagree, Your Honor. Oh, leading? All right. Do you advocate for retroactive rate making, Mr. Gunn?
No.
I just want to say real quick, I think the judge's mic is off.
Sorry.
Okay, thank you. I think you said sustained and then.
I said sustained, and then I said leading.
Okay, thank you. You can go ahead.
Did the court reporter hear the answer to the last question?
I think you were. Let's see. I think you were in the middle of your question.
Okay.
He can go ahead and answer again, if he would.
Mr. Gunn, do you advocate for retroactive rate making?
No.
Thank you. No further questions at this time.
Does any party have an objection to Mr. Gunn being excused? Oh, Mr. Gunn, you may be excused.
Thank you.
I have on my list, the next witness is Jason Clint, who is adopting the testimony of Jeff Martin. You raise your right hand. You promise to tell the truth, nothing but the truth, so help you God.
So help me God.
Please state your name.
Jason Clint, Klindt.
By whom are you employed?
Evergy.
What is your position there?
I'm the Senior Director of External Affairs.
Are you adopting Jeff Martin's direct testimony in this case on behalf, excuse me, of Evergy, Missouri Metro and Evergy, Missouri West, which has been marked as Exhibit 102?
I am, and I'd personally like to thank Jeff Martin for this opportunity.
Do you have any corrections to the adopted direct testimony?
No.
If I were to ask you these questions, would your answers be the same set forth in Exhibit 102?
Yes.
Your Honor, I move to admit Exhibit 102, the direct testimony of Jeff Martin.
So are there any objections? Hearing none, the testimony will be admitted.
Your Honor, I tender the witness for cross-examination.
Okay, cross-examination, staff.
And for the record, I don't think I spelled my name yet for the court reporter, but this is Travis Pringle, Travispringle, on behalf of staff, and staff has no questions for Mr. Clint at this time. Thank you, Judge.
Office of Public Counsel,
No questions, thank you.
are there any questions from the commissioners? Chair Hahn.
Good afternoon.
Good afternoon, Chair.
I think you might have been in the room earlier when I asked Mr. Gunn about transparency around economic development projects. I think there was also discussion that you potentially have provided a response in a DR to staff about potential projects or queue. Can you talk about that DR and what you provided to staff?
Absolutely, yes. What I provided was a list of all the projects that we had received at Evergy and where they were at current status, what their load ramp was, and I think I even provided what the jurisdiction that they were located in by county. We did the project, rather than provide the economic development project name, we just gave it a project number because that name can sometimes be out in the public and can jeopardize a project. So we took the extra step of calling it Project 1 through whatever it was. So we did provide that information that is exactly what we have, which includes the load, the jurisdiction, the year that they're starting, and what their ramp looks like.
Okay, and I'm assuming that's not in their record, so I wouldn't have the ability to access that, or do I?
Your Honor, we can provide that
Thank you.
during the break.
I'm not sure who said that.
Oh, my name is Chandler Hyatt, Chandler, last name Hiatt. Thank you.
Thank you.
Do you think that that request and using those more confidential, numbers instead of project names, is that something that could be incorporated into your company's annual report?
I would assume that it is something that could be, would need some definition around what you're, exactly what you're looking for, but yes, it's something that we can make and add if that's the commission's will.
Thank you.
Mr. Hyatt, in order for the commission to consider this evidence, it must be authenticated by a witness and offered. Just a note. Are there any more commission questions? Okay, hearing none. Okay, are there any cross-examination questions on the basis of commissioner questions? Ameren, Missouri.
No questions.
Google.
No questions. Thank you.
The Data Center Coalition.
No questions. Thank you.
Velvet Tech Services. Sierra Club.
No questions, thank you.
Renew Missouri. Staff of the Missouri Public Service Commission.
Yes, Judge, thank you. Good afternoon, Mr. Clint.
Good afternoon.
And do you recall discussing a potential DR response with Chair Hahn earlier?
Moments ago, yes.
And I just want to know, have you had the chance to review the testimony of staff witness James Bush?
No.
Does the DR number 92 sound about right to the DR that you were discussing with Chair Hahn?
I would love to tell you that my memory is that good, but I just swore that I would tell the whole truth, and it's not that good.
Well, to try to get around, because it is a confidential DR, the substance of that response did have to do with large load project ramp details, correct?
What I provided was essentially an Excel document that had the numbers project 1, project 2. It showed load ramp, showed jurisdiction. Whether that's DR 92 or otherwise, I could not tell you.
That is what I'm looking at with Appendix 2, Schedule 5 to James Bush's confidential testimony. So I think you've confirmed it for me, sir.
Thank you.
Thank you. And sorry, forgot about that part. No further questions, Judge.
Office of Public Counsel.
I have no questions.
redirect by Evergy.
Mr. Clint, in response to DR 92, did you sign a verification?
I don't remember.
Would you be able to provide written authentication of the DR in a later response?
Yes.
No further questions, Your Honor. Thank you.
Can I just, is the testimony that the DR in question is attached to Mr. Bush's testimony? Is that?
Yes, the DR, I believe that Chair Hahn and Mr. Clint were discussing, it is an appendix under Mr. Bush's testimony.
Can I solicit that the parties might later be able to confirm that, and if necessary, that would relieve the need to recall Mr. Clinton and submit the evidence? I mean, if it's already in the record, I think that most parties would be okay with just leaving it that be.
Is that fine with Evergy, since they're the one that wants to produce the document?
Yes, that is fine, Your Honor.
All right, we'll do that. Are there any objections to Mr. Clint being excused? Hearing none, you may be excused. The next witness on the list is Derek Brown.
Yeah, the company calls Derek Brown. And for the court reporter, my name is Cole Bailey, Colebailey.
Direct examination, oh, well, let's swear Mr. Brown in. I mean, he looks pretty honest, but.
Thank you.
Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Evergy, you may proceed.
Thank you, Your Honor. Mr. Brown, can you please state your name and position?
Yes, it's Derek Brown, Derekbrown. I'm the Director of Large Customer Strategy and Planning at Evergy.
And are you the same Derek Brown that caused to be filed 14 pages of rebuttal testimony on September 12th?
Yes.
And if I were to ask you those same questions today, would your answers be the same or substantially the same?
Yes.
I tender the witness for cross-examination, Your Honor.
All right, staff, do you have any cross-examination?
Your Honor, I want to offer up the testimony for Exhibit 103, the rebuttal of Derek Brown.
Are there any objections to the admission of Mr. Brown's testimony? Hearing none, Exhibit 103 will be admitted. Mr. Pringle, you may proceed.
Thank you, Judge. Good afternoon, Mr. Brown.
Good afternoon.
Do you have a copy of your rebuttal up there with you? I think it's Exhibit 103.
I do.
Could you please turn to page 2, lines 12 to 14? Let me know when you're there.
Yes.
And do you see where you state you are familiar with the tariff requirements of the, quote, National Energy Reliability Corporation, NERC, end quote?
Yes, that's correct.
And just to clarify, is that reference to NERC, is that the same as the North American Electric Reliability Corporation?
Yes, that's correct.
And you are familiar with the North American Electric Reliability Corporation?
That's correct.
Are you aware of the North American Electric Reliability Corporation, or NERC, disseminating information to the industry through email-based NERC alerts?
Yes.
And in certain situations, NERC requires acknowledgement of receipt of its alerts, correct?
That's my understanding, yes.
Is Evergy, Inc. a registered entity with NERC?
That's my understanding, yes, we are.
And do you understand that registered entities are registered with NERC under specific functions?
That's correct.
Is Evergy, Inc. registered with NERC as a transmission owner, transmission operator, transmission planner, and resource planner, among other functions?
I'm aware, yes, of several of those that you listed.
All right, thank you, Mr. Brown. Judge, at this time, I'd like to mark a staff exhibit. I guess this would be Staff Exhibit 209, and ask the witness a couple questions about it. My colleague, Ms. Klaus, has copies for the room This is the North American Electric Reliability Corporation's Industry Recommendation, Large Load Interconnection Study, Commissioning and Operations, and the initial distribution date on this exhibit is September 9th, 2025.
Okay, this exhibit will be marked 209. Are there any objections to its admission? Hearing none, the exhibit will be admitted.
I'm going to object, Your Honor. We need to, for this to be on, our witness has never seen this or read it. It appears to be 15 pages, 16 pages. We're going to need to lay a foundation.
As the witness has previously said, he is familiar with NERC, the functions of NERC, and the alerts that go out via NERC. This ties in with all of that. I believe the foundation has been laid, Judge, and also permission to approach the witness to hand him a copy of this as well.
Please do, and while you're at it, why don't you ask him if he's read it?
And Mr. Brown, have you seen this NERC alert before?
I saw that it was published, if you're referring to this industry recommendation.
Yes.
And however, not read it in detail.
All right, well, really the emphasis that I'm looking at will have to do with page 1 and page 8. If you'd like to take a moment to review those pages, I'm happy to wait.
I'm going to hold the admission of the exhibit until a proper foundation has been laid for it. It doesn't appear this witness can do that.
Well, Mr. Brown, you are aware of the North American Electric Reliability Corporation, correct?
That's correct. However, I haven't read this.
Have you had any interaction with NERC alerts in the past?
In the past, yes, but not on this particular topic.
So what is the purpose of a NERC alert?
Generally speaking, it is when, and again, this is summarizing my own experiences, that it's when there's a sufficient level of cause to for NERC to reach out to particular registered entities to take some kind of action. I mean, that's broadly speaking what it's used for.
And if a registered entity receives a NERC alert, do they have to respond to it?
My understanding is generally yes.
So if this is a NERC alert and Evergy is a registered entity with NERC, this is a alert that Evergy would have to respond to.
That is correct.
And what role do you play in guiding Evergy's response to NERC alerts?
So depending on the topic, broadly speaking, if I am a subject matter expert in the particular topic of the NERC alert, then I will help guide or facilitate where to get the information, if it is an information request, in order to submit it to NERC.
And your testimony in this matter was providing support for Evergy's large load power service tariffs?
That's correct.
And again, this study is titled Large Load Interconnection Study, Commissioning and Operations, correct?
That is what I see the title is, yep.
Well, Judge, I would move once again to enter this exhibit on the record.
I'm going to object, renew the objection, no foundation.
I agree with the objection. Do you have a witness later that you can admit this document, who can authenticate it?
We have staff witnesses who have reviewed this document as well due to the NERC alerts going out to, well, staff also receives these alerts and reviews them.
Okay, you may ask questions about this, and we'll admit it as an exhibit when you produce a witness who has seen it and is familiar with it.
All right, thank you very much, Judge.
Okay.
All right, so Mr. Brown, looking at page 1 of this alert. And I'm looking at the second full paragraph in red. Do you see that?
Yes.
And am I correct that this states that NERC...
Objection, Your Honor. Did you say he could ask my witness these questions before authenticating it?
Absolutely.
Okay.
It states that NERC regional entities and NERC registered entities have analyzed a series of disturbances that occurred on the bulk power system, shortened as BPS, resulting in widespread and unexpected customer-initiated load reduction of large loads. Did I read that correctly?
Yes.
And that it further states disturbances, first, it further states, quote, disturbances involved multiple events during which 1,000 plus megawatts of unexpected large loads output reduction occurred, and the increase of large load-related events coincide with an increase in large load penetration across the bulk power system. Did I read that correctly?
Yes.
And further on this page, I think now I'm looking at the third paragraph in red. It also states, to better understand the reliability impacts of emerging large loads on the BPS, NERC established the Large Loads Task Force in August 2024, and in July 2025, NERC published a white paper titled Characteristics and Risks of Emerging Large Loads. Do you see that?
I do.
Would you agree this alert includes certain recommendations for NERC players based on their functions?
Yeah, I haven't seen the details, so I don't know if I can confirm that without looking at it.
Would it be common practice for such alerts to describe multiple functions?
Elaborate on multiple functions again.
For example, it would go ahead and discuss the functions as a transmission owner, a resource planner, etc.
Yes, so yeah, as far as the NERC registered entity aspect, yes.
All right, and now I'm looking at page 8 of this document. And just let me know when you're there.
I'm there.
And you see how it says reporting instructions.
Yes.
And I think earlier we did discuss, I think you said you were aware of this alert when it was issued on September 9th, correct?
Yes.
And has Evergy responded to this alert yet?
To my knowledge, we have not.
Would Evergy be willing to provide its responses to this alert to the commission?
Subject to it being relevant to this proceeding, so ordered, I would think so.
All right, well, Mr. Brown, that is all I have for you on this document. Thank you, sir.
Your Honor.
Do you have any further questions, Mr. Pringle?
Nothing further from staff this time, Judge Walker. Thank you for your time, Mr. Brown.
The Office of Public Counsel?
No questions, thank you.
Questions from the commissioners? Chair Hahn?
Good afternoon, Mr. Brown.
Good afternoon, Chair.
I'm going to ask you about two different items because of your familiarity with SPP. The first item is staff has proposed that each LLPS customer be on their own pricing node. And the response to that is that it would result in highly volatile rates. Can you explain that response? How that would work in practice and the potential impacts of doing that?
Sure. Yeah, as kind of laid out in my testimony, the disaggregation of customers from an aggregate load poses risks to both existing customers and that customer you pull out, fundamentally because the transmission service functional model that SPP uses is sold on an aggregate basis. So as a pool of resources, it's sold to all load. And then when we go to the integrated marketplace, it is dispatched on an aggregate basis as well. So every customer has, in essence, paid for that transmission service through their applicable cost share. And then they get the benefit of it by having each of those resources dispatched to them. So fundamentally, if you separate those out, then you have to slice and dice which resource goes with which customer when in actuality, all customers have paid for that service and that protection, if that makes sense. And that's specific to my congestion hedging comments in my testimony.
Thank you. The second one is actually something brought up by OPC, which is requiring a mandatory emergency curtailment feature to which I think Evergy's response is we already have that for critical infrastructure, hospitals, et cetera.
Yes, yeah, that's true, Chair Han. And as you know, default is that all customers are the same, subject to further delineation in terms of responding to emergency events. If a large customer had a desire and the company had a desire for them to be a demand response resource to support the grid, then that's something that we would work out on an individual bilateral basis.
Okay, do you foresee an opportunity in the future where potentially a large load would sign up for service that could be curtailed?
I do. That is one of the concepts that's proposed by the Southwest Power Pool that's been explored and currently being explored. That's the CHILL product, conditional high impact large load. So, and that from that standpoint, those loads in concept would have offered themselves up to be curtailed during certain operating events on the system.
To your knowledge, is SPP also working on demand response frameworks that would require you to curtail certain loads in the event that SPP had a resource adequacy concern or they hit conservative operations?
Yes, yeah, that's certainly the instance that I described with CHILL, conservative operations or an emergency energy alert. Those would be the ones that would be hit first.
Okay, thank you.
Any more commission questions? Okay, hearing none. We'll go to recross of commission questions. Ameren, Missouri.
This is Jim Lowry, no questions.
Liberty. Oh, they're not here. Google.
No questions, thank you.
The Data Center Coalition.
No questions, Your Honor. Thank you.
Velvet Tech Services. Sierra Club.
No questions, thank you.
Renew Missouri. No questions, thank you. Staff of the Missouri Public Service Commission.
No questions, Judge. Thank you.
Office of the Public Counsel.
No questions, thank you.
We'll move to redirect.
Yes, Your Honor, just a few. Mr. Brown, you were talking about commercial pricing nodes with the chair. What is the latest on the commercial pricing notes and chills? Is there latest update?
Yes, so the chills product I mentioned, just background, the committee structure at the Southwest Power Pool has a primary working group who has charge over the product. So the market working group considered the chills product last week for vote. It did have a aspect of separate pricing nodes for those chills customers. At the meeting, that particular proposal for chills was rejected. So that's the bit of information that I wanted to share there.
And Your Honor, I've got the SPP vote minutes here. Well, not the minutes, but the vote that he's talking about on the revision request for chills. I'd like to offer it as Exhibit 107.
And is this on your exhibit list? Okay.
Yes.
I'm going to ask if there's any objections to taking administrative notice of the summary of motions and action items for Southwest Power Pool.
I'm sorry, are we taking administrative notice or treating it as an exhibit?
Well, we're marking it as an exhibit. And for the purposes of taking administrative notice, do you have any objection to it being admitted? Hearing no objections, it will be marked Exhibit 107 and admitted.
Mr. Brown, can you explain what RR 720 is, the chills vote?
Yes, so SPP revision request 720, that's what agenda item 7 refers to. That is the packet of a revision request to add the chills product to the SPP tariff and operating protocols. So this agenda item was what was on the market working group agenda for potential approval and what they ultimately took action on and rejected.
Thank you. No further questions.
Are there any objections to this witness being finally excused? Hearing none, Mr. Brown, you're excused.
Thank you, Your Honor.
The next witness I have is Bradley D. Lutz.
Your Honor, do you mind if I take a 5-minute break? This is the court reporter.
We'll go ahead and take a 10-minute break.
Okay, I appreciate that.
Yeah, give him a time. Say we'll be back on the record.
10, we're going to go back on the record. Hi, Mr. Lutz.
Hello?
Can you raise your right hand?
Yes,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. You may begin.
Thank you, Judge. Please state your name for the record.
My name is Brad Lutz, Bradlutz.
Are you the same Brad Lutz that caused to be filed in this case? Two pieces of testimony, direct, which have been marked as Exhibit 101, and Sir Rebuttal, which has been marked as 105.
Yes, I did.
Do you have any changes or corrections that need to be made to either of those pieces of testimony?
I do not.
Mr. Lutz, if I ask you the questions that are contained in those written testimonies, would your answers be the same, and are they true and accurate to the best of your knowledge and belief?
They would, yes.
Judge, at this time, I would move for the admission of Exhibit 101 and 105 and tender the witness for cross.
Let's take the exhibits one at a time. Can you identify them?
Yes, direct is 101. And that's
Which is?
direct testimony of Bradley D. Lutz.
Okay. Are there any objections to the admission of the testimony of Mr. Lutz? Hearing none, it will be admitted.
And then, does that cover the Sir Rebuttal too? That's 105. It's the identified as a Sir Rebuttal testimony of Bradley D. Lutz.
Are there any objections to the admission of Exhibit 105, the Sir Rebuttal testimony of Bradley Lutz? Hearing none, it will be admitted.
I tender the witness for cross.
This is the court reporter. Can I get a reminder of?
I'm James Fisher. I'm sorry, Fischer.
Thank you so much, Mr. Fisher.
I apologize.
Cross-examination, staff, do you have any questions?
Alexandra Klaus on behalf of staff. No questions. Thank you, Judge.
The Office of Public Counsel,
No questions, thank you.
are there questions by the commissioners?
Yes.
Chair Hahn?
Mr. Lutz, earlier I had asked Mr. Gunn about the Green Solution Connections Program,
Yes.
or generally about the riders and the proposed stipulation. Through that program or that rider, would any new additional generation be completely paid for by the subscribers of that program?
No. All of the renewable programs that we offered, the Renew, the Alternate Energy Credit, and the Green Solutions are REC programs. So they're only dealing with the attributes, the green attributes of those programs, not the resources themselves. So to differentiate the Green Solutions from Renew, for example, Renew uses historical and maybe even market-based RECs to fulfill those subscriptions. Under Green Solutions, those are associated with a specific resource that the company is building. Some customers are very particular about location and issues called additionality, to know that those are new RECs being built as opposed to legacy historic RECs. So the Green Solution program offers a different category of renewable attributes than the others.
Okay, and as far as, are there any differences between these program offerings and those offered in the Kansas stipulation and agreement?
For the renewable programs, no. Yes,
Okay, so
they're
they
the
would
same.
be the same across the footprint?
Yes, they would be, yes.
Okay. In the settlement negotiations and getting to, was Evergy able to understand staff's position or modification of any of these programs to meet staff's requirements? Or when I read through staff's recommendations for these programs, they didn't recommend any of them, some of them with modification. I understand now that if they were modified, they would be different than what was offered in Kansas, but in trying to meet staff's request, were you able to find any middle ground on any of these programs?
I believe that my formal testimony is no, and I think that I hesitate because I hate to close the door entirely on those particular programs, given that they're largely extensions of the large load power service plan. They're things that the customers spoke strongly about wanting to be part of our designs. So we feel that they're critical, but I would also have to believe there could be some room for some accommodation. But for the points that were highlighted in staff's testimony, we felt that our position was the correct way to go.
Okay, thank you. I don't have any more questions.
Are there any more questions? Okay, hearing none. We'll go to recross after commission questions. Ameren, Missouri.
Jim Lowry, no questions, Judge, thank you.
Google.
No questions, thank you.
Data Center Coalition.
No questions. Thank you, Your Honor.
Nucor Steel. Velvet Tech Services. Sierra Club.
No questions, thank you.
Renew Missouri. No questions, thank you. Staff of the Missouri Public Service Commission.
Briefly, thank you, Judge. Good afternoon.
Good afternoon.
The chair had asked you about certain Green Solution Connection Program riders proposed in the stipulation. Do you recall that?
I do.
Can you tell me, is Evergy actively building a resource for use in the Green Solution Connection Program for EMM?
I do not believe that those are on the chart yet. I think everything's been from Missouri West through the CCN process.
So is that saying that any resource that is being built for the Green Solution Connection Program wouldn't show in capacity filed in this case?
Clarify.
You were trying to tell me that something wasn't being shown in this case having to do with the resource being built with the Green Solution for EMM?
No, I'm just saying that our integrated resource planning had not identified resources to be built for Missouri Metro. So those aren't yet available to be available in the Green Solutions program. There has to be a resource first in order for the attributes to be available.
I think I got it now. Thanks for hanging with me there.
Yeah.
And one more quick one. There was a stipulation, an agreement for EMW with respect to the Green Solution Connection rider or program in that case.
Correct, and this would be a mirror image of that.
No further questions. Thank you.
You bet.
Thank you for your time today.
Recross the Office of Public Counsel.
No questions, thank you.
Redirect Evergy.
Thank you, Judge. In your conversations with the chair, I think you said that the customer spoke strongly about the riders. Do you recall that exchange?
I do.
What did you mean by that?
Yes, going back to the beginning when large load was first considered, we were at the time had been working with both Velvet and Google coming out of the MKT filings that we did, I think, around 2019. And as we built on those relationships, that's when they brought forward many of these thoughts or concerns around best features of programs, and having some kind of renewable option was part and parcel to what they thought was a good portfolio of solutions that we might consider.
Did you have similar discussions about all of the riders with your large customer group?
Yes, the interactions with the large customers that we currently interact with were instrumental in shaping our large load rate plan.
And did you come away with an opinion about whether those are important or not to the customers?
Yes, and that's why we brought them forward, believing them to be important to those customers.
In your discussions with staff counsel, you said something was just a mirror image.
Yes.
Would you explain which company has the approval and which one you're asking for approval for in this case?
Yeah, correct. The Green Solutions program itself was brought forward initially under a CCN filing in the Missouri West cases and was part of a stipulated settlement there. So this program that we brought forward here is just identical to the one that was already in the Missouri West filing.
And it was approved by the commission, is that correct?
I believe so, yes.
Okay, that's all I have, Judge. Thank you.
Does anyone have an objection to this witness being excused? Thank you, Mr. Lutz.
You're welcome.
All right, I have next staff, Jim Bush.
Yes, Judge, and this is Travis Pringle speaking. We have to do a little musical chairs for attorneys right now, but we'll be getting ready in a minute.
Mr. Bush, can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. Mr. Pringle, Ms. Hanson, you may begin when you are ready.
All right, this is Andrea Hansen for Commission staff. Mr. Bush, please state and spell your name for the record.
My name is James Bush. Bush is spelled B-U-S-C-H.
By whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission, and I'm currently the Director of the Industry Analysis Division.
Did you prepare rebuttal testimony in this case, which has been previously marked as Exhibit 200?
Yes.
At this time, do you have any corrections to make to Exhibit 200?
Yes, I have one typo that was on page 8, line 6, and a quote from Mr. Gunn's testimony at the very end of line 6. It says utilities across the county. I believe it was utilities across the country. So.
Thank you very much. If I asked you the same questions today within Exhibit 200, would your answers be the same or substantially similar?
They would.
Are those answers true and correct to the best of your knowledge and belief?
They are.
All right. Thank you. At this time, I offer Exhibit 200, the public version, into the record. It is the rebuttal testimony of Mr. James Bush.
Thank you. Are there any objections to the admission of the rebuttal testimony of James Bush? Hearing none, it will be admitted.
All right, Mr. Bush, and before I turn you over for cross-examination, I do have 2 questions for you. And this is from Mr. Gunn's testimony in support of the stipulation agreement. All right, so first question for you. On page 2, lines 10 through 13, Mr. Gunn states, notably, the stipulation and agreement is supported by a diverse range of stakeholders who collectively bring forward multiple viewpoints and perspectives, all of which are reflected in the negotiated stipulation and agreement. Do you agree with that statement?
Judge, I think I should interpose an objection. I may have misunderstood the court's or the commission's ruling earlier, but I understood staff has filed written testimony in support of the, or in opposition to the testimony that we filed in support of the stipulation and agreement. And I believe it's inappropriate to have live additional support of that at this time. And that seems to be where this question is going.
Overruled.
No, I do not quite agree with that statement.
Thank you very much. All right, I'm going to refer you to page 6, lines 4 through 8 of that same testimony. It states, we initiated settlement discussions in earnest after rebuttal testimony was filed and engaged through the course of multiple settlement discussions. All parties had an opportunity to participate in settlement discussions either directly with the company or with the broad group of interveners at various points. Was staff invited to these settlement discussions?
As Mr. Gunn pointed out earlier this afternoon, he reached out to me on September 19th about the settlement that was going to potentially occur on the 23rd, on Tuesday. But it was my understanding that there were previous settlement negotiations with all the other parties, excluding staff, that we were not invited to, that I found out from another party. So I take a little umbrage with that statement because I don't believe that staff was invited to all the settlement negotiations. And I think that's where the basic framework for the stipulation based upon the Kansas stipulation was discussed in those conversations that staff was not invited for, to my recollection.
Thank you very much, Mr. Bush. I now turn over Mr. Bush for cross-examination.
The Office of Public Counsel,
No questions. Thank you, Your Honor.
are there commission questions? Chair Hahn?
Good afternoon.
Judge, shouldn't there be cross-examination from the parties first?
Yeah, that'd be. I don't know. What do you guys think?
Do I get a vote?
You're the only guy without a vote. Nucor Steel? It is on. Oh, that's right. Velvet Tech Services? No questions, Your Honor. Data Center Coalition?
No questions, Your Honor.
Google?
No questions.
Sierra Club?
No questions, thank you.
Renew Missouri? No questions, thank you. Ameren Missouri?
Yes, Your Honor. This is Jim Lowry, by the way. Good afternoon, Mr. Bush. How are you?
I'm doing well, sir. How are you doing?
I'm doing fine. Focusing on staff's, let me just get some definitional things out of the way. When I say staff's proposed tariff or staff's proposal, I'm going to be referring to essentially the tariff structure, and there's actually an entire tariff filed with staff's rebuttal report back in late July. You know what I'm talking about there, right?
Yes.
And I guess that proposal has been somewhat modified by Ms. Lange's rebuttal testimony. So if I refer to staff's proposal, I guess you can assume, unless I specify, that I'm talking about it as it's been modified by Ms. Lange's rebuttal testimony. Is that fair?
I understand. I also understand that I was at a 30,000 foot view, so if you get into the weeds and the details, I will have to defer to my other staff experts.
Well, we'll see what you know or what you don't know. How about that?
Sounds good.
Did staff seek input on staff's proposal, on staff's proposed tariff? Did staff seek input on that proposal with prospective large load customers like Meta or Google who are already building data centers in the KC area before it was proposed in Evergy's case in July?
I am not aware that staff made any contacts with any large data center customer.
So the answer to my question is no.
I would believe it's no, to my knowledge.
And it obviously didn't seek, based on that answer, didn't seek any input from the Data Center Coalition, Amazon, any other large load customer, to your knowledge, right?
To my knowledge, no.
Did staff seek input on the basic staff large load customer proposal that's reflected in this case and Ameren Missouri's case, and that it attempted to inject into Liberty's pending rate case with any of those three utilities before it proposed it in Evergy's case?
I believe that Evergy, as was noted earlier today, provided an outline of what their proposal is going to be. I know that staff provided red line versions and comments back to that, as was discussed earlier today. So I think that there was some discussion with, Evergy at some point, but I think that would probably be the limit of those discussions.
Well, just to clarify, staff may have provided some comments on Evergy's proposal that Evergy vetted with staff somewhat, I don't know to what extent, before Evergy filed its case. But staff didn't come to Evergy and say, here's a proposed tariff, can you give me your input on it, did it?
I don't believe it did.
So staff's proposal was not informed by input from any prospective large load customers, nor was it informed by input from any Missouri electric utilities. Isn't that fair?
Well, I think that staff's proposal was informed by the years of experience that staff experts have had with utilities working with other large customers, i.e. like the MKT, the SIL tariff. So it's not like we did this in a vacuum. Staff has experts who have years of experience in developing tariffs and working through tariffs, and I think those were instrumental in the development of the tariff that you see before the commission today.
That's all well and good, but can you answer my question? Staff's proposed tariff filed in the Evergy case in late July, those terms and conditions, that structure, those rates was not informed by any actual input from any large load customer. You didn't go to the customers and say, here's what we're going to propose, or we're thinking about it, would you give me some input? And you didn't go to the utilities and say, here's what we're thinking about proposing, can you give me some inputs? That didn't happen, did it?
Other than the back and forth with Evergy earlier, I think that's a fair assessment.
Other than among the staff itself, from whom, if anyone, did staff receive input on the basic structure of the staff tariff proposal before staff proposed it?
You might want to also talk with Ms. Lange, as she was instrumental in developing that tariff. If she had any other contacts, I did not.
You're not aware of any, though, are you?
I'm not aware of any.
Did you have any conversations with Ms. Lange that suggested that should happen?
Quite honestly, Ms. Lange took the ball and ran with this, so if she had those conversations, I would have welcomed them. I did not direct her one way or the other.
I mean, you're her supervisor, correct?
I am her supervisor.
You agree that staff's basic tariff proposal and structure is very similar for all three Missouri utilities, do you not?
I do, because I think it's fair to have the rules in place that are similar for all the utilities, so that it doesn't appear that one portion of the state is being given undue preference than another part of the state.
Answer my question was yes, though, correct?
The answer was yes.
Did staff model its tariff after other adopted or proposed large load customer tariffs in other states that have been proposed or adopted for utilities in, say, the last 2 years?
I do not know.
You didn't discuss that among your staff?
I don't remember having discussions like that with my staff.
You don't think that's an important consideration at all?
I did not say that.
Objection to relevance.
Who made the objection?
That was Travis Pringle on behalf of staff.
Well, I think, Judge, that, as I indicated in my opening statement, these loads bring a number of benefits, including economic development to the state, and we would also suggest bring other benefits to the electric system. And if the tariffs aren't competitive with other states and don't even consider what happened in those other states, that seems to be a relevant consideration to what the tariff design should be.
I'm going to overrule the objection and allow him to answer the question.
Do you remember the question, Mr. Bush?
I do not.
Did staff model its tariff after other adopted or proposed large load tariffs in other states that have been proposed or adopted for other utilities in the last 2 years?
I cannot speak to every other tariff that is out in the United States, and I would defer that to Ms. Lange.
Well, I'm asking you, do you know whether staff did that?
I do not know.
And I think another question I asked was, might that be an important consideration to understand how staff's tariff proposal lines up with tariff proposals in other states and adopted tariffs in other states, if one of the goals of the tariff is to actually be able to compete for these loads?
Not necessarily. I mean, there could be factors that are involved that we've developed or that concerns that we've had that are necessary that other jurisdictions have not put in place. So I don't know that it's necessary to be in lockstep with all the other states.
Well, let me ask it this way. If staff has come up with the considerations or ideas or terms and conditions that from the perspective of large load customers who have choices as to where they locate are unacceptable or problematic, then isn't it fair to say that staff's proposal under those circumstances is not going to be very conducive to actually attracting those large load investments to Missouri?
Objection calls for speculation.
Sustained.
I'm going to ask you if you remember something Mr. Wills said, and if you don't, I can get you a copy of his testimony. But do you remember that Mr. Wills indicated in his testimony that he and his Ameren colleagues have spent a considerable amount of time interacting with potential customers, learning what's important to them, and choosing a jurisdiction where they might seek to establish service and making investments? Do you remember him saying that?
I don't. Do you have a copy of that?
I'll tell you what, it's going to be in the record, so just assume that he did say that, okay?
Could you repeat that again, please?
Assume that Mr. Will's rebuttal testimony says, and I'm paraphrasing, but the message is that he and his colleagues have spent considerable time interacting with potential customers, learning what was important to them and choosing a jurisdiction in which they would seek to establish service and making investments in that jurisdiction. Assume he said that in his rebuttal testimony.
Okay.
And you don't have any reason to doubt if he did say it, that that's the truth, do you?
If it's in his testimony, it's in his testimony.
Did staff spend considerable time doing the same thing as it developed and proposed its large load customer tariff proposal?
I do not believe that staff has the time or the staff to be able to negotiate and work with all those other entities.
So staff didn't spend any time on such an effort because it didn't have the time, is that right?
Like I said, Ms. Lange, refer to her, but from my perspective, I'm not aware.
Well, as the head of the division that developed the tariff proposal, you don't think that staff had the time or wherewithal to do such a thing, right?
I think that I'd be shocked to find out if they were able to.
Do you have a copy of your testimony, I assume, with you, Mr. Bush?
I do.
Can you turn to page 6?
Okay.
Let me get a copy of it as well. I'm going to direct your attention to line 19 and then carrying over to page 7, line 1.
Okay.
Could you just read that to yourself? Just to refresh your recollection as to what you said?
Okay.
And do you agree that if utilities did not have an incentive to invest in their systems generally and in generation specifically, that the odds are increased that the utility system will be less robust, reliable, and resilient than it should be?
I believe that utilities need to invest in their systems to ensure that they are able to provide safe and adequate service to their consumers.
But that wasn't my question. Do you believe if they didn't have an incentive, if the regulatory construct didn't give utilities an incentive to invest in infrastructure generally and generation specifically, so that incentive didn't exist, don't you think that the odds would be increased that the system would be less robust, reliable, and resilient than it should be?
I guess I'm trying to understand what you mean by the incentive, because all businesses they're able to earn return on their investment. So I think that's inherent in any business, in any industry.
Well, Mr. Bush, you said in your testimony that utilities have an incentive to overstate the needs on their system, and then basically you went on to say, look, the way they make money is they invest in infrastructure, they increase their rate base, and that's how they make money. So that's the incentive they have, right?
Well, that is, the incentive is that the more that they build, the higher the rate of return. That would be yes.
And if they didn't get a rate of return, they didn't have that incentive if they built. So if they built but they don't get a return, they don't gain anything from building, right? Do you follow my hypothetical?
Yeah.
Let's imagine that incentive does not exist, and so they don't They can spend $500 million, but they don't get any return.
Yeah.
Do you think they're going to be as likely to build generation that might otherwise be needed?
Yeah, I mean, they're going to invest in their systems in order to earn a return on that investment. So that's, yes, I agree with that.
Yeah, you agree if they don't have the incentive, they may not invest in their system as much, right?
Objection, asked and answered at this point, Judge.
I don't think it was.
Sustained.
Isn't it true that neither Evergy nor Ameren can build new generation that they would need to meet their load if new large load customers do come onto the system unless the commission gives them a CCN saying, yes, you can build that generation?
It's my understanding that they would need a CCN, any investor-owned utility in Missouri would need a CCN from the commission in order to build.
So they can't just decide to overbuild their system on their own. They've got to come to the commission and convince the commission that the generation should be built. Isn't that right?
That is correct, but the utility, if has the ability and maybe the incentive to explain to the commission that we have all these gigawatts that are coming on to our system that may or may not actually come to fruition, as was discussed today. So, they can tell the commission, and if we don't have the abilities to fully get into what is actually potentially going to actually be here, the utilities do have an incentive to let the commission know that we have a lot of customers that are coming on and we need to build, and those customers that might be coming on may not exist. So the utility then would be able to extract all those costs from the existing ratepayers. So
Well, I suppose staff's going to tell the commission that in the CCN case, right?
if staff has the ability to get the information to make that argument, we certainly will try. But, I've watched my staff work through a lot of CCN cases lately, and it's, there's a lot of information that is provided and a lot of information that I think that staff still requires that is difficult to obtain. And in fact, we talked about Senate Bill 4. We're going to have all new system in place in the next few years that's going to impact how CCNs are going to be decided in the state.
Because the General Assembly decided the rules should be changed, right? That's
Yeah.
not your decision, is it? That was the General Assembly's
That was the
decision.
General Assembly, yes.
Do you have a copy of the staff rebuttal report?
I do not.
May I approach, Your Honor?
Yes, you may.
Thank you.
Would you please confirm that that appears to be a copy of the staff rebuttal report?
It does.
Turn to page 8 if you would.
8?
Yes.
I'm there.
Would you agree that staff raises the issue of inducing demand-side management savings on the one hand and adding generation on the other hand, and suggests, because it's in the contradictory policy section, suggests that that's a contradictory policy?
I completely lost what you're asking me.
Okay, fair enough. Let me slow down a little bit.
Thank you.
Point you to the exact area. See lines 5 to 11
Yes.
on page 8? And if you turn back on page 7, you see that the section that text on lines 5 to 11 on page 8 is in a section staff titles contradictory policy.
That is correct.
And what staff says is, they said, furthermore, since 2015, EMW has collected more than $232 million, and EMM has collected more than $235 million. I'm going to skip a few words, through the DSIM, through demand-side management, right?
That's what it says.
And goes on to talk about that the DSIM is premised on the concept of avoiding capacity cost. And then the last sentence in that passage, lines 9 to 11, says, now, Evergy is actively seeking large load customers that will require massive amounts of new generation facilities, which will be recovered through the rates of all captive ratepayers, effectively erasing the proposed benefit of avoiding generation facility costs. You see that?
I do.
And the point that staff is making, I'm not saying that I agree with it, but it's the point staff's making, or you can confirm that's the point that staff is making, is on the one hand, Evergy has spent money to induce customers to use less load and would need less generation. On the other hand, if you bring these large load customers on, you're growing load and maybe inducing the need for more generation. And staff contends that's contradictory, right?
I mean, as you notice, Mr. Lubert, he was a staff sponsor of this, so I would request that you ask him that question, but that's what it appears that we're saying.
Well, you sponsored the overall staff report. In fact, that's the purpose of your testimony, is it not?
Yes.
You read this report, I assume, you can tell me if I'm wrong, I assume you read this entire report before it was filed, did you not?
I read this entire report before it was filed, that is correct.
And if you disagreed with something in this report, it wouldn't have been filed that way, would it?
That is correct, and that's what I said. I agreed with it, but I asked you to, Mr. Lubert could go into more detail on that.
Well, you either know or you don't. I think you just said you did. The point staff's making is that those two things are in contradiction to each other, right?
Yes.
Objection asked and answered.
Sustained.
So let's talk about adding capacity while reducing load at the same time. And I'm going to use an example, hypothetical, and ask you some questions about it. Assume my wife and I own a 2,500 square foot all-electric house and that we want to add a 750 square foot family room. Would you agree that if that's all we do, we don't touch any of the other systems in the house other than to extend electricity, plumbing, HVAC to that addition? Would you agree that our heating and cooling bills are likely to go up because now we need to heat and cool 3,250 square feet and not 2,500 square feet?
In your hypothetical, you're simply adding on a 750 square foot room to your existing home. I think that would make sense that your electric costs would go up.
Okay, let's add some more assumed facts. Assume that we recognize that reality, that our utility bills are going to go up when we add this 750 square feet. So we decide to replace our HVAC unit at the same time, and we decide to replace it with units that are expected to require 50% less electricity to heat and cool.
Objection, relevance.
Judge, may I respond, Judge?
May I ask who's making these objections?
Andrea Hansen with Commission staff.
Okay, I just can't see. Sorry.
Overruled.
So let's add some more assumed facts. We realize when we add this 750 square feet that our bills are going to go up. So we say, you know, maybe in the long run what we ought to do is replace our HVAC unit with a much more efficient one. We'll spend some money to do that. And those new units we're going to replace it with are expected to require 50% less electricity to heat and cool that what is now a 3,250 square foot house. Are you with me?
I think so.
Would you agree that although the house is about 30% bigger, we're going to consume less electricity with the new HVAC system to heat and cool it than we would have had we left the old system?
Based upon the assumption that you've given me, I don't know.
Well, if it's going to cost 50% less, and I increase the size of the house by 30%, doesn't it have to be the case?
Depends on what you put in that room. There could be, you could put a massive theater system that would require a lot more electricity than which was in your previous house. So there are a lot of other assumptions that I think we'd have to make.
Well, let's assume that, in fact, the new units will allow us to save money as compared to what it would have cost had we not replaced the system, okay?
Okay.
So what happened here is we added capacity, we added square footage to our house. It can hold more people and more belongings than it could before. And at the same time, we spent money to reduce energy consumption from our HVAC system, right?
You might have reduced it from the existing, yes.
And us doing those two things at the same time are not in contradiction to each other, are they?
I don't know if it's, I don't know that that's what we said in our report, but I don't know that they're necessarily contradictory. I don't know, there's a lot, like I said, there's a lot of things that could be put in that room that could cause your overall electric usage to go up.
Well, my hypothetical indicated that that isn't going to happen, that in fact, my electricity usage is going to be 50% less. So in that case, I spent money to replace the HVAC unit, so I spent money to reduce my consumption, but I also spent money at the same time to make my house bigger, right? And those two things were not contradictory of each other, were they?
I guess I can agree that in that hypothetical, they're not contradictory.
So let's talk about this at a utility system level. Isn't it true that a utility can spend money that will cause some customers to use energy more efficiently, like my wife and I did in the hypothetical on the new HVAC system, and the utility can also add generation needed to serve its load with additional load coming from large load customers and incur costs to expand that capacity, and that there's nothing inherently contradictory about doing both at the same time?
Well, on a system-wide basis, I think that, through the DSIM, that was monies that were spent by every single ratepayer that have already been spent to help lower the energy usage. So that's, I think $200 million that have already been spent by the consumers, whether or not they wanted to participate or not. And now you see billions upon billions of dollars being spent more. So I do see that that's a slightly difference than you as a homeowner making a decision for yourself and your family than captive ratepayers who don't necessarily have that choice that you have as an individual homeowner.
Can you turn to page 36 of the staff rebuttal report?
36?
Yes, please. Take a look at lines 5 to 6. You see with the sentence that starts data center loads?
Give me a second.
It says data center loads can be quite weather sensitive in climates such as Missouri, in that cooling can be a major end use due to the waste heat produced by computing equipment. Do you see that?
Yes, I see that.
Would you agree that if the load forecasting models that Evergy uses today, when it doesn't have, at least it has maybe some data center load on its system, but it doesn't have the kind of data center load that it's showing for its projections in the near term? If those load forecasting models that they use today are able to forecast the impact of weather on Evergy's load the next day with a good level of accuracy, shouldn't those same models be able to do a good job of forecasting the next day's load after material data center load is added?
I don't know.
Well, why wouldn't they be able to? If the models, we live in Missouri and we have hot summers and very humid summers, and we have weather forecast, and of course SPP's forecasting the load, several days ahead in those hot spells, for example. If those models are doing a good job today of forecasting what happens to all that air conditioning load that all the residences and businesses have, why would there be a problem with forecasting the same phenomenon that's going to happen with data center load?
I don't believe that a data center is going to have anywhere near the same type of load or needs as a residential. So a model that is working well today may not work quite as well when you put in a new type of customer that hasn't necessarily been used before. So I don't know that I would necessarily agree that the current models will be able to take into effect what's going to change when you add the type of customers like the data centers.
Well, wasn't the reason that staff said that the loads could be weather sensitive is that cooling could be a major end use? I mean, it was cooling, right? It was focused on air conditioning, right?
I think so. I agree with that.
And so it's your testimony that the impact of weather on air conditioning for all of the rest of the load is somehow significantly different than the impact of weather on air conditioning for a data center?
I'm assuming a data center is going to run much, much hotter internally than my house will. So I think there's a slight difference between what a data center and what a residential home would be.
You've served as an economist for both OPC and staff, have you not?
I have.
You've provided testimony on rate design, is that right?
I have.
You've performed class cost of service studies?
I have.
Have you developed a retail revenue requirement that an analyst like yourself would use to perform a class cost of service study?
I'm sorry, could you repeat that, please?
Have you developed a retail revenue requirement? The things that Ms. Boland's team does. Have you done that?
I know I've worked on I know I did a cash working capital case way back in the day, but I don't think I developed the entirety of the revenue requirement model. I don't think I've ever done that.
But you do understand how a retail revenue requirement is developed, right?
Yes.
Would you agree that in Missouri, and I mentioned this before, retail revenue requirements in the case of staff, are developed by staff's auditing function, right?
Our auditing department, yes.
And they're developed based on a utilities test year or often a trued-up test year, right?
Well, let me also, there's other aspects like fuel that is also, members of my team also provide into the revenue requirement for the auditor. So I just want to make sure that it is not just our auditing department.
That's true, but you know, the production cost modeling and so on that your team does, I don't know if this is the right word, you feed that to the auditing department and they take that into account and they build a revenue requirement, right?
Yeah.
I mean, your work's an input into their work, right?
That is correct.
Okay. And retail revenue requirements that they ultimately are developed based on a utilities test year, trued-up test year, right?
Yes.
And the goal of doing that is to determine based on the test year, trued-up test year, to determine how many dollars the utilities rates need to collect annually to cover the revenue requirement under normalized conditions, right?
I would agree.
Would you agree that revenue requirements are by design intended to reflect what it costs the utility to service customers?
Yes.
And that those revenue requirements that are developed in a rate case are intended to be a proxy for what it will cost once new rates are set by the commission?
Could you repeat that, please?
Maybe it's a bad question. What we're doing with the revenue requirement is we're trying to come up with a proxy for what it will cost to provide service once new rates are set by the commission, right?
I guess I don't agree with the word proxy. I mean, I think we're just trying to come up with what we believe that the cost of service is.
But that cost of service is going to be applied in the future once new rates are set, right?
Yes.
And at least in theory, ideally, we'd like to set a cost of service that's going to be reflective of those conditions once rates are set, right?
I think that's the general goal, yes.
Do you agree that the process of class cost of service allocation is a process whereby one seeks to allocate the appropriate portion of the revenue requirement that was developed in the rate case we just talked about
Yes.
to each rate class?
Class cost of service rate design is to divide the pie, yes.
And what you're trying to do is allocate that portion of the costs that are caused by that class to that class, right?
Yes.
Would you agree that once in a rate case, once we have the revenue requirement in a rate case and we've allocated the cost to the rate classes like we just talked about, that one then engages in rate design? That's the next step?
Yes.
Would you agree that one of the key things one is trying to accomplish with rate design is to have rates for each class that are effective at yielding the total revenue requirement allocated to that class, so that when you sum all those up, the rates as a whole are designed to yield the utility's total revenue requirement?
Yes.
Given that you agree with those principles, you'd agree, would you not, that Evergy's LLPS rates, however they're set, should reasonably reflect the costs that are and will be in Evergy's revenue requirement over time, wouldn't you?
I think that the goal is to ensure that whatever class always pays their share and their costs.
Well, they should reasonably reflect what those costs actually are, right?
Yes.
They shouldn't be too low, they shouldn't be too high. Isn't that fair?
There are other aspects involved, but that's the general idea, yes.
If Evergy's rates were designed so that certain costs are collected twice via different billing determinants, or the costs are otherwise overstated, the utility could collect more than its revenue requirement, couldn't it?
I think I missed a little bit of what you said first, but I think your general premise is that there's the potential for the utility to collect more than their authorized revenue requirement.
If costs are collected twice in the analysis or they're overstated,
Yes.
that could happen, right?
Yeah.
Is it possible to recover the exact same amount of revenue from a customer when billing them with different numbers of discrete charges and billing determinants?
Repeat that again,
Let
please.
me maybe try to ask it a little bit differently. Can't you, if you need, let me say it this way, just take an example. If we need $1,000 of revenue from a customer, you can get that $1,000 with a rate design that includes 1 charge, 2 charges, 3 charges, or 20 or 25 charges, right?
I do not believe there's a limit, yes.
You don't have to have a lot of different charges and billing determinants. You can have a few, and you can still design it to collect that $1,000, isn't that right?
For simple customers, a simple rate design. For more complex customers, I understand that you would necessarily want to have a rate design that takes into account the unique circumstances of the customers.
It's not inherently necessary to have a large number of different charges to produce the revenues associated with a particular allocation of the revenue requirement, is it?
Not necessarily.
Doesn't that mean that a standard rate design like Evergy's LLPS design, its design that it's proposed, can have its rate levels adjusted to target any level of revenue that a cost allocation suggests is appropriate?
Maybe, but there could be situations where it misses something because you're trying to put too many costs or too many things in one bucket, so.
Theoretically, that could happen, but it's not necessarily the case, is it?
When the time comes to really start digging in and developing these rates, there are going to be a lot of aspects that we're going to want to consider to make sure that we develop the appropriate rate structure for these new customers that are coming to the state. We want to make sure we do it right.
Pardon me. Let's talk about your division's role in this case, and I think you talked about this a little bit. You supervise the industry analysis division, but not the staff's auditing function, right?
That is correct.
That's Ms. Boland's division as we talked about it, right?
Correct.
Did Ms. Boland or her team review, or have input on the staff rebuttal report, or your testimony, or Ms. Lange's testimony filed in this case before they were filed?
I can't speak to exactly what Ms. Boland or her team did or did not review. I know that Ms. Boland is generally, like as all division directors, are given the opportunity to review all the work that before it is submitted to the commission, but I can't speak to exactly what Ms. Boland did, or I'm sure that staff reached out to some members of the auditing team, but I cannot be for sure exactly who. It was 2 or 3 months ago when this was all done, so.
So you don't know what input they had or didn't have?
Not off the top of my head, I do not.
Nothing comes to mind that the auditing team said.
Objection asked and answered.
So nothing specific comes to mind where one of your team members said, hey, we consulted with the auditing team and they raised this issue or that issue, or we specifically asked them this question or that question. Nothing comes to mind at all that happened.
I would request you ask that question to the members of my team who participate in this report, but to my knowledge, I can't think of anything off the top of my head.
It's my assumption that you personally had input into, reviewed, and approved the staff's filing of the testimony in this case, right?
I did review the testimony in this case.
You agree that you are responsible for the positions that staff is taking in this case?
I do agree with that.
Staff's report reflects use of a multi-average of locational marginal prices, LMPs, otherwise known as market prices. You understand that, right?
Okay.
You know what an LMP is, right?
Yes.
It's basically the market price of energy, right?
Yep.
Would you agree that staff's report reflects use of a multi-year market energy price as the basis for its proposed energy charge?
You're getting into the weeds of something that I reviewed many months ago, so I would say I don't know and ask the appropriate staff witness at this time.
So you don't know what the basis of staff's proposed energy charge is?
I don't remember off the top of my head
remember.
that I can discuss here. I'd rather let our experts talk about that.
When Ms. Bolin and her team develop revenue requirements, and if you don't know, you can say you don't know, but when they develop the revenue requirement for a Missouri electric utility, does their revenue requirement model contain a line item? Do they rely upon market energy prices applied to all retail load in setting the base rates?
I don't know.
Now, it's true that the auditing team would use historical LMPs to develop prices for production cost modeling. I guess really your team is doing that, right?
I think we have a witness come up here who does production cost modeling, and he would be the appropriate witness to ask exactly how staff does that. I have not done that function.
Okay, you don't really understand what prices are used in the production cost modeling that staff does?
I know there's a lot of prices that are used, and so I would not want to opine at this time. I would rather let the appropriate witness tell the commission exactly what they do.
Would you agree that the cost for Evergy to generate a megawatt hour of electricity is not equal to the market price of energy in a given hour, except by wild coincidence?
I think that's correct. I think I can agree with that.
You have a master's and a bachelor's degree in economics, right?
I do.
Go Salukis, right?
Nope. Cougars.
Cougars. Oh, I've got the wrong
You got the
Illinois
wrong-
University. I
you got the-
insulted you. I apologize.
Yeah, no, sorry. SIUE.
You agree, do you not, that the cleared market price in every hour in an RTO market like SPP or MISO is based on the variable production cost of the most expensive unit bid into the market in that hour that's needed to cover load in that hour? Do you agree with that?
I think that's correct.
Which means that all of the other units dispatched in that hour are receiving a price that is higher than their marginal cost of production because they're not on the margin, right?
You're quickly going beyond my my expertise up on the SPP market.
Well, if the market price is set by the most expensive unit, let's say the most expensive unit has a production cost of $20, then every other unit that has a production cost of $19.99 or less is getting some margin, right?
I think I can agree with that.
I mean, as an economist, I think that has to be, right?
I think so.
So the price that those non-marginal units are getting, the margin that they're getting, except for the 5% sharing in the fuel adjustment clause, that margin is going back to customers through the fuel adjustment clause, is it not?
Off the top of my head, I don't know.
I think you agreed earlier that when we come up with a revenue requirement, usually a trued up revenue requirement, that what we're trying to do is set a revenue requirement that's going to be reflective of the costs the utility would actually incur when base rates are set. That's what we're at least trying to do, right?
Yes.
Given that Evergy has had a series of rate cases over the past several years, as has Ameren, Missouri for that matter, and staff has found rate increases of some level are needed in most of all of those cases, it apparently is the case that those revenue requirements are not sufficient to cover the cost once rates are in effect, right? Otherwise, you wouldn't need to come in and change rates again, right?
Well, I don't know a history of every case, but I do know that both Ameren and Evergy have a fuel adjustment clause, which require them to come in for a rate case within a certain amount of time, regardless of whether or not they are meeting all their cost of service. And there could be, they could have been meeting it, and then within the last year, they may not have been meeting it. So But generally speaking, if increase in rates is required, that's because they did not meet their trued up or their revenue requirement, cost of service within the test year.
The revenue requirement that was set in that last case is no longer good enough to meet their cost of service, right? Otherwise, you wouldn't need a rate increase, right?
I think that's probably correct.
And Ameren, Missouri, and Evergy have been coming in significantly more often than they have to come in under the fuel adjustment clause statute, right? Which requires they come in every 4 years, right?
Yeah, it's amazing how much more the utilities are coming in nowadays.
Would you agree that the fact that they are having to come in pretty often, more often than the fuel adjustment clause statute would require, and that they're justifying rate increases because that prior revenue requirement didn't turn out to be sufficient to reflect their cost, would you agree that they're thereby incurring negative regulatory lag until those rates can be reset again?
I think at some level, there is a little bit of regulatory lag, and there have been various mechanisms that have been passed by the General Assembly to address those that have eased the burden of regulatory lag to the utilities.
Well, despite those mechanisms, they're still justifying rate increases on a pretty frequent basis. And so those mechanisms are not eliminating that negative regulatory lag, are they?
I didn't say it eliminated, but it definitely made it less burdensome to the utility, to the detriment of the consumers.
Well, it may have been really terrible before and it isn't as bad now. Is that what you're saying?
No, I'm not saying that at all.
As an economist, would you agree that this regulatory lag, positive and negative, provides an incentive for utilities to control costs and operate efficiently?
I think that is an argument for regulatory lag.
I mean, that's the basic premise of regulatory lag in public utility rate making, isn't it?
I think so.
Do you disagree with it?
No.
Positive regulatory lag will increase earnings, so if the utility can control costs and be more efficient, its shareholders can gain, right?
The general principle, yes.
And for the same reason, negative regulatory lag provides that incentive because the higher the utility's costs are, the less efficient it is, the less it controls costs, the less shareholders can earn, right?
I think so.
Staff's proposal regarding capturing positive regulatory lag is a one-way tracker, is it not?
I think that the potential for positive regulatory lag due to the size of the customers that would be coming on board will dwarf anything that was that we've seen before. So I think that's where staff's coming from with that.
Yeah, but you didn't answer my question. My question was if it's one way, and it is, right?
I believe in this regard because the regulatory lag positive is one way.
So if there's X dollars of new revenues coming from large load customers, but there are offsetting cost increases going on in the utilities business, your tracker's only going to take into account the revenues from the large load customers and is going to ignore the cost increases elsewhere in the business, isn't it?
I don't believe that's the case, but I don't know. I didn't think it would just look at the positive side. If there's costs are going up, I think that would be considered as well.
So let me ask you a question about that then. So
can we hold on 1 second? Sorry, my
absolutely.
Okay, I appreciate that. 1 second.
Apologies, Judge. I was just trying to be polite.
Well, actually, Judge, just while we are waiting, Mr. Bush has been up there for going on an hour at this point. I would request a break sooner rather than later, depending upon how many more questions Mr. Lowry has.
I am probably 80% done.
And I'm ready to go back on whenever y'all.
We can go a little further. I'm fine.
Thank you, Judge. let me just explore your answer just a little bit. As I understand the proposal, and you may understand it differently, or maybe you don't fully understand it, but as I understand the proposal, it would take the positive regulatory lag the utility may experience from incremental large load customer revenues that weren't baked into the prior rate case. Are you with me so far?
Yes.
And defer it to a regulatory liability, right?
I believe that's correct.
And the idea then would be when you get to a rate case after that regulatory liability has been built up, the utility would have to, dollar for dollar, probably over a multi-year amortization that the commission decides upon, but would have to, dollar for dollar, reduce its revenue requirement equal to those incremental large load revenues, right?
I think that's correct, but for a better understanding of it, I would also defer to staff witness Lange on this.
But you think that's how it works, right?
I think that's how that works, but,
If at the same time, let's say we have 2 years between a rate case and we have X dollars of incremental large load revenues that weren't baked into the prior revenue requirement. Let's say that the utility is incurring negative regulatory lag despite the existence of PISA. PISA doesn't get rid of all the regulatory lag on capital investment, does it?
maybe not all of it, but it gets a lot of it.
Well, it's at 85%, but at least 15%, right?
Okay,
And well, is that right?
I think so.
And utilities are investing a lot in their systems these days, do you not? So 15% of $500 million or $1 billion is a lot of money, right?
Yes.
So let's say at the same time, during that same interval, when the large load customer incremental revenues are being tracked in staff's tracker, the utility incurs $50 million of lag despite PISA. The utility's transmission costs go up $15 or $20 million a year. Its union contracts cause its wages to go up $15 or $20 million, whatever the numbers are. Under staff's proposal, those three instances of regulatory lag, negative regulatory lag, the commission is, or the utility is experiencing, the staff's not proposing to track those, are they?
I don't remember that we are, and I would suggest that the utility could always come in for a rate case if they were suffering from that level of regulatory lag. There's nothing preventing the utility from coming in for a rate case to
Well,
help.
there's nothing preventing the staff from bringing a complaint case to lower rates if you think the utility is earning more than it should, more than a fair return, is there?
For staff to do the work to determine whether or not the utility was over earnings, and then to file a complaint, and then the whole process of a complaint to fruition is a much more complex process and is not subject to, from my understanding, the 11-month window that a rate case is. So even though staff, public counsel, and other parties could do that, the time and effort for a party to make that adjustment and make that recommendation to the commission, and the commission to agree to that and change rates is a much more complex, more difficult, and than the utility asking for rates in the normal process.
But under the staff's proposal, you could have, let's say, $50 million of incremental large load customer revenues that have to be deferred to this reg liability, and they're going to be given back in that next rate case under staff's proposal. And the utility, even if it comes in and files rate cases really quickly, could also have $50 million of other lag that's going the other way. And the utility's going to eat that negative lag between those rate cases, but they're going to give back the positive regulatory lag through that deferral in that next rate case. That's staff's proposal, isn't it?
Like I said, I would defer to Ms. Lange for a complete description of how that would work.
Don't you understand that that's staff's proposal?
There are a lot of
Argumentative?
Are you telling me you didn't understand the proposal when it was made?
Objection, argumentative.
Mr. Pringle, I don't think I caught that first objection.
Sorry, both were argumentative.
And both are sustained.
Thank you, Judge.
Mr. Bush, you're aware, are you not, that Evergy has requested in a number of cases over the last decade or so a transmission cost tracker, and that staff's opposed every one of those requests, are you not?
Is this dealing with Crossroads?
Nope.
Then I'm not aware of that.
If Evergy gets one or more large load customers to come onto its system in the next few years, what would be your expectation regarding whether such customers' load will be at its ultimate peak demand on day one of their operations versus whether that demand would likely ramp up over a number of years?
It's my understanding that these loads ramp up over a series of up to 5 years, I believe.
It's generally not the case, let's say we have a 500 megawatt facility, that's what ultimately it's going to be. It's generally not the case that on day one, when the data center or other large loads open, that it's operating at 500 megawatts, isn't that right?
That's my understanding.
Your Honor, just give me just a second, please, if you would. That's all the questions I have. Thank you, Mr. Bush.
We're going to take a 10-minute break and come back at 3:35.
Jim, you want this back?
Back on the record. Mr. Lowry, have you completed your cross-examination of Mr. Bush?
I have, Your Honor. Thank you.
Okay, thank you. Ameren? Oh, you are Ameren. I'm sorry.
How about Evergy?
How about Evergy? That sounds good.
Okay, thank you. Good afternoon, Mr. Bush.
Good afternoon, Mr. Fisher.
Thanks for coming back. The good news is I was able to cut down a lot of the cross after I listened to your conversation with Mr. Lowry. So let's go back to a higher level and hopefully we can get done fairly quickly.
Okay.
Why don't we just start at the beginning of your rebuttal testimony at line 22?
Page 1?
Yeah, page 1. There you say, I also provide a broad overview to the commission on the staff's concerns with not only the Evergy's proposed large power service tariff, but the entire concept of large load customers building facilities in Missouri. You see that?
Yes.
I think I'd like to visit with you about that entire concept of large load customers building facilities in Missouri, if that's okay.
Sure.
Would you turn to page 5 of your rebuttal testimony at lines 15 through 17?
I'm there.
At that point in your testimony, oh, by the way, the court reporter, this is Jim Fisher. I don't think I identified myself again. And if I go too fast, please stop me, okay? At line 15 there on page 5, you're asked the question, but are not the economic advantages of locating large data centers in Missouri worth the risk? And then you go on to answer the question, not in my opinion. Is that right?
That is correct.
And now, is that the staff's opinion too? You're speaking for the staff.
I think it's fair to say I'm speaking for staff there.
Okay, and this is the first case, I think, that's gone to hearing on large load tariffs in Missouri. Is that right?
I mean, I'm thinking about the MKT tariff, and I think that went to hearing, and that was large load, but to this extent.
That's fair.
I just, yeah.
Okay, but this is the first one which I would call the large load tariff that we're doing pursuant to SB 4.
I would agree with that, yes.
Okay. Now, if I understood some of the answers to Mr. Lowry, is it correct to say that staff's conceptual tariff provisions were developed by the staff personnel whose names are listed there in the staff report?
That is correct.
And if I also understood your testimony, I think you said Sarah Lange took the ball and ran with it, and you were talking about particularly the tariff provisions at that point. Is that right?
Yes.
So is she the principal author of the tariffs?
Yes.
Okay. Now, prior to filing the staff report in this case, did staff provide the Department of Economic Development with a summary or a copy of the staff's conceptual tariff provisions in this case?
No.
No? Okay.
That I'm aware of.
Would you have provided it to any of the other state agencies that you mentioned in the staff report, the Department of Natural Resources or the Division of Energy for that department or the governor's office? Any of those folks had any input in the process?
Not to my knowledge.
Okay. And did staff hire any outside consultants with economic development credentials to help develop the tariff?
We did not.
What about any outside consultants that had experience with data centers or large load tariffs for data centers?
We did not.
So essentially, staff relied on its own in-house employees, as you often do, to draft the proposed tariffs in this case, without input from other outside experts or other agencies, right?
Other than the input that we've received over the years, working on tariffs, class cost of service, rate design, et cetera.
Do you happen to know if any other states have adopted the type of regulatory approach that the Missouri staff is taking in this case for large load tariffs?
I personally do not know.
Okay. You couldn't point, I know you mentioned several tariffs, several other states, I think Ohio and a couple others in your testimony, but those are not like the ones that you're providing here, right?
I don't believe so.
Okay. Would you agree that the staff's approach could be characterized as a novel approach?
A novel approach, I think I could agree with that.
Okay. On page 2 of your rebuttal, at page 10, you state, and I'll let you get there.
Page 2, line 10?
Yeah, line 10. You say, first, Evergy, as well as other utilities across Missouri and throughout the United States, are seeing massive customers, commonly data centers, but potentially other hyperscale customers approach them to move into the into the utility service territories. Is that right?
That is correct.
And what do you mean by hyperscale there?
By that, what I'm meaning is just other large, massive customers with loads that are above, 25 megawatts of basically why we're here, right?
Yeah,
so massive load customers that we're not used to seeing.
Did you happen to have time to read Mr. Gunn's testimony where he discussed the fact that the company's working with over 20 prospective large load customers with more than 6 gigawatts of incremental demand that are interested in locating in Evergy service territory?
I'm familiar that there are a lot of companies that Evergy has been talking to, and I think 6 gigawatts was brought up as what their potential.
I think your staff counsel may have had a chart that showed just how massive the interest is out there in our territory.
I think it was actually Mr. Kleiser from
Oh,
Public Counsel
I
that had the chart.
apologize. I think you're right. I'm sorry. Yeah.
That's okay.
Does staff agree that Google, other data centers, or other large load customers have a choice about where they locate their facilities?
I think that they make the decision on where to locate their facilities based upon a myriad of factors, yes.
Well, for example, they could locate in Evergy's Missouri territory, or they could locate just across the state line and locate in Evergy's Kansas service territory, right?
I mean, I think there's going to be limits to where they can, as was discussed earlier, you have to have, there's a lot of water that's being used, so you have to have water resources. I think they have to have, a good backbone of infrastructure for other than just electricity. So they can go to various places that meet all the requirements that they have. So I don't think they can just go anywhere.
And electricity certainly will be one of the things they'll look at, right?
Yes, it is.
Okay, if we go to page 2 of your rebuttal testimony, there at line 18 you state, second, during the last legislative session, the Missouri General Assembly passed and Governor Mike Kehoe signed Senate Bill 4, which you refer to as SB 4. While SB 4 has many provisions, it has one section that states all investor-owned utilities must have tariffs in effect dealing with customers with large loads. Is that right?
That is correct.
Does that section of SB 4 indicate to you that it's the policy of the state of Missouri that this commission develop tariffs for dealing with customers with large loads?
I think it means that, in my understanding, that it's the commission's responsibility to develop tariffs that are fair and equitable to the large load customers and the entire rate base, all the rate customers within the state of Missouri, not just large load.
And the public utilities themselves are being required by SB 4 to develop and have those tariffs approved by the commission, right?
Yes.
Okay. Do you believe that the legislature would have adopted a requirement that the commission approve large load tariffs if the legislature believed that the whole concept of data center customers or other large load customers in Missouri was a bad idea?
I think when you take that into consideration with the requirements to ensure that the rest of the ratepayer, the rest of the captive customers are not subsidizing unreasonably the large data, I think that there was a concern that they want to bring in economic development through data centers, but they want to do it properly and fairly to ensure that all other customers are not unjustly burdened.
So if I understood your answer, you would agree that the legislature wasn't saying keep data centers out of Missouri?
I don't believe that's what they were saying. I don't believe that's what staff is saying.
Do you believe that the legislature would have adopted a requirement that the commission approve large load tariffs if the legislature believed that the economic risks were just too great to have data centers in Missouri?
Objection calls for speculation.
You know, there was a lot of give and take and a lot of discussion with Senate Bill 4, and so it'd be hard pressed for me to understand exactly what the legislature did or didn't want.
It's not the role of the staff here in Missouri, though, to pick winners or losers in Missouri's economy, right?
I don't believe it's the role of the staff or the role of the commission. I don't think government at all should be picking winners and losers.
Okay, that's fair. Do you still have that staff report that Mr. Lowry gave you?
No, I got rid of that.
Could I ask Mr. Lowry to give you that? Thank you.
Thank you.
And I was going to ask you to turn to page 6, line 13 and 14 of that staff report.
Page 6, lines 13 and 14.
Yeah, that's where I'm going.
I'm there.
Okay, there it says, staff does not take a position on the propriety of serving any given potential customer of a regulated utility. Is that correct?
That is correct.
And that statement would be true for a whole industry like the data center industry.
I believe so.
It's not the role of the staff to recommend conceptual tariff provisions designed to keep specific customers or industries from locating in Missouri. Wouldn't you agree?
I don't believe it's our role to create barriers to entry for any customer to come into the state.
Okay, great. Judge, I'd like to have an exhibit marked.
Thank you.
Judge, I think my number would be 107. Is that 108? I'm sorry. Mr. Bush, you testified that Governor Kehoe signed Senate Bill 4 that includes the requirement that the electric companies have a large load tariff. I'm sorry, I didn't hear.
I'm sorry, Mr. Fisher, I don't mean to interrupt you. This Exhibit 108, are you offering it for admission?
No, I'm not. I'm just going to ask him some questions about whether he agrees with a couple concepts.
Okay, thank you.
I'd like to show you a press release and ask you a couple questions about whether you agreed with some of the statements. There, Governor Kehoe has stated, with this legislation, Missouri is well positioned to attract new industry, support growth, and maintain affordable, reliable energy for our citizens. My question to you is, do you agree that the large load tariffs that will be approved in this case should be designed to make Missouri well positioned to attract new industry?
I believe staff's tariffs do that.
So you think that that's what one of the goals should be for the commission, is to make sure the tariffs are designed to attract new industry?
Yes.
Good. Do you agree that it's the state's policy to attract new industry, support growth, and maintain affordable, reliable energy for our citizens?
I think that attracting economic development of all sorts, not putting all of our eggs in one basket, to have a diverse economic development with the diverse industries in the state of Missouri is ultimately a good thing for the state and all citizens.
Well, the state has an entire department that has the principal responsibility to promote economic development within our state, right?
And we used to be a part of it, that is correct.
Yeah, yeah. Now we're now called what, Insurance and Commerce?
Commerce and, yeah, Commerce and Industry? Commerce and
Okay.
DCI.
In this case, the commission's being asked to review two different distinct versions of the conceptual tariffs to serve the large load customers. Wouldn't you agree with that?
Yes, there are two different tariff mechanisms that are in front of the commission at this stage.
The Evergy tariff was attached to Brad Lutz's testimony, and I believe the second conceptual tariff developed by the commission staff was attached to the staff report and at Appendix 2, Schedules 1 through 5. Is that what your understanding is?
I believe so. I think they've both been modified through a stipulation for Evergy, and then we've modified ours in Surrey rebuttal with Ms. Lange's testimony. Yeah.
And I wasn't sure if I caught the answer, but did you tell Mr. Lowry that staff did not begin with the Evergy tariff and make track changes and then redline it, or did you say that they did that?
I know that we provided some red lines to Evergy when they provided us information back in February. I don't know if it was a red line to the actual tariff or a red line to concepts. I mean, that's been 6-7 months ago. I cannot remember exactly.
Right, but the tariff that the staff filed and is recommending in this case is not that marked up version of Evergy's tariff, right?
That is correct.
They're considerably different, distinct, the two versions, right?
I believe so.
Well, in evaluating these two tariff approaches, would you agree that the commission should approve a tariff that appropriately balances the risks and the benefits presented by new large load customers?
I believe that the commission should take into consideration all aspects of what their duty is to make sure that the rates that are charged to all consumers are just and reasonable and not unduly discriminatory.
And promote the public interest,
Promote the
right?
public interest, absolutely.
And would you agree that part of that public interest is economic development for Missouri?
I do believe economic development can be considered part of the public interest.
Would you also agree that the tariff should establish reasonable protections and safeguards for existing customers?
I 100% agree that has to be taken into consideration.
And would you agree that the tariff should be designed to reasonably ensure that the new large load customers will pay their fair share of the system costs associated with serving their loads?
I think the new tariff should be allow for all sorts of large load customers to come in, and they should, they should have to pay for their loads.
Would you agree that the tariff should provide a competitive rate program that will help drive economic development in the state of Missouri?
I think that it should be a just and reasonable rate. And so I think there, I get a little nervous over time when you start using utility rates for broader economic goals.
But I believe you did say that's part of the public interest.
It is part of the public interest, but it's not the sole. I think affordability is a part of the public interest as well. And so if you go down a path where you're giving what theoretically could be competitive rates, which would be lower and lower rates for a particular class, that causes the rates for, say, residentials or small general service customers to go up, so the affordability becomes a problem, then I think you have to weigh those interests, and those are very distinct interests.
And you believe the commission can do that? That's what they do.
I believe that is the
throughout its
commission's role.
history, right? Do you believe that it's important that the approved tariff be supported by a diverse range of stakeholders, including the customers that will be served under the tariff provisions?
I think there's a lot more stakeholders that should be involved in that determination than just those customers and the utility, yes.
Okay, well, we'll go there in a minute, but you're suggesting there are not enough people involved in this room, is that what you're saying?
Well, I know when we get into a rate case, we're going to have other large industrial customers. I think we have some of those in the Ameren case. Other than public counsel, I don't think there's any consumer groups that are involved that are going to be impacted by how these rates are ultimately developed and how those will impact overall rates. So Yeah, there is a large amount of stakeholders who are generally in utility rate cases that are going to be impacted by the decisions that are made out of these cases.
Is it your understanding that typically the commission balances the interests of customers and shareholders of the company?
That is their task.
And the goal is to set just and reasonable rates for the customers of the regulated company and promote the public interest, right?
All customers, yes.
Now, it's your understanding that Evergy, Google, the Data Center Coalition, and several other parties that are in this room, Nucor Steel, Velvet Tech, Renew Missouri, Sierra Club, Ameren Missouri, and the Empire District Electric Company have entered into a non-unanimous stipulation and agreement which does recommend the approval of a modified version of the Evergy tariff, right?
That is my understanding.
And staff's not a signatory, clearly.
That is correct.
Evergy, I think we've all heard in the opening, has also entered into a unanimous agreement in Kansas before the Kansas Corporation Commission, which recommends that the KCC approve a similar large load tariff that would affect Evergy's large load customers in Kansas. Is that right?
That is my understanding.
Now, Mr. Gunn attached that stipulation from Kansas to his testimony. Did you happen to look at that?
I was able to glance at it. I wasn't able to read it very closely.
Okay, well, I'd like to show it to you just for a minute. And I'm going to refer to Mr. Gunn's schedule. I'm going to refer to Mr. Gunn's schedule, KD-1, and pages 34, 35, and 36. And it'll be a simple task because
It's a lot of paper for a simple task. Where are we at?
I just want you to ask or to verify that that's the signature page to the stipulation and that the commission staff at the KCC is a signatory to it.
Yes, excuse me, it appears so.
And is the Citizens Utility Rate Board, CURB, which they're called over there, the equivalent of our public council, a signatory?
Yes, they are.
And is Evergy a signatory?
Yes.
And Google is?
Yes.
And the Data Center Coalition is?
Yes.
And are there some large industrial customers represented there?
It appears so.
Would you read those or tell me who they are?
It looks like Goodyear Tire and Rubber Company, the Kansas Industrial Consumers Group, which I don't know exactly who's all included in that. Associated Purchasing Services, I'm not familiar with them. Occidental Chemical Corp. And Spirit Aero Systems, Inc. And then it looks like 4 school districts and a paper company.
Okay, and is there anybody else? Is Sierra Club on there?
Sierra Club is also on there as well,
And NDRC?
and RDC as well, yes.
Anybody else that I missed?
That appears to be everybody.
Okay, so that diverse group at least is recommending that the commission in Kansas approve the tariff that is very similar to the one in Missouri, right?
I believe so, but I also, it's my understanding, and staff has witnesses that can further discuss the differences between the regulatory structure in Kansas versus Missouri as well. So there might not be similarities necessarily between Kansas and Missouri that allow these consumers to agree to that.
You're not the witness that would talk about that though, right?
I am not the witness. I think Ms. Lange or Mr. Lubert would be happy to talk about those differences.
Is it your understanding that both the Missouri stipulation and the Kansas stipulation recommend the approval of a rate design that includes the same rate elements? Customer charge, facilities charge, those kinds of rate elements?
I haven't looked at them that closely to be able to opine on that.
Have you read the position statements in this case?
Not all of them.
Is it your understanding that Google, the Data Center Coalition, and Velvet Tech are not supporting the adoption of staff's proposed conceptual tariffs in this case?
I think that's my understanding.
And it's also your understanding, I'm sure from your cross from Mr. Lowry, that Ameren's not supporting the staff's proposed conceptual tariffs, right?
I got that feeling today, yes.
Now, customers like Google or other data centers could choose to locate in Kansas City, Missouri, or they could go to Kansas, right?
Assuming location and everything else, yes, there are other factors they could consider, but yes.
Let's assume that the KCC adopts the proposed unanimous stipulation that's pending in the Kansas load case. Would you make that assumption with me?
Okay.
And let's also assume that the Missouri Commission adopts the staff's recommendations on the tariff provisions in this case. You understand my assumptions so far?
I believe so.
Now, under those assumptions, wouldn't you expect the large load customers to locate their facilities in Kansas rather than Missouri, holding other factors constant?
I don't know necessarily. I mean, there are a lot of factors that I think that the data centers would be looking at when they decide to locate in one area versus another area. And so I believe it would be a factor that they would consider, but it may not be the deciding factor.
Well, let me ask you this. Under those assumptions and based upon the testimony they filed in this case, wouldn't you expect the large load customers to locate their new facilities in Kansas rather than Missouri?
I don't know that I would expect them to.
No? Okay. Your Honor, I think that's all the questions I have. Thank you.
Any other commission questions? Okay. Okay, recross. Do we have any recross?
There's no bench question, so there would be no recross. You move directly to redirect.
I'm so glad you're here. Redirect.
Thank you. Just a few questions for redirect. Mr. Bush, are you aware of Ameren providing staff a copy of its proposal before filing in ET 2025-0184?
I cannot remember if they did or did not.
That's fair. Did staff ask Evergy who potential customers were?
I believe we did.
Did Evergy provide that information?
They did not provide us a list of the customers.
Did staff ask intervening customers about expected energy demand requirements?
We asked a lot of questions. I cannot remember exactly if we asked that one. I would assume we did, but I don't know for sure.
Does staff's deferral recommendation remove recovery on rate base or double recovery?
I'm sorry, could you repeat that, please?
Absolutely. Does staff's deferral recommendation remove recovery on rate base or double recovery?
Yeah, I'm sorry. I'm not quite catching what you're asking me. I'm sorry.
I don't know what she's talking about.
All right, I'm going to try it one more way. Does staff's deferral recommendation mitigate the risk of double recovery?
Yes.
All right. Is the utility compensated for avoided kilowatt hours under MIA?
I believe so.
Is Evergy requesting to retain all additional revenues under LLPS?
I believe so.
Is the utility compensated for generation not built under MIA?
Yes.
Is staff's concerns with variable loads that it is unpredictable or that data centers can exacerbate peaks?
Objection. All these questions are leading.
Overruled.
Who asked the objection?
Jim Lowry.
Okay, thank you, sorry.
Could you repeat that last
Absolutely.
question, please?
Is staff's concerns with variable loads that it's unpredictable or that data centers can exacerbate peaks?
Yes.
Do utilities time rate to coincide with the addition of new plant not considered in a previous rate case?
Could you repeat that, please?
Absolutely. Do utilities time rate cases to coincide with the addition of new plant not considered in a previous rate case?
Yes.
Are you aware if units can be bid as price takers and may generate at a loss?
Are you asking can certain generation facilities be bid have a loss? Let them know. I believe that's correct.
Would you defer to Sarah J., Mike or Sean on this?
I would definitely defer to other staff experts on this.
Is staff's recommendation meant to address the risks you discussed on the stand?
Yes, it is. Staff is, we have risks that we think that are out there that the data centers can bring, and that it is, we don't want to create barriers to entry to other large customers or other industrial customers at all. So it is my opinion that staff has developed a proposal that will address those concerns.
Is it staff's position that the commission only has two options, approve the STIP or order staff's recommendation?
No, I think as it was pointed out, I think there could be bits and pieces of both that could be utilized. I think the commission has the ability and the authority to develop the appropriate tariff that they think is right. If there are aspects of the Evergy tariff, if there are aspects of the staff tariff, or if the commission wants to put its own way in, I think the creation of a working docket would also be a potential outcome of this.
Is utility regulation in Missouri the same as Kansas?
I don't think the structures are the same exactly.
Do you believe that Missouri already has more inherent factors making it a more attractive location than Kansas? For example, more diverse population, geographic variability, rural versus urban?
Yeah, I think I think I touched on that a little bit earlier. Missouri has, we have the large St. Louis on the east side of the state. We have Kansas City on the west side of the state. We are fortunate to have the Mississippi, the Missouri rivers flowing through it. I think Kansas, and I could be wrong, I've driven through there a few times to go to Colorado. There's a lot of, once you get out of the eastern part of Kansas, there's not, a lot of population. So I think that, Missouri does offer some of those other intangible benefits, or not intangible, actual benefits of population, other factors that would sway a large data center or a large industrial customer at any level to come to Missouri.
And lastly, this is the last question for you, Mr. Bush. What is the most important aspect of your testimony that you would like the commission to take away today?
I think just to be concerned, you know, the AI, the data centers, you know, it's a bubble. I mean, it was brought up today. There's a lot of money being flowed into data centers and into AI, and nobody sitting in this room today, and I don't think anybody in the world can tell you where it's going to be 5 or 10 years from now. And you know, I think back to, you know, the dot-com bubble of the late 90s and early 2000s, where everybody was pouring money into anything that had a .com on its name, and that bubble burst, and we drove the whole country into a recession at that time. The housing bubble that we experienced just, you know, in the late 2000s, in the late aughts, a lot of money into assets, that eventually burst. You know, this goes all the way back to the Dutch back in the 1600s with the tulip bubble. Nobody knows where this is going to end, and you know, there are you know, protections that are built in even to the Evergy plan, and I acknowledge that, but they're for 12, 15, 20 years. When these facilities get built, they're going to be online for 30 or 40 years. What happens after that? What happens after, you know, if those facilities are no longer needed because, one, the entity doesn't exist anymore, or two, they find a more efficient way to do this. You know, we saw that happen earlier this year with DeepSeek, right? You know, it's my guess that Google and Meta and all those are feverishly looking for a way to do this process in a more efficient way. They're spending millions of dollars on electric costs. If I'm one of them, I'm thinking I'm going to spend millions of dollars to find ways not to keep having to spend millions of dollars in electricity costs. But once Evergy or once Ameren puts that steel in the ground and it's there, who's going to pay for it? I don't want to see Ameren go bankrupt. I don't want to see Evergy go bankrupt. I don't want to see the rest of the ratepayers have to pay for it. So I think what the takeaway is, just be cautious and make sure that the commission, you make the decision that will set the state up so we're not putting all of our eggs in the one basket, so that we attract data centers when we need them, we attract other industrial customers. They're going to be industries that we don't even know are going to be able to exist in the next 10 or 15 years probably. Let's make sure that all those customers have a place to come in Missouri so we can develop an economy that is diverse and is in the public interest for everybody.
No more questions. Thank you very much, Mr. Bush.
And Judge Walker, just a quick clarification, having to go back to when Evergy witness Mr. Clint was on the stand. The DR that Chair Hahn was asking about, it was not the DR 92, it was a DR 34, which is still in the appendix attached to Mr. Bush's testimony. Appendix 2, Schedule 5. It is not the complete response to that DR due to the complete response having potential highly confidential information, but that is where the DR that Chair Hahn was asking questions about earlier, that's where it's currently at.
Staff, would you like to call your next witness?
Why, yes, just looking for our order of witnesses right now to figure out who we're calling next.
You have Sean Lang listed here.
And there we go, Judge Walker, thank you very much. Staff called Mr. Lange to the stand.
Mr. Lang, can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
May be seated.
Judge? Good afternoon, Mr. Lange.
Good afternoon.
And could you please state and spell your name for the record?
My name is Sean, S-H-A-W-N-E, Lange, L-A-N-G-E.
And Mr. Lange, by whom are you employed and in what capacity?
I am employed by the Missouri Public Service Commission staff as a senior professional engineer.
And are you the same Sean Lange who contributed to the staff recommendation rebuttal report, which has been pre-labeled as Staff Exhibit 201?
Yes.
And are the contributions that you have made to the staff recommendation rebuttal report true and correct to the best of your belief and knowledge?
Yes.
At this time, do you have any additions or corrections to make to your contributions to the staff recommendation rebuttal report, which has been pre-marked Staff Exhibit 201?
Not that I'm aware of.
Thank you, Mr. Lange. And Judge, since we have a few more witnesses who are coming up who have contributed to the report, we'll be not entering on the record at this time. So I do now tender Mr. Lange for cross-examination.
All right. Office of Public Counsel? You
Yeah,
have any questions?
no questions. Thank you, Your Honor.
Velvet Tech Services? Data Center Coalition?
No questions, Your Honor.
Google LLC?
No questions, thank you.
Sierra Club?
No questions, thank you.
Renew Missouri? Ameren Missouri?
I have a few, Your Honor. Afternoon, Mr. Lange.
Good afternoon.
You, I believe, run staff's production cost model in rate cases, right?
I am one of the engineers that does that work.
You have a lot of experience with production cost modeling in rate cases, though. Is that fair to say?
I've been here a while.
I didn't mean to date you. Am I correct that staff develops historical locational marginal price averages, generally speaking, usually looks at a multi-year average of what LMPs have been in the market, and develops prices using those market prices that it uses to run its production cost model?
Could you repeat the question, please?
Well, are some, whether it could be the test year, it could be the trued up test year, it could be a multi-year average, but staff looks at historical locational marginal prices, in Evergy's case it'd be for SPP, and comes up with market prices that are an input into its production cost modeling, right?
Yes.
And those are market prices for energy, right?
Typically day ahead, but yes.
Okay. And of course it does the same thing for fuel as well. It comes up with fuel prices and it inputs those into the production cost model, right?
Yes.
And the model dispatches the utilities generation using assumed fuel and variable operating costs and those market energy prices for energy, right?
And some other inputs, but generally yes.
And what you're trying to do is you're trying to come up with the production, what it cost those generators that are owned by that utility that are in that rate case. You're trying to figure out what those generators, what it costs for them to produce megawatt hours of energy, right?
For that normalized load based upon the fuel prices and market prices. Yes.
And you or Mr. Bush's team, the folks that are responsible for production cost modeling, you then feed those production cost modeling results, those dispatch results, to the auditors who then use them as one of the inputs into their revenue requirement development, right?
We typically provide the results to the auditing staff as well as energy resources staff.
And what's the energy resources staff role with those? What do they do with them?
I think that goes into FAC and setting the base.
Okay. Okay. Do you know how the auditing staff uses the results of your production cost model in developing the revenue requirement?
They have described what they have done, but it's been so long since I have looked at that, I can't recall.
Well, let me probe that just a little bit. You understand, do you not, that they take your production costs, you know, in Evergy's case, you get production costs for Hawthorne and Wolf Creek and Lacine and Iatan 1 and 2 and all their other units. They take those production costs that have been developed through your modeling, and those production costs become one of the inputs into the revenue requirement, right?
That is my understanding, yes.
And the production costs, you know, you're gonna have cost, you know, you're gonna have fuel and other things to run the generating plants, but you're also gonna have some revenues from off-system sales that's offsetting some of that cost, right?
There will be revenues from the dispatch of the units that could be inferred to be off-system sales.
Okay.
Yes.
Have you ever heard of the phrase true purchase power?
I believe so.
Do you know what it is? When I use that term, do you know what I mean?
Not right here, right now, no.
Let me ask you a few questions. I know you were around when this was happening. Maybe you'll remember. Do you recall that there was a debate, I think it was about a decade ago or so, about whether or not all of the transmission costs that utilities incur from the RTO associated with energy, whether all of those transmission costs should be included in the fuel adjustment clause, or whether only some subset of the transmission costs should be included in the fuel adjustment clause? Do you remember that?
I remember some of that debate, yes.
And do you recall that the commission decided that even though utilities sell all their generation into the market, all the megawatt hours they produce, and then they buy all the megawatt hours their load consumes from the market, that what the commission decided was they were going to look at the net of those, and to the extent the utility produced megawatt hours, the commission said transmission charges associated with that quantity of megawatt hours are not true purchase power, and whatever that percentage is, we're not going to allow in the FAC. Do you recall that?
Vaguely, but not a great understanding of that, no.
Would you agree that the cost to generate a megawatt hour of electricity for Evergy is not equal to the market price of energy in any given hour, except by coincidence?
Could you repeat the question, please?
Would you agree that the cost for Evergy to generate a megawatt of hour of electricity from its generators will not equal the market price of energy in that same hour, except by coincidence?
So when you say market price, are you including the losses? I guess
I'm saying the LMP. So the production cost, what it cost Evergy to generate a megawatt hour of electricity in hour 23 on, today,
Yes.
September 30th or whatever.
Yes.
That's not going to match the LMP in that same hour on that day, except by coincidence, is it?
When you say except by coincidence, if that unit was the last one dispatched, or the last one dispatched to meet the load in that hour, then in theory it should be the cost of that unit.
Well, so the marginal unit it would be for that hour, right?
Yes.
But all its other units are not going to match the market price, right?
Each unit would have a specific price, and those prices differ among the units. So
Well, let me back up. I agree with you that the marginal unit, if Evergy's unit is the marginal unit, it's going to get the market price for its generation, right? I agree with
Yes.
that, right?
Correct.
But that doesn't mean that's what it cost Evergy to produce it, does it?
Correct. Correct. The unit could be bid at a depending on the utility, depending on how the utility bids those units, there could be a difference between the bid price and the accounting price of the fuel for that unit in that hour.
When you give production costs to the auditing staff for the revenue requirement, you're not giving them a market price as the production cost for those units, are you? You're giving it a production cost based upon the various inputs, fuel, et cetera, that you used to figure out what the dispatch would be, right?
I give them the amount of fuel burn. I give them the fuel cost of that fuel burn. I give them an amount of revenues associated with that fuel burn. I give them an amount of expense of the load in that hour for or when that fuel burn happened, if you will, and zip it up to the year that we are looking at.
Okay. Thank you, Mr. Lange. No further questions, Judge.
Thank you, Mr. Lowry. Any questions from Evergy?
No, thank you, Judge.
Okay. Staff, do you have any redirect?
Yes, Judge, thank you, very brief. Good afternoon again, Mr. Lange.
Good afternoon.
So, just kind of based on some of the discussions you had with Mr. Lowry earlier, what role do fuel prices play in the cost of energy to serve load?
Fuel prices help to determine the dispatch price of the given unit that you're looking at. So in the case of, production cost modeling, you're looking at all of the units. So we are looking at, the heat rate curve for that unit, so the efficiency of that unit, as well as the cost of fuel burn. So the fuel model will come up with a dispatch price for that unit and compare that to, let's say, market prices in that hour. And then based on the difference there is whether or not that unit gets dispatched.
And then how do market prices play in that analysis?
So the way staff's production cost model is set up, all of the coal plants, all of the natural gas plants, they will look to a market price. So there may be differences among how staff models this among the different utility companies. It may be such that you have a locational marginal price that is solely that unit. You may have an aggregate price that is kind of the aggregate of all of the units that you're comparing against, but the market price is used to dispatch those units in that given hour.
And just one moment, Mr. Lange. Nothing more from staff, Judge. Thank you very much.
Thank you. Does anyone have an objection to this witness being excused? Hearing no objections, Mr. Lange, you are excused.
Thank you.
Thank you, Judge. And I think next on staff's list is Mr. Michael Stallman. Sorry, Jim, I was gonna get up there and get that for you. I was like, what's that still doing?
Do you swear to tell the whole truth and nothing but the truth, so help you God?
I do.
You may be seated.
And may I proceed, Judge?
Please.
Thank you very much. Good afternoon, Mr. Stallman.
Good afternoon.
Could you please state and spell your name for the record?
Michael L. Stallman, Michael L. Stallman.
Thank you, Mr. Stallman. And by whom are you employed and in what capacity?
The Missouri Public Service Commission as an economist.
And are you the same Michael L. Stallman who contributed to staff's recommendation rebuttal report, which has been pre-marked as staff exhibit number 201?
Yes.
And today, are your contributions to that recommendation rebuttal report true and correct to the best of your belief and knowledge?
Yes.
And do you have any additions or corrections to make to your contributions to exhibit 201 at this time?
No.
Thank you, Mr. Stallman. And again, Judge Walker, we have a few more witnesses coming up who contribute to the report, so we will not be entering it on the record at this time, but I do tender Mr. Stallman for cross-examination.
Very good. Office of Public Counsel?
No questions, thank you.
Velvet Tech Services, do you have any cross-examination? Data Center Coalition?
No questions, Your Honor. Thank you.
Google LLC?
No questions. Thank you, Judge.
Sierra Club?
No questions, thank you.
Renew Missouri? Ameren Missouri?
No questions, thanks.
Evergy?
No questions, thank you.
Okay, we'll go to commissioner questions. Hearing no commissioner questions. Any redirect?
No, Judge, nothing asked.
Okay, does anyone have an objection to excusing this witness? Hearing none, Mr. Stallman, thank you. You are excused. How's that?
Staff would next like to call Ms. Brooke Mastroyanis, and we will need to do a little bit of musical chairs as well.
Okay. Can you raise your right hand, please?
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Staff, when you're ready.
Please state and spell your name for the record.
Brooke Mastroyanis, BROOKE MASTROGIANNIS.
By whom are you employed and in what capacity?
The Missouri Public Service Commission as a utility regulatory audit supervisor.
Did you contribute to the staff recommendation in this case, which has been previously marked as Exhibit 201?
Yes.
At this time, do you have any corrections to make to your portions of Exhibit 201?
No.
If I asked you the same questions today within your portions of Exhibit 201, would your answers be the same or substantially similar?
Yes.
Are those answers true and correct to the best of your knowledge and belief?
Yes.
Thank you. At this time, I tender Ms. Mastroyanis for cross-examination.
All right. Office of Public Counsel.
We'll try and keep this brief. Miss Mastrianis, did I get even close to correct?
Yes.
Oh, thank God. You are familiar with the FAC mechanism, correct?
Correct.
All right, I just want to have a quick couple of questions to set the record on what the FAC is. So if a utility has a fuel adjustment clause, then during a general rate case, there is rates are set that establish the net base energy cost for the utility and included in base rates. Is that correct?
Yes.
And then subsequent to that, at a future period during a rate adjustment for the FAC, the actual net energy costs are calculated, and that represents the actual fuel and purchase power costs that were incurred by the utility over the period in review. Is that accurate?
Yes.
And so the FAC represents the difference between the net base energy costs set in base rates and the actual net energy costs calculated during a fuel adjustment period. Is that accurate?
Yeah, the accumulation period.
All right, thank you. Again, just to establish really quick, if a utility has an FAC and the net base energy costs are set during the FAC without the inclusion of a large load customer, and then subsequent to rates being set, a large load customer comes online, the company will incur purchase power costs to serve that large load customer, correct?
If there's no adjustment being made after the conclusion of this case, yes, I believe so.
And if they incur costs, that will increase the actual net energy cost, presumably, correct?
Correct.
And if the actual net energy cost is higher than the net base energy determined in the rate case, because of the addition of that large load customer, that difference will flow through the FAC, correct?
The way it currently is, yes.
And if it flows through the FAC, it will be recovered from all customers subject to the FAC, correct?
Correct.
All right, I have no further questions. Thank you.
Thank you. We'll go through the list. Velvet Tech Services, Data Center Coalition,
No questions, Your Honor.
Google LLC,
No questions, thank you.
Sierra Club,
No questions, thank you.
Renew Missouri, Ameren Missouri,
Just one or two, I think. Following up on Mr. Kleiser's questions, won't there also be additional revenue generated because the base factor times the SAP, because of the base factor times the because the base factor times the SAP, those additional sales, won't those additional sales from that large load customer also flow through the FAC?
The additional sales will be included in that net base energy cost calculation.
Well, and that means the large load customer is also going to pay some of that, isn't that right?
Yes.
So not all of, if there is an increase in cost, not all of the increase in cost is going to be paid for by non-LOPS customers, is it?
I don't believe I said all of them would.
I'm just asking. I didn't say whether you said it or not, but isn't that correct? Not all of the increase that Mr. Kleiser was talking about, assuming there is an increase, is going to fall on the non-LLPS customers, is it?
I believe it depends on what the commission orders in this case, but if there is no adjustment in the FAC and the LLPS customer is not on an optional agreement that staff recommends, then yes, I think they would pay part of that increase.
I mean, if the FAC stays the way it is, they're going to pay the FAC on all of their megawatt hours as well, right? They come on the system, they're going to also pay the FAC charge, right?
They will pay some of the FAC charge.
Right, and so if there's an increase, if there is an increase, they'll pay some of that increase, isn't that right?
I believe you just asked me that.
Well, I'm just confirming, just looping back, they will pay part of that increase in those costs flowing through the FAC by paying charges under the FAC, right?
Yes.
Thank you. No further questions.
Thank you.
Evergy,
No questions, thank you.
right? Commission questions? Okay, hearing none. Redirect?
No to redirect from staff.
Does anyone have an objection to this witness being excused? Hearing none, Ms. Mastrangiani, you are excused.
Staff would next like to call Mr. Jordan Hull.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Direct examination?
Thank you, Judge. Good afternoon, Mr. Hull.
Afternoon.
Could you please state and spell your name for the record, please?
Jordan Hull, Jordan, last name Hull, Hull.
By whom are you employed and in what capacity?
Missouri Public Service Commission, and I am the Associate Engineer for Energy Resources.
Are you the same Jordan Hull who contributed to the staff recommendation rebuttal report in this case, marked as Staff Exhibit 201, both public and confidential versions?
Yes.
Do you have any changes or corrections to your portion of the staff recommendation rebuttal report in this case?
I do not.
If I asked you about the topic or topics in your portion, would your answers or information be the same or substantially similar to that contained in your portion of the staff recommendation?
Yes.
That information in your portion is true and accurate to your knowledge and belief?
Yes.
Judge will offer the staff recommendation with our last witness. At this time, I tender the witness for cross-examination.
Thank you. The Office of Public Counsel, do you have cross-examination questions?
No, Your Honor, thank you.
Velvet Tech Services? Data Center Coalition?
No, Your Honor, we do not. Thank you.
Google LLC?
No questions. Thank you.
Sierra Club?
No questions, thank you.
Renew Missouri? No questions, thank you. Ameren Missouri?
No questions, thank you.
Evergy?
No questions, Your Honor, thank you.
Okay, we will go to commission questions. Hearing no commission questions, any redirect?
No, thank you, Judge.
Okay. Does anyone have an objection to this witness being excused? Mr. Hall, you may be excused. Thank you.
Thank you.
I don't have any more of these sheets. Staff, would you like to call your next witness?
Thank you, Judge. Staff calls Brad Fortson.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Direct examination by staff.
Thank you, Judge. Good afternoon, Mr. Fortson.
Good afternoon.
Could you please state and spell your name for the record, please?
Sure. Brad, B-R-A-D, Fortson, F-O-R-T-S-O-N.
By whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission as the manager of the Energy Resources Department.
Are you the same Brad Fortson who contributed to the staff recommendation rebuttal report in this case, marked as staff exhibit number 201, both public and confidential versions?
I am.
Are you the same Brad Fortson who filed SIR rebuttal testimony in this case, marked as staff exhibit number 202?
I am.
Do you have any changes or corrections to your portion of the staff recommendation or your SIR rebuttal testimony in this case?
I do not.
If I asked you about the topics in your portion and the same questions in your SIR rebuttal testimony, would your answers or information be the same or substantially similar to that contained in your portion of the staff recommendation and in your SIR rebuttal testimony?
They would.
The information in your portion and your SIR rebuttal is true and accurate to your knowledge and belief?
It is.
Judge, I'd like to offer staff exhibit number 202, which is the SIR rebuttal testimony of Brad Fortson. And again, we'll hold on the staff recommendation with our last witness.
Are there any objections to Exhibit 202, the SIR rebuttal testimony, staff testimony of Brad Fortson? Hearing none, the testimony will be Exhibit 202 and will be admitted.
Thank you, Judge. I tender this witness for cross.
Office of Public Counsel, do you have cross-examination questions?
No questions. Thank you, Your Honor.
All right, let's go through the list. Velvet Tech Services, Data Center Coalition,
No questions, Your Honor.
Google LLC,
No questions.
Sierra Club,
No questions, thank you.
Renew Missouri, Ameren Missouri,
No questions, thank you.
Evergy.
No questions, thank you.
Hearing no cross-examination questions, do we have questions by the commissioners? Hearing no questions? Any redirect?
No, thank you, Judge.
Okay. Does anyone have an objection to excusing this witness? Mr. Forson, you are excused. Sheets too. I think this is a good stopping place for the day. We'll start again tomorrow at 9. Thank you all for coming and for your patience, and I look forward to seeing you tomorrow.
Thank you, Judge.
I will not, this is the court reporter. I will not be here for the proceedings tomorrow. So just so that I have it on the record, I don't know if anyone wants to order the transcript I'm gonna produce. But if you know ahead of time right now, if you want to let me know, it would be a good time.
Yes, we absolutely want to order the transcript.
Okay. Do any other parties, are any other parties going to order as well?
And Judge, it's expedited as well in the procedural schedule.
I think our contract says 10 days.
The procedural schedule says 7 days from the hearing.
We have requested to have it expedited.
Yes, I have it for due on the 7th of October.
That's correct.
The commission anticipates filing the transcript in EFIS as with all other cases, correct?
Correct.
So yeah, I don't think that we need additional copies.
Okay. I just wanted to make sure before I got off of here. I appreciate you guys.
Judge Walker, this is Nikhil Vijayakar on behalf of DCC.